Yeah.
I just got a low worth about a half a ticket. Non-swipe Da Vinci got him looking at me different. I can't be feeling when I kiss him. Yeah, kidnap you and Mrs. Yeah, I hit him. I was in the slums. Any weather, I was still trapping, sliding on the bus. They putting cameras on the lights, playing like you stupid dog. You know what I do to you. Hit me from a cell, told me get the cake. I'm weighing up them bowls, selling coke around the digi. Playing with them bloods, they gon' pop you like a.
Those videos still gives me nightmares, dude. I don't know how someone would do that. I don't think they show it here. No, okay. Yeah, I don't think she shows the graphic part of it, but I still don't understand how someone... I mean, I don't really care about his defense. That's not really what matters. But the fact is that he couldn't take responsibility for it, that's the thing that made him irredeemable for me.
This is case number 21 CF 1848, State of Wisconsin versus Darrell Brooks.
Obviously, I don't need to state Mr. Brooks is facing 5 consecutive life sentences.
It was only 5 at that
on
point.
all counts in this complaint. I wish to notify the court sadly that today we learned of another death of a child related to this case. We do expect a 6th count for first-degree intentional homicide to be issued or added, to this case. There's a number of other charges that we are reviewing and considering, but certainly, at the very least, we do intend to file a 6th count of intentional homicide. I want this court to know, and I think the court has read the complaint, you've indicated you've read the complaint, there are not words to describe the risk that this defendant presents to our community. Not only flight risk, but the dangerousness that he presents, his history of violence, and the allegations in this complaint where it is stated plainly that on several occasions he was told to stop by police officers. They risked their own safety to try and step in front of the car to stop him. Everything was done to get him to stop. And
Yeah.
he just simply continued down the roadway, causing
He only
death
needed
and
to
destruction
brake.
in his path. So I am advocating for a significant cash bail, Your Honor. I'm asking for $5 million cash bail. I know that's a large amount of money, but I think it is warranted on this history, and I think it's warranted when the court considers, if convicted, Mr. Brooks will spend the rest of his life in prison. Thank you.
Thank you. Attorney Perry.
Thank you, Commissioner. When this court determines what amount of monetary bail is reasonable and necessary to assure Mr. Brooks's appearance in court, I guess at today's hearing, the only thing I would add for the court's consideration is that Mr. Brooks is financially indigent, does qualify for public defender representation.
Of course he
That
doesn't have money.
individual circumstance must be taken into account.
He's a leech.
Does that conclude your argument?
It does.
The gravity of the offenses, the maximum possible penalties as the statute allows for, likelihood of incarceration, which if you're found guilty of 1 or more of these, even 1, would put you in prison for the rest of your life. I believe you are a flight risk. There's failure to follow court orders.
Yep.
This allegation, although the motive is not known, I'm not entitled to know what that is, but it looks like there was either panic or whatever, or an intentional act for whatever reason. You don't do well under pressure. The Milwaukee County case talks about, as Attorney Hopper indicated, you using a vehicle to run over another person with your vehicle. So you don't respond well to what is common sense within our community, our society. I have no problem with the bail being recommended by the state. I'm an old guy who has been doing this for almost 4 years. DA's office, criminal defense attorney, 17, 18 years as a commissioner, both in Milwaukee and now in Waukesha. The nature of this offense is shocking. Actually, the detail I was not expecting here today, that two detectives, not lay people, detectives, not only tried to stop this, but rendered an opinion that this was an intentional act. You're presumed innocent, sir, but that's what the allegations are. And I've not seen anything like this in my very long career. It seems to be a very strong case for the state.
Sorry.
Likelihood of incarceration, which is the other aspect of bail, is absolute. If you are found guilty of any one of these, a multitude of them, it's a life imprisonment sentence that must be meted out. So I have no problem. I just, with that bail, it's extraordinarily high, but it's an extraordinarily big case. It's an extraordinarily serious case with an extraordinary history of this gentleman, of fleeing, of hurting people, of not following court orders, not following criminal laws, not following just your societal norms.
Yeah, just be a normal
that's
person.
extraordinarily high bail. It's warranted here, and I am setting cash bail in the amount of $5 million.
Good.
And then we'll come back and, of course, address the jury questionnaire issues. Is there anything ahead of that that the parties need me to address or before we break? Attorney Opera, anything from the state?
Just briefly, Judge, I observed that for about the past 40 minutes, Mr. Brooks appears to be asleep in the courtroom. I don't know if he's just
The
being
disrespect is always there from the beginning.
respectful, uninterested, or if he's not feeling well. But to avoid a appellate issue in the future, I think it'd be appropriate to inquire if he is capable of assisting in his own defense at this point.
All right, why don't I give the defense attorneys a moment? We'll mute the microphone so they can talk to Mr. Brooks, make sure he's feeling okay, and make an assessment of his ability to assist in his defense during these proceedings. I'll step off while we do that.
All right, and we're going to take a break, and then we'll pick this up when we return.
Why don't we do that? That's
Okay.
probably best. I will mute the audio. The live stream will keep going unless the defense wants me to stop it.
This is the beginning of. I think he didn't care when he was.
Mr. Brooks, the live stream is on.
He had the long hair.
Just like y'all don't care.
And when he took off his hair, the reins came off.
Mr. Brooks, Mr. Brooks, look at me for a minute. Mr. Brooks. Mr. Brooks, look
Sit
at
here, act like you know me. People like you don't, y'all
Mr.
you
Brooks.
don't know nothing about where I come from.
Mr. Brooks.
You push me, dog. Don't push back.
No one cares where you come from.
Don't push back. Push me again.
Mr. Brooks, we have to continue with this hearing.
Don't worry about me. Don't put your hand on me.
Nobody put their hands on you.
Yeah, they better not put their hand on me.
Okay, Mr. Brooks.
They better not. What are you gonna do about it, bro?
Why? Listen to all this political stuff y'all got going on.
Mr. Brooks, I'm more concerned about.
Don't touch me, dog. They see it.
All right, we're gonna take a break and we're gonna come back after lunch. I'm not gonna do this with him right now. He needs to be here. He's not cooperating. Give you the warning, Mr. I will give you the warning that if you continue to interrupt when we go back on the record, you will forfeit your right to be in the courtroom today. I can't have these interruptions. I want you here. It's been a long day and a half.
Keep your hands off me.
We'll come back at 12:30.
Just told you to get off me.
Yeah, I don't think he understands that Once you are in
Mr.
prison,
Brooks
you
is
forfeit your
competent
right to be like that.
to represent himself and waive his
Oh, here we
right to
go.
an attorney.
Quick
I think
objection.
it all, Mr. Brooks, you're not, don't interrupt me. It also helps explain. some
That's
of
the first, don't
interruptions.
interrupt me.
That's arrested
And-
judgment, Your Honor.
Not right now. You can ask when I'm done. It also, I believe,
I
helps
object.
Mr. Brooks, let me get through this. It's really important that I make a record and honor your request
I understand that.
to
Then shut up.
I don't understand
represent
why.
yourself.
I don't understand why.
Mr. Brooks,
um,
I'm going to explain the
something-
relevance. So
I
just
don't-
stop
I don't
talking and listen to
understand-
me.
I don't understand why.
If you don't understand, let her explain it.
Pertaining to a plea that is not standing anymore has relevancy to the decision that's being made right now, months
Stop
after.
talking and listen, because you're gonna get the answer. okay?
Okay,
Okay.
I hope so.
Frankly, statements like I'm informed or I'm aware are the functional equivalent of you saying I understand.
It is.
I
object to
cannot
that.
say that this is one of
Never
those
once
narrow
said I
class of,
understand.
Mr. Brooks,
I
stop.
object, which is my First Amendment right to be able to say what I want.
Mr. Brooks, your rights do not involve interrupting me. That's the,
I objected. I didn't
that's the
interrupt. I
procedure
interject.
that we will
Object.
follow. At trial, what's going to happen if you continue to do that is you will be admonished in front of the jury
That's
if
fine.
you continue that.
That's fine.
Mr. Brooks, we're having issues because of you.
We're having issues.
Not because of
I'm not gonna
me.
let you-
I've made my determination. I provided you with the
I'm
law.
not gonna let you intimidate me into believing
Mr.
something.
Brooks,
that
I am
know
not
true.
intimidating you.
Because you can't, and you see that.
Well, then don't.
You clearly see that you can't intimidate me.
No one's
Or I'm not.
trying.
All right, then you will participate. I'm going to start jury selection.
Or I will not. I'm not consenting to anything you say until you can answer the questions that I'm asking.
He is, by his conduct, not the choice of the court,
No, that is judicial
He is-
misconduct of anything, Your Honor. I simply merely
going to
asked
be in
for
the other
questions to be answered.
courtroom for jury selection.
Okay, this is the first thing that I have with this guy is that he doesn't consent. But he doesn't consenting doesn't mean anything. It's like, yeah, you don't consent, we get it. But at the same time, it doesn't matter. They don't have to answer questions for you. They told you specifically at the beginning, like, bro, we are not gonna explain it to you. If you don't understand it, that's on you. We don't have to do anything.
You can take him back there. He has repeatedly interrupted this court. He has refused to follow the most simplest of standards despite being given the rules of courtesy and decorum for the courts of Wisconsin. Again, Mr. Brooks, I absolutely want you present in the courtroom, but that is for you to decide at this point. Would the bailiffs please remove him to the other courtroom? This court is on day one. It is 2:15 p.m. This court, within 5 minutes of starting court this morning, had to remove Mr. Brooks based upon his interruptions at that time. I've lost track, but I think I'm at least 5 or 6. Who knows, maybe more. We have this amazing technology. The case law hasn't caught up to that technology. I believe this court can continue to go forward in this fashion with Mr. Brooks being in the courtroom next door.
Darrell Brooks, now representing himself in court, spent most of the
Why?
first day of jury selection removed from the courtroom
Why?
for his outburst and disruptions. Nevertheless, the court was able to make some progress towards the needed jury
Look
of
at-
12 with
Look at that face. Look at, just see what this guy is about. I mean, he was gone from day one. I mean, there was no defense for him. There was no misconduct of anyone. He was just gone. He was dead. So I don't know. I still don't know why he went through all this circus.
4 alternates. It was November 21st, 2021. Thousands of people were gathered in downtown Waukesha, Wisconsin for the annual Christmas parade. But an afternoon of holiday cheer turned into a tragic nightmare. Police say this man deliberately drove his SUV into the parade.
It increases its speed and it begins to do a zigzagging motion through the crowd, hitting people, running people over, and it appears that the vehicle's intentionally aiming for people.
The alleged driver, Darrell Brooks, drove through the parade route for 5 blocks, driving up to 25 miles per hour while plowing into parade goers and participants. Detective Thomas Casey was working that day and testified about what he saw at a pretrial hearing.
I first stepped in front of the SUV, put my hands up, and was yelling for the vehicle to stop.
Okay. Did the vehicle stop?
It did not. It first hits drum player and continues, and I would say it hits approximately 10 people and runs directly over the top of them, and then turns to the right and starts hitting other people in the parade route.
Dozens of people were hit. 6 people died from multiple blunt force injuries, including an 8-year-old boy, and 61 others were injured. Faith in you.
These it was
families
more
are
than
going through a
61.
really hard time. Everybody
61 was
that
the one
was
that
here
they charged
just
him with.
went through such trauma.
According to
That's
the
just
criminal
physical
complaint, the driver slowed down only to then accelerate, taking an abrupt left turn directly into a crowd. This, investigators say, showed an intentional act to strike and hurt as many people as possible. The driver didn't stop until a police officer shot at him.
One of our officers saw the vehicle coming at him and forced that officer to discharge his service weapon.
He fired at Mr. Brooks' vehicle?
Yes, he did.
Did he strike the vehicle?
3 times.
Did the vehicle stop?
Did not.
Brooks eventually drove into a nearby
Look at that
neighborhood,
face.
crashed his
Look at
car,
that face.
and then took off on foot. He stopped
I
at
think
this
I've
house where
blocked it
a
a
ring
little bit, so you
camera
can see.
captured the moment police caught up with him. Brooks was arrested and charged with dozens of criminal acts, including 6 counts of first-degree intentional homicide. Interrogation records from that night show Brooks told police that he, quote, didn't mean to kill anyone. Brooks pleaded not guilty by reason of insanity, but withdrew that plea in September.
Have you
It's not
had the
insane.
opportunity to
It's
thoroughly
definitely not
discuss
insane.
your decision to withdraw your special plea with your attorneys?
Yeah.
Have they discussed the advantages and disadvantages of withdrawing that plea with you?
Yeah. I have my own reasons why.
Just a week before trial, yet another twist in the case. Brooks decided he would represent himself, prompting his defense attorneys to withdraw. At a hearing, the judge ruled Brooks competent enough to represent himself, but his actions in court are raising questions.
I object to that.
Responses
I
to
object to that.
questions asked.
I object to that because at the end of
I
the day,
understand, you, Mr.
I
Brooks,
object.
stop. You can
I
object. Your objection is noted. I'm going on. This is one
At
of
the
the
end of the day-
expectations that I
at the end of
have,
the day-
is you can object. It will be noted, but you can't keep interrupting.
You're
Your
reading from
objection,
something-
sir, your
you're
objection
reading
is
from something
noted.
that I haven't been privileged
This
to
is a
read
prime
myself.
example of some of the difficulty with Mr. Brooks.
I don't think you have a PhD,
He
Your
can
Honor.
be,
Wow.
in my opinion, deliberately disruptive.
Does he have a
But
PhD?
nonetheless, he maintains being
Judge.
competent at the most basic level in order to
Thorough.
present a defense on his behalf.
Object to that.
Brooks' mother pleaded with the court not to allow him to represent himself.
see if she has a
She
PhD.
says she won't be at the trial and expects her son will be out of control.
And I hate to say this, you're going to see manic, full blown. That's what you're going to see.
With the Secretary of State.
I provided you yesterday as a courtesy with a copy of my oaths of office. My name is on that as well.
They were not certified.
You are
Your Honor.
attempting to disrupt with asking questions like this.
I am not
I
attempting
realize
to
it may very well be related to your
I don't think she has one.
claim to be a sovereign citizen and
Claim to be
disputing
sovereign.
the
Claim to be sovereign, that's correct. That's the
jurisdiction
right
of this
amount of
court,
record.
but these are not questions this court
No, she
is
has a
obligated to
archer?
I have
answer.
to correct the record and say that I am sovereign.
All right, you believe you're sovereign, the record is corrected.
He's a doctor
So,
of law.
Mr. Brooks, we're getting really close for you crossing the line,
Really close to crossing the
being
red line,
removed
Your
from the
Honor.
courtún for
I
continued
did not-
interruptions.
I
I
did not
want you
consent to
here,
that, Your Honor.
Mr. Brooks, you haven't let me get in one sentence this morning. It is only, it's 8:57. I want you to be here. Certainly my preference is for you to be here to participate fully, but you do not have the right to disrupt the proper administration. I demand dignity, order, and decorum. Everyone here has been respectful other than you throughout these proceedings.
I object to that respectfully. I have not been disruptive, and I do not see any paperwork that you just described to be in
Mr.
front
Brooks,
of you.
I'm going to continue with a finding right now that you have flagrantly disregarded elementary standards of proper conduct. That conduct will not be tolerated. You stating things even in a mild-mannered tone of voice doesn't change the fact that we've had a dozen or more interruptions by you and by you alone. When you don't like the answer I give, even if that's a non-response, you continue to ask the same question over and over. You repeat yourself. You show absolutely no respect for the court. But the next interruption, you will be removed to the next courtroom.
I do not consent to any paperwork that is not based factually in law.
All your
I do
documents
give
are
my
based
consent,
We have the
law.
jurors here?
and I will not agree to anything.
Not yet, okay.
So again, with that title, I object respectfully. With that title name that is on your card, since you will not answer the question that I've merely asked of your honor numerous times at this point.
She doesn't have
In
to.
that title name, please direct the prosecutor to answer whether there are any more charges. Can the title name please direct the prosecutor to answer whether there are assessment for the charges
Mr. Brooks.
in her possession?
No one's going to be answering these questions, okay?
No one cares.
I'm not requiring the state to do that. I'm advising you to stop asking those questions.
request
It will
the-
be considered he's interrupted.
I
Take him to the
request
next
the title
courtroom.
name.
Yeah,
I'll
get
make
him out of
more
there.
findings when he is in the courtroom next
Do
door,
not agree
and
to
I
a
can
estoppel, Your Honor.
do that without
I do
an
not
interruption.
consent or agree to an estoppel, and I
You
will
don't have
move
to
the
agree,
court
my guy.
again.
Currently, you are not muted. All right, Mr. Brooks? All right, you can mute him. All right, Mr. Brooks, you have been muted so that I can make some appropriate findings here this morning. I understand that you object. Your objection is noted. Your lack of consent is noted. As I indicated earlier, I lost track after about a dozen or so interruptions by Mr. Brooks. He continues to ask questions
I
that
think the mute button was
told
the
him I would
greatest
not
ally
answer.
of this case.
He has failed to follow the simplest of procedural requirements. He continues to be in the other courtroom. You can see on the monitor, he's standing, he's facing the other direction, he's yelling I can't hear him, but it appears that he is yelling. I muted him because of his interruptions of the
he's
court.
yelling.
And
No, I don't know to who.
understand
I don't
he
know who
objects. His
thinks he can
objection
help
is
him
again
with
once
that.
is noted. And because of the disruptions, and based upon the authority in Illinois versus Allen, I also referenced yesterday a persuasive case. It's not at my fingertips. I'll get that for the record. It's the Pennsylvania case that I found to be of persuasive value, where a similar procedure was done. Frankly, what we are providing here in Waukesha County through the use of the technology we have in the courtroom is far superior to what was done in that Pennsylvania case. I have the ability to mute, to unmute. I can see him. He can see the 4 cameras in this courtroom right now. That would be me. It would be the table where I would like him to be seated. That is empty, the prosecution table, and then the witness stand. I will instruct the bailiffs over there to give him a pad of paper if he doesn't have one already. I know he had some documents and some things in front of him. At one point, I saw him sort of do a sweeping motion, and things seemed to go flying. I'll get some verification of that
Yeah, he's
from the
drama
bailiffs
like
who
that.
are over there through the bailiff that is in my courtroom. but he will at least be given a notepad, a writing utensil. He is advised that should he want to raise a strike for cause of any juror, my procedure is to address that at the end. Certainly if something comes up before that and he wishes to do that under the law, he can simply write on the pad of paper he has cause, hold it up, and I'll make a determination if I should excuse the jury and then take up that decision.
I know that the defendant made 2 motions to dismiss for judicial misconduct. Again, I'd ask the court to summarily deny those motions based upon lack of merit, and he didn't provide any support for either motion.
I believe he did raise a motion to dismiss based on judicial misconduct. I think he also threw in there another request to stay the proceedings or file an interlocutory appeal.
He always wanted
While
to.
that's really not something I would need to address because nothing's been
delay
filed
stuff.
as it relates to a request for an appeal, I will deny that summarily. There's been no basis in law or fact provided. I'll also deny the motion to dismiss based on judicial conduct, based upon there being no showing in law or fact. It appears to me that Mr. Brooks continues to stand, make hand gestures, and talk. I will, again, just advise him, should he desire to raise
hello,
any issues
sorry.
with the court,
I'm
he is
doing laundry
advised
as well.
to write that down on paper. The bailiffs are instructed to promptly provide that either to the court staff that's in there or another bailiff, and that will be provided to me forthwith so that I can raise any issues of merit. All right, with that, then
I
we
love
will
how he
begin the
just
jury selection
screams to himself.
process.
I
and so,
love that.
We can go ahead and bring them in.
All right, he's back.
All right, we are back on the record. Mr. Brooks, I was able to inquire. I've been told it would take maybe 15 minutes, but I'd like you to go to your cell to get whatever that list is that you have so that I can adequately advise the jury, potential jurors, about any witnesses who may be called in this case. I don't designate when I say if it's the state or the defendant, but you told me you have that, so I'm going to give you that opportunity. In the meantime, I'm going to print off the state's witness list.
I don't need it.
Now, you also mentioned
You do need it.
previously, when I referenced going back to your cell to get the list, I'm giving you that opportunity. You asked me to do that.
I did not ask you to do that. The question was, where was the list at?
That's true. So you said the list was in your cell. I'm advising you that I'll give you the opportunity
I
to
don't
go.
want to do that.
Can I finish?
I don't want to do that.
I'm
I just-
advising you
I
that
don't wanna.
you are being given the opportunity, if you so choose, to go back to your cell to obtain the list of witnesses that you have been working on. Further advising you that if you choose not to do that, either tell me now or write them down so that I can include them in the list of names I'm providing to the jurors.
So how am I supposed to do that without the list in front of me?
Well, go for
The
take
list
the
that you
list.
have in your cell?
How am I supposed to do that without the
I'm
list?
telling you, I'm giving you the opportunity to
I'm
go
not-
get that.
I'm not
So,
gonna go do that.
Mr. Brooks, I'm not going to play games with you.
And
I'm giving you
I'm
an
not gonna-
opportunity.
and I told you
You
that I'm
either
not
go to
gonna
your
do that.
cell and get.
I'm not gonna play games. I'm not gonna do that. How? It's just this is the kind of things that piss me off. It's like, okay,
You said I have the opportunity
not.
to do that.
All
You
right.
said I have the opportunity.
I'm not going to
do
demand that
that.
you do it, but you have to understand, sir, that if you
I
choose
don't
not to
understand.
do
I
that.
don't understand.
I never
I
understand.
don't understand.
All right,
I've
Mr.
made
Brooks.
that clear. I don't know
You
how
claim
many
to not
times for the
understand,
record.
and that's been made very
No,
clear
I don't
here, sir.
understand. You're not
So-
gonna get me to consent to something that I don't consent to or agree to. I do
know.
not
All right.
understand. Just
Mr.
like I
Brooks,
don't
we're gonna
understand the
take a
nature and
recess
cause
so
of
that
this.
the court can get this
Exactly
information
like I've
from
been
the
telling
state.
you from the beginning.
Okay, he's continuing with his disruptive behavior. It is his choice to do that. Mr. Brooks, you are hereby warned, once again, if you continue with that, you will be removed from the
Remove me
courtroom.
then. Remove me. Remove me.
Requesting to go to the other
Remove
courtroom?
me. I told you that before I even came over here.
Sir, are you requesting to
I
go?
told you that before I even came over here.
Mr. Brooks, are you
That
requesting?
It was pointless of me to come over here. You can smile all you want and
Sir,
think it's funny. I don't take this as a joke. I don't take this as a game.
You do.
My preference is for you to be
You
here.
expect me to answer all these questions that you have for me, Your Honor, but you have yet to answer one question that I've asked you. You have yet
Right.
to verify anything
You
by
can take
sworn
them back to
affidavit.
the
Doesn't have
other
to.
room
You
that has
haven't
been
even honored-
disrupted.
You haven't even honored my request to make an offer for my appeal.
Thank you, ladies and gentlemen. We'll have to clear the courtroom.
I don't agree to a stop when I move this court for a motion to dismiss.
The record should reflect
The record should reflect that my rights are being trampled on. The record should reflect that I don't agree to a stop. This is ridiculous.
It's ridiculous. It's really ridiculous what he's doing.
As soon as I raise the issue, I'm being disruptive. I'm intentionally trying to be disruptive. I'm intentionally doing this. I'm intentionally doing that. So I should have just stayed over here, which ain't even legal to do anyway. Can't be present and not present when it should be a motion. This is ridiculous, man. This is ridiculous. You're forcing somebody to agree to something that they ain't agree to. Y'all come up with
You really
anything
think
y'all
that?
can.
Well, just
Anything y'all
because
can.
I don't agree to being in jail, you cannot make me go to jail.
Why I need that in here? You could have left that over there. I'm going back over there anyway.
Just in case.
If I'm right here in front of her face, I ain't gonna have no problem hearing. That's why these could have. I'm gonna have to go back over there. Y'all know that.
We'll bring it with us.
I'm just saying, man, this is ridiculous, man. This is ridiculous.
Yeah, it is. I think this is the proper trial now. That was pre-trial.
Sir, state your name for the record, please.
Oh, no. This is still pre-trial.
Intervener in that matter appearing as authorized representative for my client. I accept for value and return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments. Also, Your Honor, I would like to make an offer for my appeal, if I may.
Why would you want to offer your... Well, you want to appeal if you're still not being convicted?
The record will reflect that the individual known to this court to be Darrell Brooks is appearing in person in custody. We are, of course, outside the presence of the jury today. Since they are not here, we are dealing with some housekeeping type of issues.
I do not consent or identify by the name that you stated earlier. I want the record to reflect that, if I may.
The record will...
Doesn't matter.
Thank you. I instructed my staff to make sure ample copies of the subpoena forms were provided to you. I did receive verification that those were hand-delivered.
Look at that. Look at all this acting. He's just acting. And then he just says no.
We'll provide additional copies.
Like there's no way
My
to prove that what
understanding
he's
those were
saying.
hand-delivered. Mr. Brooks, I believe you were requesting 6 subpoena forms. I'm going to have my clerk print out 10 so that you have ample copies. And when that is done and those are handed to you, I'll make a record of that.
Will we address the inmate communication form I sent about the...
I have a number of issues I need to address, so yes, we'll get to that.
You don't believe that has that's an important issue that should be taken up before
She's gonna take it up.
any further in the proceedings?
I just want to make sure the state has a copy of what was forwarded first before we take that up.
Respectfully, would like to state for the record and would like the record to reflect that I believe that this is an issue that should be addressed at this point.
It's gonna be addressed.
Preparing to do that after receiving the inmate communication form from Mr. Brooks requesting an adjournment. For the reasons stated in that document, I thought it important that we all have before us the current county protocol related to COVID-19.
Decline to accept that if I don't believe
Sir,
that it's
it will be
law.
placed on your table, but I will be referring to that today, so
Is
it's
it
been
law?
given to you.
Is it verified law, Your Honor?
Verified law.
Attorney Opper do
Like,
acknowledge
you think
that the
they're gonna
COVID-19
let
illness reporting protocol
something
was
that is not
provided.
verified law?
We object.
Yes, Judge.
Your Honor, I would like an answer to that question if I may. Because I have not consented to or agreed to accept any paperwork that.
Sir, it's been
It's not
provided
okay.
to you. It's
So are you
something I'm gonna
making-
consider. You don't wanna
Are you
read it,
making- are
you
you
wanna
making a
disregard it, that's
judicial-
your choice.
Are you making a judicial determination that you don't have to answer that question I just asked you, Your Honor?
Mr. Brooks, the COVID-19 protocol has been placed in front of you. It is your choice whether you want to review it or not.
They better lose it,
My
loser.
understanding, just from the information Mr. Brooks has provided, which is part of the public record, is he is requesting an adjournment of all proceedings due to learning that he's on a COVID-19 protocol. I don't have any other information than that, sir.
That is very easy information to obtain.
Sir, I
Just-
have
just like-
an attorney for the
Excuse me,
county
Your Honor.
here
I
who
don't-
will
I don't wanna-
verify
I
that
don't
none
want
of
you to
that
think I'm trying to
information
argue
has
with
been
you, Your Honor.
provided to me due to HIPAA
I don't want you to think I'm
requirements.
arguing.
So I'm
But
not
you're
arguing
arguing.
it with you,
I
sir,
know, I
one
just
bit.
want you to know that I'm not arguing with you either, but I was right in the middle of finishing what I was saying.
No one
So I
cares.
need to stop you for a minute, Mr. Brooks,
I don't
because
consent to that, Your Honor, because
you don't have to consent,
I
but here we
don't
go. Let
consent or agree to
me,
being cut off right when I'm trying
all right,
to
I'm just
provide
gonna
the
talk
court with
over him for a
information.
minute. I do not have any other information regarding, the COVID-19 protocol, meaning anything specific about you, Mr. Brooks, other than what was put in the inmate communication, which reads, due to just learning I'm on COVID-19 protocol, I respectfully ask for all proceedings to be adjourned at this time, which is why I asked you if there was any other information you wanted to provide me as I consider your request, because the jail has not provided me with any specific information.
That is incorrect, because just yesterday you were trying to obtain the witness list that was in my cell. You had no problem whatsoever having the JA come down here to have me verify that they can go in my cell and search for that. So I find it very hard to believe that you can't consult with jail staff for them to tell you what is going on in my situation, where they know
Because it's a health
that I've
reason,
just been
not
seen
a
by
list.
a nurse that placed
Different.
me on this protocol for having a loss of taste, fatigue. We're talking about someone's health that can affect not just you, but anybody else, not just officers, but also inmates. We're talking about health and we're talking about safety. That has a lot of merit.
I'm sure you're-
Frankly, Your Honor, I'm afraid. I'm fully vaccinated and I've never had COVID. I don't know what I'm looking at here. I'm
He's so worried.
that was the
You can
last
see it on
thing
his
I
face
was
that he's
hoping
worried.
I would be told today, Your Honor. So I'm afraid right now. I'm not feeling well. I don't know what's going on with myself. That's the reason why I put in the sick call slip initially. I had been telling officers for days that I hadn't been feeling well, but I didn't know what it was. But I felt that I had to put in the sick call slip because I was not able to taste anything. That is the reason why I was seen by nurses. That is the reason why the COVID test was administered, and that's why I'm on the protocol as we speak.
Are you willing to discuss with me what tests were done? Again, I cannot obtain that information on my own.
I'm not a nurse, Your Honor. I mean, why can't it be verified with the nurse?
I have to verify it with you. The nurse will not provide me with this information.
But the jail can, because they control the movement. They control all inmate movement. I can't just go from my cell to a HSU.
Inmate movement is not the issue at the
It's
moment.
not, but I'm saying the jail itself controls the movement of the inmates. That's common sense, Your Honor.
I'm not here to talk about
I can't
inmate movement
just-
at the
I can't
moment.
just
What I'm
walk to
asking
the
you is,
HSU.
do you believe you were tested for COVID?
I obviously was tested for COVID. I would not be on the protocol if I was not.
Do you know
The
what
nurses-
type of test? Was it an oral swab, a nasal swab?
It was a nasal swab.
All right. Do you know when the results of that test will be back?
From my understanding, Friday.
Friday.
That's what I was told by the doctors. I would have to be at least on this protocol until the results.
But what is the angle? Does he gain by delaying the trial another 3 days or whatever?
Come back, which
Were you-
he said the earliest would be Friday.
Were you offered a rapid test?
They said they do not do the rapid test.
So you weren't offered a rapid test?
They said they don't do them.
You see what he does right there? He was like, were you offered a rapid test? And he was like, they say they don't do it. And she asked again, this is a yes or no question. You were offered one. And he doesn't answer. That means that he was offered one. Someone at some point told him, we don't do one, but they actually offered him one.
Frankly, I'm very afraid right now because I don't know what's going on. This is new to me. Like I said, I'm fully vaccinated, Your Honor. I've been fully vaccinated since 2021. And so for this to just be sprung on me now to say this could possibly be a COVID thing, I've had people close to me that have passed away from COVID. I'm afraid as hell, Your Honor. That's the reason why I submitted the ICF for the adjournment. I was thinking at least until I can get the results, at bare minimum. I don't think I'm asking something that's
Sir,
impossible for
if
Your
I
Honor to
can
grant.
make arrangements to have a rapid test
There you
brought
go.
to you and administered, are you willing to submit to that test?
There you
Not
go.
at this time.
No.
Why not?
Not at this time.
Why not?
Why can't I get the results for the test I already took?
Because you're saying you're afraid, my guy. You're saying you're scared. You said you never had COVID. So why not?
But you're telling me you're scared? You're
Yes,
fearful?
I
Yes.
am.
But you
I am
don't
very.
want to take a test that might
I
tell you
took
today?
I took the test that he gave me.
And
if
you're
he
telling
And you
me
can
the
get
test
another
results
one.
won't be available to you until at least Friday.
At least Friday, that's what I was
So
told.
tomorrow.
I was told that I would be
Sorry,
placed
day
on this
after.
protocol until the results came back. The earliest that the results would be back would be Friday.
So that sounds like, to me, I think that's what they call a PCR test.
I have no idea, Your Honor.
Okay.
I have no idea what it's called. Like
Let
I
me
said,
ask
I've
you-
never had COVID. I don't know the test names. I don't know what they call them.
I'm generally familiar with some of the testing for COVID, and I'm asking you once again, if a rapid test can be obtained, are you willing to take a rapid test?
How would that be obtained? How would it be obtained?
I would
was
work
told,
with-
I can only go by what was told to me, because when I was brought in there and they told me that they had to test me for COVID, I was immediately like, what do you mean you have to
What do you
test
mean?
me for this? What is this about?
Well,
I had
didn't
a
you
lieutenant.
report symptoms to them?
Excuse me, Your Honor. I had a lieutenant and 2 officers present when I was asking all these questions. Why do I need? What's going on with this? Why is this? Why is this? Why is that? Because I didn't understand. Immediately in my head, I started to get afraid when they said they had to even test for COVID.
Well, were you reporting being sick and symptoms prior to them asking you to test?
Yes, I've told multiple officers. I didn't know what it was at first because it started with fatigue.
You
With me
don't.
feeling
You
very
have
fatigued.
nothing.
And I said, man, I don't know if it's just me being tired, or that's what I initially thought it was. Maybe I'm just a little exhausted. But I said, no.
I said no.
Anybody knows their body. I said this got to be something more, because I'm really, I don't even have an appetite. Then when I'm trying to eat, I can't taste anything.
That's what's it. Okay, now I need to put the medical sick
When did
card
you
slip
report
in.
these symptoms to the medical people or to even just a correctional officer?
A few days ago.
Few days ago.
A few days ago, over the weekend is when I started to notice the fatigue. So
He doesn't
I was
like
telling
saying
officers, "Man, I
concrete
don't
dates
feel
because
good."
that can be proven.
I don't know if it's just I'm tired.
When
Usually,
did you-
usually I don't just jump the gun and say something's wrong, because it may just be, it could be anything. So
When did you report the loss of taste?
I reported the loss of taste last night.
At the moment, I told you this earlier, you're not within 6 feet of anyone else in this courtroom. And I believe that provides ample protection for the other people in this courtroom. As I consider this request, you've provided information to the court. You've been able to tell me the symptoms that you are reporting, your understanding of the protocols. Despite you reporting fatigue, I know, I don't know if you're standing or sitting on the chair. I can't quite tell. It appears like you're standing, but maybe leaning over the table.
I got a knee on the chair.
Oh, knee on the chair. Okay, but you've been able to very clearly, coherently make your position known to the court at this time, and I appreciate that.
I'm
Let
just
me
saying
ask,
I'm tired and
Attorney Opper, if
I don't
there's
taste
anything
it's
you
like
would
so
wanna
easy
provide
to
or state at this
say.
time regarding this request.
Yes, Your Honor, a couple of things. Number one, we believe this is nothing more than a further delay tactic by Mr. Brooks. I can advise the court, as an officer of the court and as an offer of proof, that he is.
How could
Mr.
that?
Brooks,
How
did
could
you
that
hear
even?
Attorney Opper interrupt you when you were talking?
Well, I respectfully object to
You
that.
can object, your objection's noted, but you need
But
to
shut
let
up.
her state what she needs to state. I will give you an opportunity to respond. I'd
That's
encourage you to use
that is
paper and a
ridiculous, Your
pen
Honor.
to write down. That's the rules of decorum in the courtroom, sir. We generally avoid interrupting one another. That is a sign that we all understand that this is a place of dignity. It is a place of respect. So I will give you an opportunity to respond, but you need to give Attorney Opper an opportunity without interruption. Go ahead, Attorney Opper.
Thank you, Your Honor. Your Honor, again, we believe this is a delay tactic in line with the defendant's behavior since about the August 25th or 26th motion hearing. I can advise the court, as an officer of the court, that Mr. Brooks has been saying for the last several weeks in his recorded jail calls to his mother and others that he's going to get this trial delayed or adjourned or pushed back.
They have access to your conversations,
Behavior,
dude.
Again, on the 11th hour is 100% consistent with that. I believe that if the court wanted more information from the jail administrator, she is present and could provide that information. I believe Mr. Brooks has waived any HIPAA privacy rights he may have in that regard and indicated that to the court. The fact that he claims to have started reporting symptoms as far back as the weekend, we're probably right up against the 5 days right now. If he started this on Saturday, which I don't believe there's any record of, we're at 5 days right now. And certainly the court's offer to...
I never once said.
Mr. Brooks,
I never
have
said.
an
I never.
opportunity
No,
momentarily.
No,
You
I
need to stay
respectfully
quiet.
object
This is
to
why he
that
doesn't
because
say
that,
days.
That has no merit.
Mr. Brooks,
I-
it's not
she's
your
saying-
time
no,
to speak.
No, I respectfully object. I never reported saying what day. I never said a day. And if you saying she's saying she has jail phone calls, well, why aren't they present? Why can't they be verified by sworn affidavit and brought into this court to be shown that this is a delay tactic, as you say it is? How come it can't be shown by sworn affidavit? Can you provide
What?
proof of that?
All right, Mr.
What?
Brooks, I've given you a little bit of leeway
just like you're
because we
saying
are outside the
that I've
presence
waived
of the
something,
jury.
I haven't given consent to waive anything. I've simply told the judge that I had no issue with her verifying with the jail that this protocol is in effect and that I was in effect tested for COVID-19. How could that be a delay tactic? If that was a delay tactic, why would I even need to be tested and placed on the protocol? Why does everybody
Because you
have to
said you
have
had
one mask to
symptoms.
bring me down here?
All right, Mr.
Is
Brooks,
there no-
I've
is there
given,
no
Mr.
verification?
Brooks, I'm gonna warn you now that you have interrupted a couple of times. You interrupted
I have to
Attorney
be able-
Opper
I have to be
twice.
able to speak up,
You're
Your
now
Honor.
interrupting me yet again. We all were polite and had you provide
was not
information.
polite. That was
That's
abuse.
the-
That was
at least
abuse.
the
That
third,
was not abuse.
interruption of this court.
That was abuse by the prosecution. That was abuse.
Mr. Brooks, let me finish.
No, because
No.
that's- I
So
would
now
not-
he's
I would not
outright
sit here-
refusing to listen.
I would
He's
not sit
outright
here.
talking over
no,
me
I didn't
at the
refuse
moment.
anything. I didn't refuse
Mr.
anything.
Brooks, we are at
I'm
the
not-
point
I'm not gonna-
yet
I'm not
again
gonna- I'm not
where
gonna
I
sit-
will put you in the other courtroom because
And
you
I
are
don't
not
consent.
able.
I don't consent to being removed. I have not waived the right to be present, and I don't agree with that.
Mr. Brooks,
Does the
I
record
have
reflect?
provided
does
you
the-
on multiple occasions and it's should be in front of you,
No,
and
I
if
don't.
not,
I don't acknowledge that. I haven't agreed
you
to
have been
it, and I
advised
haven't
on
given
multiple
consent of it.
occasions that you need to abide by the standards of courtesy and decorum for the courts of Wisconsin. Because you are a litigant, you're both a named defendant, you are now acting as your own attorney by
I'm not a named
representing
defendant.
yourself.
I don't recognize the name
That all of the
the
rules
state
of courtesy and
put on
decorum.
If you're not a named defendant, what are you doing there, my guy? Why are you not asking anyone to be like, hey, they have me kidnapped here. I'm not that guy. The fact that you don't recognize that doesn't mean anything.
Apply to
I don't
you.
recognize that name.
I need to warn you that further interruptions may very well result in you being removed to the other courtroom where you would participate by audiovisual means. From the jail administrator, thank you very much. And just to get some general information and perhaps even some specific information regarding the what Mr. Brooks has provided, since he indicated I could verify all of this information with either the lieutenant or others who are present. So I believe we have Angela Wallenhaupt here, if she would come up to the witness stand.
Your Honor, if I don't want to mix issues, but the inmate communication form from September 28th also still needs to be addressed by the court, and I think the jail administrator may have some information relevant to that issue as well.
All right, thank you.
Please.
I have a list of a bunch of things I want to go over, and I'm gonna.
So, Your Honor, respectfully, just so I'm clear, are we addressing the issue at hand now?
We are.
Or are we addressing something from September?
Well, I will get to the September inmate communication form at some point during this hearing, but right now I'm addressing the most recent inmate communication form that is dated October 5, and that addresses your request for an adjournment.
Judge, I have not reviewed his medical record prior to arriving here.
All right, fair enough. Do you have an understanding of what that is?
Yes,
Based
however,
on information provided to you?
yes, however, he has not signed a release allowing me to speak to the court. So if you are ordering me to speak to the court, I can speak to what my understanding is.
Mr. Brooks, I took your statements earlier that you would not object to me asking jail staff about the current situation to verify the information you provided. Is that still correct?
No.
I said that I wouldn't have any issue with pertaining to myself. I don't know. I'm not speaking about anybody else in the jail. I'm not speaking about what everybody's situation is different.
Right, and I'm specifically referring to your situation.
Well, the question was asked in, how does it pertain to me? It was pertaining to me, all the questions, which it came up when I said that there was a lieutenant and there were officers present when I took this test from the nurse.
Right, I'd like to verify the
Yeah,
information that
they
you're
need to-
providing to me regarding what was reported by you, what tests or tests were administered, and why you're on the protocol with the jail administrator. First of all, do you understand what I want to ask
I don't
her
understand.
No, I do not understand.
about? Did you hear what I said just now?
I do not
I
understand.
do not understand.
But did you hear what I said?
Frankly, Your
That
Honor,
was
I
not
think
the
She
question.
would probably be the wrong person to be asking because she wasn't present.
You must understand then what I'm saying if you
I
think
don't
she's not
understand.
the person who would provide that
No, I don't
information.
understand.
So,
I didn't consent to understanding or agreeing to that.
Never
No,
consented
I
to
do not
understanding.
all right. I took his statements earlier. I realize you don't have a written waiver as to be a verbal waiver of any privacy rights under HIPAA, and I am directing you to answer the question.
Okay. It was brought to my attention shortly before the lunch hour that he had made statements that prompted the medical department to follow up. As I said before, I have not reviewed the medical record. It is my understanding he was administered a test. He was also offered another test, to which he refused.
He refused.
Do you have any information regarding whether this other test would have been a rapid test?
I believe it to be.
Do you have those tests available in the facility to offer to an individual?
I have one available right now.
Right now, let's do it, bro.
Can I ask a question, Your Honor?
Of me or of the witness?
Of jail administration.
Go ahead, you can ask a question.
Ms. Wallenhoff, if there were different types of tests available, why wasn't I administered the correct test when I first was tested?
The correct test.
Why would essentially I would be asked to take a test, take that test, then turn around again and be told to take a whole nother test? In my mind, that's almost like some type of ploy or something, some type of scheme. Why?
It's always something against him. Always
I asked the
something
question,
against
why
him.
would I not be given the correct test from the get-go instead of having to take two tests? If I've already taken one test,
You have to give her an opportunity to answer, and you
I've
gotta
already-
ask one question at a time.
I just asked the question.
And
Can
let
she
them
answer
answer.
it then? Do you want her to answer it? I presume you do since you asked the question, so you need to stop talking so that she can answer it, okay?
Limit your abuse, Your Honor.
I'm sorry?
I don't appreciate being talked to that way, Your Honor.
Your objection
No
is
one
noted.
cares.
Go ahead and answer.
Judge, I would prefer not to answer that question. He states the wrong test. I don't know what he's speaking of. I have not reviewed the medical record with what test was administered, so I would prefer not to answer that question.
All right, fair enough.
I did not say the wrong test. I said two tests. If it was, why would I need to take two tests for the same symptom?
Your Honor, I object to relevance and beyond the scope of this witness's knowledge, and it also assumes a fact, not an evidence.
It's all wrong.
I didn't have clarity on the answer to that question. Essentially, what I'm asking is, why would I need to take two tests for the same thing? There shouldn't. If I'm taking a COVID test, why would I need to take another one?
Because you're bitching about it.
Object is the lack of foundation and beyond the scope of this witness's knowledge, Your Honor.
The objection is sustained. I'll direct the witness. She does not need to answer that question. Next question, if you have one, please.
I still don't have clarity on that, Your Honor. I'm baffled.
Of course you are.
Another question? A different question?
Would it be any way to verify why I would need to take two tests for the same symptoms?
I'm
What?
not sure I understand the question, sir. I think
I'm referring to the nurse who administered the test.
the nurse isn't here, though. This is Jail Administrator Wallenhaupt.
And that's why it's hard for me to wrap my head around why Mrs. Wallenhoff would be called to testify when she was not present. I think the wrong person is testifying.
Do you have any other
Because
questions
the
for
reason
her?
why I say
I understand
that-
what you're saying. Do you have any other questions for her, though?
Are you sure you wrapping your head around what I'm saying? Your Honor?
Yes.
Do you have any other questions for this witness?
to your knowledge, you just said that you have a rapid test available right now. When did that become available? Because I was told otherwise.
I know there is a rapid test available right now. As I stated before, it is my understanding that you were offered a rapid test and you refused.
So why was I not offered a rapid test from the get-go?
Objection, relevance.
If she knows, she may answer.
I do not know the answer to that. I have not reviewed the medical record, jail contracts with a medical provider.
Thank you. Next question?
Yeah, she doesn't know. What would she know?
So there are more than one type of COVID test administered by this jail.
Oh, this guy.
Again, the jail contracts, Judge, I prefer not to answer that. The jail contracts with a medical provider. I do not direct testing.
He doesn't know.
I believe
Let's
the
move
record's
on.
clear that a rapid test was offered. It was declined by Mr. Brooks. The record's also clear that
I
he did
object to that,
submit.
Your Honor.
He did submit to a test. To further answer it might be speculative. So, do you have another question?
So would it be fair to say, you just said it would be speculative, so would it be fair to say that it'd be speculative that the second test would be a rapid test?
No. What?
I will make a determination on your motion after all of the evidence and testimony on this issue is received.
Is that an
I
answer?
can't
Your
answer
Honor?
Yes,
that
that's an
question
answer.
at this
Well,
time,
I'm
sir.
asking it of Ms. Wallenhoff. Is it because we just said it would be speculative? So
That's not what she
You
meant.
said that.
Well,
So are you? And I'm not going to answer that question. I'm not a witness in this.
the
I
reason
make
why
the
I was-
determination
the reason why
ultimately.
I was looking at Your Honor is because
Do you have another question
I'm
for
still trying
Jail
to figure out
Administrator
how-
Wallenhaupt?
I thought testimony was supposed to be the prosecution and the defense's time to
Sir,
ask
do you
questions.
have another question? Otherwise, I'm going to ask the
Ask
state if they have
something.
any more from this witness.
I asked the question, would it be fair to say that it's speculative about what the second test actually was?
No.
Mr. Brooks, I don't understand your question.
What isn't to understand about it? If you were offered a test,
Objection, relevance.
no, it's a question.
Hold on.
I'm
You're
getting
asking
some.
a
I'm going somewhere.
I'll let you get the question out, but I would just note you're asking her a hypothetical that, given her role, she might not be qualified to answer. But you can go ahead and ask it.
Well, it's not hypothetical. It's very logical. If you were offered a test and you took it, why would you need to essentially take another test that could have been done right from the beginning? If there would be any issues, if there would be
Hello. Thanks, Paul.
All right, Mr. Brooks, it's not
Are
relevant.
you
what
another
she would
self-punishing
do.
fan of
So
this
that's
trial?
essentially
Yeah.
argumentative
I'm
question.
really.
It's
why would I
not
do it?
relevant. So
I mean,
you're done
I'm the
asking
kind of guy
questions.
that
Now
just
ask-
listen to this stuff to
I haven't
sleep.
made a judicial determination yet.
you're
Go ahead,
practicing
Attorney
law from the
Opper.
bench by being able to ask
Mr.
her
Brooks.
questions of yourself.
Mr.
That's
Brooks,
not what
okay, here's your
practicing
warning.
law from the bench
I'm
means,
giving
dude.
Attorney Opper an opportunity
So
to
you're
ask this
practicing law from
witness
the bench.
questions, and if you interrupt her, you will be
That's
removed
not what
from
it
the next
means.
courtroom.
I don't consent to being removed to the next courtroom. I don't consent to even being at these proceedings if I'm not able to put on a proper defense, which is my constitutional right to be able to do so.
You don't need to consent.
I haven't agreed to any contracts. I haven't consented to any contracts, and I have
Your
not
objection
consented-
is noted. Attorney Opper, go ahead.
I have not consented
Thank you.
to
Ms.
an
Wallenhoff.
estoppel either. Jay, for relevance.
To your knowledge, are those materials?
The objection is overruled.
Yeah, shut up.
To your knowledge, if you know, are his discovery materials currently in his jail cell?
Yes, ma'am, to the best of my knowledge.
Okay.
I object to
Is
that,
he
Your-
still
I object
able-
to that, Your Honor. I'm not allowed.
Oh yeah, I mean,
Stands, there's no
listening
question
to him
which
right
you
now
object.
just
Object to that.
yelling to the clouds is
You
great
can't
because you know
testify if
he's
you
not
want.
getting
If you
away
want
with
to
it.
provide further information after she is done testifying, I will give you that opportunity.
Will she-
Your
will she be
objection
able to-
is
Will she
overruled.
be able
Overruled.
to Stay right there so I can ask the question.
It's not your time yet. You have to wait.
Yeah,
So
shut up.
This is the final warning. Okay, I've given you a lot of leeway today.
You have not, Your Honor.
You have not. This
No.
bitch.
I am turning to
Oh,
Attorney
sorry for the
Opper.
word.
It is her opportunity, her turn to ask this witness a question.
And it is my right to be able to object, just like she objected
And
when I was asking
right,
questions.
and when the court rules on an objection,
You shut up.
usually the party who objects stays silent.
I'm
I rule on the objection. The parties don't debate the ruling. It's noted for appeal. And then we move on.
Then I
Move
would
on.
like to put you on notice that I will be appealing that judicial decision that you are making.
Next question, Attorney Opper.
Judicial determination.
Ms.
rather,
Molenhoff,
that you are making.
while on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses. Is that correct?
If he wants.
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Yes, ma'am.
He does.
And nothing about the protocol would restrict his access to any of those materials. Is that correct?
Correct, ma'am.
And you've
I object to
indicated
that. I
previously.
object to that respectfully, Your Honor.
Object to what?
So, an objection goes to whether there's lots of rules of evidence that apply. But if you're objecting to her answer, that's a different thing. You can argue
I'm
the meaning
objecting
of
to
that
the
later.
question.
Okay,
Not
the
that-
No, you're
objection.
not.
But
They're
then you
objecting
have
to the
to say
answer.
objection before she answers. You
She
objected
didn't
after
answer.
she answered.
didn't answer the last
The
question.
objection is noted, it's overruled, her answer may stand. Next question.
Ms. Wollenhop, you're aware that there has been
I love when he
digital
gets mad.
discovery
That's one of my
made
joys
available
in life.
to Mr. Brooks for him to view in the
Him-
Waukesha County Jail, correct?
Getting mad is so great.
Overruled, she may answer.
Correct.
He would view that digital discovery on the computer in the conference room in his pod,
I
correct?
respectfully object to that.
Overruled, you may answer.
Correct, ma'am.
And
So you're gonna
the
overrule everything, Your Honor?
All right, Mr. Brooks.
He's like, look at his face. Look at this frown. I love this frown. I love when he makes that. Like, you're gonna overrule anything? Yes. Everything that needs to be overruled is gonna be overruled. Just deal with it.
You have got to stop. It's fine if you object. I will rule on it as I deem appropriate under the rules of evidence, which, by the way, I provided a copy for you. See that big book over there?
No, I don't
It
see
has
it.
the criminal statutes.
I don't see it.
It has the traffic
I don't see
code,
it.
it has the
I'm-
rules of
I don't see it.
Well, it's
Where?
on your
Where?
table. It's behind the microphone, and it's there. I've provided it to you as a courtesy so that you have that available
You did not
to
provide
you.
anything to me.
All right, I'm
Something
directing the
that-
bailiffs to
something
remove
that
him
may
to the
have-
other courtroom.
Get him
I've
out.
provided
Get him
ample
out.
Opportunity
I've
for
never-
Mr.
I've
Brooks
never
to
taken
abide by the
anything-
simple
I've
rules
never
of
taken
decorum
anything,
and
Your Honor.
civility.
Your
Yeah,
Honor, I
you don't have to be a
agree
genius in order for you to understand
Your
how
lack of
Don't give
consent is
consent.
noted for the
How
record.
don't give
simple
consent
court
to an
works.
estoppel. I don't
I'll
I
make
can.
a more full
I'm not
record
even in
when we,
America, and I get
I
it.
don't
Open
give consent
again to
an
the public.
estoppel. I don't give consent to be removed.
Madam
from
Reporter,
being
the
able
record
to
should reflect,
exercise my
the court is
constitutional
stepping
right.
off the bench. You may step off.
I
if you
move.
want.
I move for a motion to dismiss. You still haven't even ruled on the claim. There's no one that even has a claim against me here.
Mr. Brooks is
You
muted, so I can
no one.
appropriately make
That's one of the other things that I love / hate about this is that he's like, where is the injured party? Who makes the claim? And like, well, you killed 6 people. How are they gonna come out and be like, I accuse him of killing me?
my record here today. I will promise to unmute him when we continue with the hearing after I make my record regarding the removal,
Yeah.
assuming he can maintain even the simplest of civility. And I do want to initially confirm.
Yeah, you're right. I mean,
I know
she's
I could
and
hear
the thing
him
is,
until I
she has his life here. Like she's the one that is like, you know what? I can give you 6 concurrent life sentences and dismiss other charges. But no, he wants to argue with the people that's gonna
Muted him.
put you
I
in
can
jail
see
for
him.
1,000
Could
years.
we please get
At
confirmation
least.
from the other courtroom that the audio and visual is working? All right, and we do have confirmation of that as well. I gave him ample warning before he was removed. This court
Objection.
frankly has no other option at this point other than to put him in the other courtroom so that I can continue with this very important hearing, a hearing at which he has requested an adjournment.
Yeah,
of
you
the
can make your record.
proceedings.
Judge,
All right, go ahead, Attorney Opera, for the record.
judge that has the power to
mute has
remove
been
me from
undone.
here.
In order for him to view the contents of the thumb drive, he'd have to use the computer in the conference room, correct?
Correct, ma'am.
And that is available to Mr. Brooks upon his request, correct?
Yes.
Correct, ma'am.
And nothing
Hold on
about,
a second. Mr. Brooks, the basis for your objection at this time?
That is irrelevant to why I'm asking for adjournment. I was not asking for adjournment based on being able to utilize the conference room or a tablet.
Your objection is noted. It's overruled. Her
Shut
answers
up.
may stand.
nothing about this protocol then would limit his access to any of his discovery materials,
Nothing.
correct, ma'am?
Objection.
Overruled. She may answer.
Correct, ma'am.
And he would have access to the telephone if he wants it.
Objection.
Overruled. She may answer.
Yes, ma'am.
And there would be nothing that would
We didn't even
restrict his
finish our
ability to
discussion. You
come
got
to
to make
court
record
each
when
day?
you do. I get to make mine the massive felony. Yeah, it's just
Overruled.
he thinks it's fair. He thinks
Correct,
that
ma'am.
he thinks that because the judge does something, he needs to be able to do it as well. That's not how it works. Maybe I will need Artie or someone like that to be like to tell me if the state does something, then he gets to do something as well. I think that's how it works. But if the judge does something, you don't have right to nothing. You just exist. That's
And
it.
when he comes to court each day, he has the ability to bring whatever discovery materials with him that he wants. Is that correct?
Objection.
Overruled.
Correct, ma'am.
And in fact, there's a card available for him to do that if he so requests.
Objection.
Overruled.
That is correct, ma'am.
He started feeling not well, I believe were his words, over the weekend.
Yeah, I mean,
And,
by
is
age, he's
there
an adult,
any
but
notice to any correctional
But no, he's not an
officer
adult.
or,
He's a kid.
Jail supervisor that you're aware of that Mr. Brooks reported that to them.
Objection.
Overruled.
also the fact that he has to object to everything. I don't know how many objections he did during the trial, but almost like 90% of all the questions were objected to. Ugh.
I have not reviewed the jail medical record. This came to my attention shortly before the lunch hour.
Okay, I guess maybe I'm asking a question I don't know the answer to. If he were to say to one of the officers or a lieutenant,
Hold on a second. Was that an objection? Or just a comment under your breath? Your objection's noted. It's overruled.
I mean, he should be 41 by now.
Protocols would prohibit being able to shower.
objection, irrelevant.
I'm not gonna, it's sustained. Mr. Brooks, I'm going to honor the request of the jail administrator not to talk generally about protocols, given the operations of the jail, but you may ask her if there's something specific as to you.
Yeah, we all been since we were born and then we were more adults.
Currently,
We took a few breaths of air and then we were more adults than him.
and or shave.
Do you speak moving forward?
He
As of right
he also doesn't know how to answer, so how to ask questions. He talks so in general about everything. It's like all the information that you know at that point. What do you know? And the people is like, what?
You would be allowed to shower on the protocol you're currently on.
Would I be able to shave?
You would be able to shave.
I mean, he does have really childish reactions.
Clippers or a razor?
Like right now, when they find out about the
Mr. Brooks, we would monitor behavior
when
and
they
other
find
factors
out
in that and
about
make a determination. There's procedures
the
and
results of the
operation in
COVID
the jail
test,
that you can request those items.
um,
And you could
he starts crying.
The COVID protocols.
Correct, ma'am.
That's not an adult reaction. That's a child reaction. You're not getting away with his
I'm saying
thing.
myself as well, being housed in the jail, that we are only permitted razors once a week and clippers only once a month.
Judge, I would prefer not to answer questions in regards to jail operations.
Right, I'll honor the request of the jail administrator. It goes beyond the scope of this hearing.
No one cares.
A little far field, I gave you a little bit of leeway, but whether you shower or shave would, in my humble opinion, not be relevant to the issue.
Yeah, it doesn't
of whether
matter.
You can assist in your own defense.
Would you care to share with the court on record the types of protocols that I am currently on outside of the COVID protocol?
Objection, irrelevant.
Yeah,
There's the jail
who cares?
operations.
Sustained.
Does my specific protocol change the normal time that I would be allowed out of my cell?
That doesn't matter.
Again, that speaks to jail operations.
Mr. Brooks, unless you have a specific question related to access to your materials, I'm gonna have her not answer that.
Yeah.
To the best of your knowledge, are you aware that there is a certain times that the phone will be available? You have other inmates that
Let's not talk about other inmates, but
that doesn't matter.
I'm sorry for the interruption, but I want to try to get us through these questions. If you're asking,
Okay, let me ask it another way.
okay, go ahead.
Being that because of this COVID protocol, I won't have my usual time out of my cell that I would have regularly, would I be able to utilize the phone in the same manner that I would be able to use the phone had I not been placed on this protocol? Or would it be strictly by me having to just ask?
I guess I'm unclear as to the manner you speak of. What are you referring to?
Yeah, what do you mean?
I think I was very clear.
No, you were. If you were asking a question and the people are like, I don't get it, then whatever.
Are you trying to ask her?
Are you aware, which I know you are, that
I know you are.
the protocol that I'm on outside of the COVID protocol prohibits me from being able to utilize the phone at certain times of the day? Would the COVID protocol prohibit that any further?
No.
Mr. Brooks, are you trying to ask whether the COVID protocol impacts your phone privileges?
Yeah.
That's what I just said. No,
No, that's not what you said.
Because I think it's more accurate with the way that I asked it.
But your question assumes facts not in evidence and that are beyond the scope of this proceeding. I'm concerned about what, if any, impact the COVID protocol has on your ability to prepare for this case.
Yeah.
The reason why we're having this didn't have anything to do with limiting my preparation.
So
What?
That wasn't the real issue.
I think it's related to
I
the.
just wanted that clear.
I understand.
That's all. Outside of the COVID protocol, the protocol that I've been on for a very, very long time. So my phone
Yeah, he has no idea what prepare means.
certain hours of the day, which works out.
All right,
for
Mr.
my
Brooks, we're
family.
getting a little far field. I need to make a determination on your request.
Yep.
So I'll ask you one last.
You haven't let me finish what I was getting to.
Mr. Brooks, I will ask you one last time. Do you have any other questions for the jail administrator?
Your Honor, what you're doing right now is you're not being fair right now.
All right, Mr. Brooks has not
Ah.
answered unless there's any further questioning from the state based upon the additional questions that were asked, then I'm gonna have her step down.
I just want to ask of the court if you're intending to take up his inmate communication form that was dated September 28, 2022 as well, while Ms. Wollenhaupt is on the stand. I just have a few questions related to that, Your Honor.
I object to that. Relevancy. What does it have to do with?
It doesn't have to do with anything. It has to do with another thing that you put in your, that you wanted to address.
She's testifying to right now today. They're two separate issues.
I'm sorry, I don't know the document. Oh, I do have the document number, 258.
Objection for relevancy.
Hold on, Mr. Brooks. I need to find the document in my record.
I need something that I can raise as well.
I am going to allow the jail administrator to be questioned regarding document 258.
I have a picture of myself.
So I will print it off in that courtroom.
Look at this guy. Look at this young guy. I think I was 17 in this picture.
So that I have this correct on the record, you're making a judicial determination to allow testimony of something that has no relevancy to what's being raised today.
I'm going to address it after I address the motion to adjourn that you filed, but since we have her here, I'm going to have the parties question her on that document as well. It promotes judicial economy, and that's my decision. So go ahead.
Can I put Your Honor on notice that I intend to appeal that decision?
Why would she care if you appeal or not? It doesn't matter to her.
Your statements noted of record. Can someone confirm whether that document was given to Mr. Brooks as well? I did print it to the printer over there. I have that ability. It was. All right, thank you. The record to reflect he has also been provided with a copy of docket number 258.
I'm not acknowledging that document, Your Honor.
Of course you're not.
I don't consent to any.
All right, I'm going to mute him because he's interrupting. Mr. Brooks, it's a document you filed.
Yeah.
This communication to the court, Mr. Brooks indicates that he is on a, quote, keep separate, end quote, in the jail, correct?
Correct.
And at the conclusion of the form, near the bottom, the last two sentences, he indicates that he has no access to the materials he needs to prepare for trial because of the keep separate order, correct?
Right.
Correct, that's what he states.
Okay. Did Mr. Brooks have access to his legal materials during the time that he was under a keep separate order?
Yes, ma'am.
Yes.
Again, that would be the banker boxes of written discovery in his own jail cell?
Correct. Anything that was in his jail cell, he would have access to.
Okay.
And he would also have access to the conference room and a tablet.
And the
in his
tablet.
cell.
The legal materials that
Yeah.
are provided to him are on that
There's
tablet
there's
and
several
on the
times where
computer
Judge
in the
Darrell just laugh at him,
And
laughs
nothing about
straight up
that keep
laugh at
separate
what's
order
going on because he
affected his
cannot
ability
believe it.
to access those things, correct?
Correct.
Thank you. I don't have any other questions on this topic, Your Honor.
All right, Mr. Brooks,
There we go.
I will unmute you. Do you have any questions on this topic?
Also this, the headphones. The whole headphone thing is a sham. It's an act. He doesn't need those.
For the jail administrator.
Yes, I do. You just stated on record that I had access to all materials for trial prep during the time of this keep separate, correct?
Yes.
It doesn't specifically say what you don't have access to, so yes, what was in your cell.
Did you just say in open court on the record that I in fact had access at the time of this keep separate?
Yes.
2 items in your cell, and you could have access to the conference room to view electronic.
So, am I correct in saying that when you brought over these
Yeah, then he tried to amend it to I can hear you good.
that I was in fact in one of those conference rooms and I talked to you face to face, is that correct?
You were in a conference room and we spoke.
Yeah.
And I informed you then that I was on the keep separate, correct?
I do not recall that.
I specifically told you
that I was gonna keep separate with the guy that was in the cell next to me that had placed that on me, correct?
I do not recall that.
So you don't recall, you can recall that we spoke, but you can't recall what we spoke about?
Yeah.
I informed you at that time I was delivering the banker's boxes.
And I took the liberty to explain to you that
The
I was gonna
liberty.
keep separate, and that
I
was
did you a favor
me being able
of
to.
explaining you
Is
this.
that correct?
I do not recall that.
You don't recall that, or you don't remember me bringing it up?
I do not recall us having a conversation regarding the keep separates. We had a conversation regarding me delivering your legal material.
Yeah.
So, is there a way to verify when the keep separate went into effect?
Objection relevance? Well, hold on, Mr. Brooks, is the issue that keep separate protocol, or that you didn't have access to the materials that we've now established through testimony you had access to once they were delivered to you?
Initially why I wrote it was because that stops me from being able to shower in the unit, because officers would have to then take me.
This is this. He made a document for the court for Judge Darrell because he couldn't shower. How is that her problem?
And take me to another part of the jail, sometimes in the pod, in a secure shower is what they call it, which is downstairs.
Sir, I'm just gonna stop you, because I honestly, the whether you have a shower or
Yeah.
not is not relevant to the
Who
issue
cares?
of whether you had access to the materials you need to prepare for your case. Any questions?
Actually, never caught that. This is
at
new
this
to me. I
point
didn't caught that he
for
was
the jail
bitching about
administrator?
not being able to
Not
shower.
related to the shower, but related to access to materials.
Does a keep separate protocol, Ms. Waterhall, does a keep separate protocol restrict inmate movement in any way?
Objection relevance. Sustained.
Yeah, it doesn't matter right now.
If I am on a keep separate protocol, with that in effect, limit me to only being in my cell and being able to only utilize what I would essentially have in my cell.
What?
That's a compound question, so you have to break it down one at a time. So rephrase.
Would a keep separate protocol restrict me to cell confinement until arrangements can be made for me to be able to resume my normal activities?
What does that have to do with anything?
Judge, I would prefer not to answer that. It's due to jail operations.
Mr. Brooks, I'm gonna honor the request of the jail administrator.
Doesn't matter.
To not answer that because it would require her to provide information regarding jail operations. It's overly broad. You need to limit the question to how this
the court,
protocol
to the case.
limits you, specifically as it relates to access to materials needed to prepare for trial.
Yes.
I asked the question.
No, you didn't.
And I was told that it wouldn't be answered. I asked at the time that she brought over the discovery materials, was she aware that I was on a keep separate protocol at that time?
What does that matter?
Asked and answered. Sustained. The answer was already provided. She doesn't need to answer it again. Next question.
What was the answer to that?
The record speaks for itself, sir.
Yeah, if you're not paying attention, it's not.
Next question,
I don't
please.
recall her answering that specific question.
Next question.
That's on you.
please.
Pay attention if you're asking it.
Can you provide for me where she answered that specific question?
No.
Mr. Brooks, do you have another question for the jail administrator?
Is it going to be answered? Is it going to be honored?
The record speaks for itself, sir.
Well, if the record speaks for itself, then that question should be able to be answered. Were you aware, Ms. Wallahop, that at that time I was on a keep separate protocol.
Doesn't matter.
It's already in the system that I was on that protocol.
What date are you referring to, sir?
It's too general all the time.
The date that you brought over the discovery materials, were you aware at that time, on that date, that I was under a keep separate protocol?
You previously asked me if I recall the discussion you were informing me.
But that's not the question now, though.
I was aware.
The question is, the day that you brought over the discovery material, were you aware at that time?
I also think that a lot of times he knew what they said, but he was trying to get them to switch a word or two, maybe try to confuse them and change the testimony a little bit, just so he can have something to go on. That's my theory.
I can't state for certain at that moment in time. I was aware you were on a keep separate. I can't state what day that I was made aware of that. I think it was due to a complaint that you sent forward to the jail.
I sent no such complaint. The complaint was by the other party. Were you aware of that?
Who
Judge,
cares?
I prefer not to answer this. I don't
Not relevant.
understand how it impacts what he has
Mr.
had
Brooks, we're
access to.
far afield from the issue at hand, so I'm going to ask you one last time, do you have any additional questions for the jail administrator?
What are you allowed and not allowed to do on the keep separate protocol?
Who cares?
Sustained. All right, then, I gave him the opportunity to ask questions. That was his last one.
I wasn't done.
You are done.
Mr. Brooks.
You're asking the same thing.
I'll give you one more opportunity then.
Why?
They need to be
No,
relevant. They
Judge,
need to be within
please.
the bounds that
Let him
I've
die.
Already discussed.
That was in the bounds. I just asked this.
The issue is limited to the impact of the keep.
I mean, the judge also has a lot of fault in this because she gives him a lot of free passes, a lot of them.
Separate on your ability to have access to materials needed to prepare for trial.
But Your Honor, with all respect, every question that I asked that had relevancy to that was either overruled or you were.
He was basically asking if he was allowed what he wanted to say, but he was too dumb to understand this. He wanted to ask if, by him being in these protocols that he has, that he was going to be able to do that and still do all the other stuff that goes on in jail. But he doesn't know how to say that. And if he managed to get it out, it's irrelevant anyway, so they don't have to answer it. So yeah, it doesn't matter.
She was directed not to answer that.
Mr. Brooks.
So how the
Mr. Brooks, you indicated you had other questions. I will give you this opportunity if you can ask a question that falls within the scope that I've previously identified.
Please.
Do you have another question?
Would I be allowed out of my cell on a keep separate protocol?
It's vague, Your Honor.
Yeah, it doesn't matter. It doesn't matter.
The question is, was he allowed out of his cell to access his legal materials?
That's not what I asked.
Right, the question you asked,
She just gave him the question that he needed, and he was like, no, that's not it.
objection is sustained. If you'd like to ask the question suggested by Attorney Opera, that would be permissible by the court.
Never.
No, I would want to ask my own question.
I'm gonna die. I'm gonna hang myself, please.
Able to come out of my cell on the keep separate protocol.
Judge, I would prefer not to answer that.
Yeah.
Beyond the scope of the inquiry right now, the jail administrator need not answer that question.
Nope, he doesn't.
The basis why, Your Honor.
It's beyond the scope.
What does that mean? I do not understand.
That's on you, bro. She doesn't have to explain what does that mean. It's simply on you for not wanting to have representation. So, tough nuts.
Mr. Brooks, do you have any other questions?
I do not understand what beyond the scope means.
One last
That doesn't
time,
matter.
sir. Do
That's
you
not
have
a
any other
question.
questions?
That was a direct question.
All right, I'm going to mute him because he's now not being responsive to the question that I asked, and that is, does he have any questions to ask the jail administrator within the scope that I've previously outlined? Any follow-up from the state? No. All right, thank you. You may step down.
The state got it so easy. I mean, I could have gone there
else from
and
the state, Your
trial to be one-on-one with
Mr.
Darrell,
Brooks, do
and
you have
I would have
anything
won.
else
I'm sure I
related
would
to
have
the
get the
inmate
jury to
communication
agree
form
with me.
dated September 28 of 2022, since we obviously included that after we took up the other issue.
Yeah, I'm still.
Yeah, he's
I
a
don't
dumb.
understand how
He's a dumb guy.
any questions that I was asking are not allowed to be answered.
And keep in mind, I'm foreign. I'm not American. I don't even understand how that works. But I will take the time to read all these books that they give me, like at least the statues, because there's gonna be a part coming up about the statues and all that stuff that it hurts me. It hurts me to, but we'll see it.
Testimony or evidence you want to present as it relates to the inmate communication form dated September 28 of 2022.
Yeah, I would like to. Is it a way that we can verify the standards of the Keep Separate protocol?
Why?
Mr. Brooks?
Doesn't matter.
Mr. Brooks, please listen very carefully. There's a question I'm asking you is, do you have any other evidence? Document? All right, then I'll. All right, I'm going to mute him once again. He is not answering very clear questions.
Where's my picture?
Mr. Brooks is holding up the objection. That we're not taking testimony at this time, so the court does not feel compelled to acknowledge that.
Yeah,
any
and he was
further,
told from the beginning, we
other
are
than to
not
say
gonna explain
the fact
stuff
that
to
he's
you, dude.
objecting
You are
is
on your own.
for the
You don't
record.
want lawyers?
Mr. Brooks, I'm going
That's
to
fine.
unmute you because it is your motion to adjourn these proceedings.
But
And as
it's
such,
on
I will
you.
give you the first opportunity to make your specific request known to the court. I then will give the state an opportunity, and then I'll decide the motion. All right, Mr. Brooks, what is your argument as it relates to the motion to adjourn?
Well, I'm not arguing.
That thing, he also doesn't understand what arguing mean. Arguing, it doesn't mean fighting. Arguing doesn't mean what you think it means. Arguing means
pretty clear why
stating something.
an adjournment. I don't think I need to argue anything. I don't think I need to provide anything more. If it's
I don't have to do anything more,
it's clear,
Your Honor.
It's clear to me that the wrong person was testifying. She said that she was not present for the said COVID test. To her knowledge, no way to say for sure why I wasn't provided with the test that I should have been provided with if that becomes an issue. Honestly, Your Honor, I'm powering my way through this hearing. I feel like total crap, to be honest with you.
You are total crap.
I don't feel good at all. My
I'm sorry.
reasoning for raising this issue, like I said, was strictly a health and safety thing. It didn't have anything to do with trial prep. It didn't have anything to do with.
I think that's one of the largest angles I can decide where he honestly believes he's doing anything here, or if he knew is he trying to acting play. I think the main issue here is this. The main issue with this guy is that he knows. He knows that he's done. He knows that he did it. He knows that they have evidence, they have videos, all these things. He knows that. So I think the only way that I believe he had any chance to fight this was to make the court, make the state, make everyone, force them to make a mistake. And if they made that mistake, then he will go free, the mistrial or whatever. I don't think that would have happened anyway, but that's what he want. That's what he aimed to. All this I don't understand, I don't consent. Can you explain me this? Because I believe I will need someone to explain this to me. That if the judge is helping him in any way, that could be like a no-no for the judge. And that could be seen as bad malpractice. And that's how he wanted to get out.
Access to anything. It was strictly because, like I stated before on record, I've never had this issue come up for me. Like I stated before on the record, I've had people that I know, loved ones, close people, pass away from this COVID disease.
Okay.
Frankly, I'm terrified because I have yet to even...
I'm terrified, but I don't want to do a rapid test right now. That doesn't add up, dude. That doesn't
say whether I'm positive or negative. I am fully vaccinated.
Plus, you're vaccinated. You don't have to worry about it.
Tested positive for COVID, and frankly, to even be told that it's a possibility that I could have COVID, it makes me very afraid. And my intention was to at least be able to get the results back, so that I know.
Fair, it'll buy him the time, but at the same time, he wasn't caring enough to know the rules. He might be breaking. That will be the hurt. And just, yeah, I think he was just plotting to play dumb.
That was my intention, and not.
Yeah, someone terrified would have been like, oh God, we have the test right now. Like, yeah, let's go, let's do it. I want to know if I got to protect myself. No, I don't know. I start getting some medicine or whatever, but nah.
Wanting to infect anyone else or put anyone else in jeopardy, and also doing the things that I may need to do if I'm found to be positive, doing the things that I need to do to be healthy.
Why not start doing it right now?
That's why I raised the issue, Your Honor.
Well, Judge, I'm glad to hear Mr. Brooks say this is not a trial prep issue and merely his concern for the health and safety of
she loves that.
The court has already made the record that we can safely accommodate Mr. Brooks in this courtroom without risking the health and safety of other individuals, even if he should have positive results.
Hey, Miss Mandy. How are you?
We feel comfortable with that as well. The jail can still move him.
We're suffering here. We're trying to. We're trying to. All right. We're trying to see what the end goal of Mr. Brooks was here, or the alleged defendant, because I don't see this. I don't see his end game. It doesn't work.
Respond to his needs properly. So if it's merely a health and
I'm
safety
doing good,
issue,
thank you.
I believe we've easily overcome that,
How are you?
Your Honor. I don't put much credibility in the comments of Mr. Brooks here. As Detective Regland just advised me, he made 17 attempts for phone calls
17
this morning alone. So his statement to the court that he was worried about being able to call his family, I think, really is questionable. So I would ask you to deny the motion to adjourn because of the COVID protocol, and to the extent that there was a prior motion to adjourn because of a keep separate order, that also is inappropriate at this time. Thank you.
He doesn't know what alleged means.
Your Honor, may I state something for the record?
You may briefly respond. Go ahead.
Oh, I'm sorry. I think Nipot got you with the.
Sitting right behind the prosecutor's desk right
I'm sorry. Let me fix that. Actually, I'm sorry, Miss Mandy. Nightbot. I'm new with this bot, so I need to. I'm sorry. I'll change that.
I can't speak to that situation. It's not my business, frankly. But he wasn't present in the courtroom, and I think that has relevancy due to.
Yeah, the Nightbot doesn't like you using all caps.
Infect anyone else or put anyone else at risk. Let
me excess caps disable. There you go. Now you can use all the caps and symbols that you
Not going
want.
to adjourn this
I
trial.
apologize for that.
I'd also put on the record that he has not been denied access to materials. He has full access, even with this protocol. He has had access even to the phone. He would not answer the court's question directly about whether he would take a rapid test. To me, his credibility is at issue with that. If he were truly concerned about his own health and safety, he would want to know immediately. And he repeatedly would not answer that question and instead wanted to debate about what test was provided to him and why perhaps it was not. All right, you're interrupting me. I'm going to mute you.
I love when she mutes him.
So
it just gives me joy.
Here today, I agree with the state's assessment. This is nothing more than a delay tactic, given the information that this court, and once again on the record before me, there is nothing to suggest that he is actively being impacted by COVID-19. I know Mr. Brooks appears to be talking to someone and hand gesturing. Unless he writes a note that he has a topic he wants to address for me at this moment, I'm going to assume he's just directing his commentary to the bailiff that's in there. I will unmute him momentarily to ask him.
No, don't unmute. We don't need him. Just leave him muted for the whole trial. That's going to be better for us.
On his list. All right, Mr. Brooks, are there any additional issues that you believe need to be addressed? Mr. Brooks, can you hear me? Mr. Brooks?
What?
Do you have any additional issues to what I've already set forth and the state's added to the list of what I will call generally housekeeping issues, other than perhaps the motion for reconsideration? That's not housekeeping, but.
I was having a side conversation with the bailiff about something.
Yeah, I would also love that, if you could have what he said before.
It's my understanding that the bailiffs would not be having a conversation back with you or at you during court proceedings. I'll have to confirm or deny that with them.
Yeah.
Becky, if you could talk to the bailiff, please.
He was asking how to pronounce a word.
All right, so it's my understanding you were asking the deputy.
Yeah, you can you imagine my memories as the bailiff of the Darrell Brooks trial?
A word. Did he provide a response back to you, Mr. Brooks?
A kind of a response.
What kind of
Did you hear
response?
that?
It was kind of a response.
Did he provide a response verbally?
I'd rather not say, Your Honor.
I'd rather not say.
I'll have to get clarification from the bailiff later on. He's coming in here. Okay, thank you.
Yeah.
He asked me to pronounce what the pronunciation of a word was, and he spelled it to me. I said, I don't know what that is.
Okay, thank you. Mr. Brooks, I'd like to invite you back into the courtroom if you
Here we
so
go.
choose.
Back
Would you
again.
like to come back to this courtroom, sir?
No.
I never stated that I wanted to be removed in the first.
It's a yes or no question, my
to you,
guy.
sir, is would you like to come
Yes,
back over
no.
to this courtroom?
I respectfully never consented to being removed.
What does
We'll
that
ask
mean?
one last time before I consider his answer to be non-responsive. Would you like to come back over to this courtroom, sir?
That is not a non-responsive answer, Your Honor.
So the
It's a non-responsive answer because it's a yes or no question. So if you don't answer one of those, then you're not. It's not a.
The answers provided were not responsive to the question that I asked, and therefore he'll remain in the other courtroom. The record speaks for itself, sir.
Your Honor, I'm very tired, so.
I'm very tired.
Mr. Brooks, we're gonna keep.
Doesn't
Mr.
matter.
Brooks, we're gonna keep
No one
going.
cares.
So Please don't interrupt so that we can do this as quickly as possible so you can go back to your cell.
I was just merely trying to make the record, which you have denied me to do. As I stated at the beginning of the hearing, I would like to make an offer for my appeal.
No one cares.
I've stated that on the record numerous of times yesterday and today as well, and I haven't been awarded that right to do so.
That is not within my authority.
No.
That is a reviewing court would decide that, whether that be the Court of Appeals, the Supreme Court, or otherwise.
Yeah.
So that's why I'm non-responsive to that, is because there's nothing for me to do as it relates to that based upon the request that you have made. So with that, Mr. Brooks,
Can you verify that by sworn
Mr. Brooks, I'm
affidavit
gonna
that I
mute you,
cannot make?
okay?
Yeah.
Mr. Brooks,
Shut up.
you've now earned the mute button once again.
You earned the
You
mute
have a
button.
total number of
I
convictions from
I
Mr.
love how
Brooks,
she
and
said
the
it.
number that
You earned it.
asked be the number he
Congratulations,
answered the
my
question
guy.
to. Should he testify, have you been convicted of a crime, and if so, how many?
Yes, Your Honor, we believe the answer would be 12, with the first 3 coming from the state of Nevada, and then the remaining convictions all in the state of Wisconsin, mostly from Milwaukee County, but also 1 conviction from Wood County and 1 conviction from Manitowoc County.
So, Mr. Brooks, not going to address this today. The state's putting you on notice that if you elect to testify in this case, they will be seeking.
He's lying there because he's lying. First of all, straight up, he's straight up lying. But also, it's because he wants to convey that he's really tired. That he's really he cannot stand still in order for him to be there. You know? That's why.
A ruling on whether you may be asked, have you been convicted of a crime? And then the follow-up, if that answer is yes, is how many times?
I do want to just say one thing, and not to that. I just wanted to say one thing on the record, that I did inform the bailiffs that I did not wish to accept the paperwork that was brought off by the detective.
Why
I don't know
not?
his name, so I don't want to be disrespectful. And
I don't want to be
The
disrespectful.
information I have is Detective Ragland did personally serve you with that. He'll file the appropriate service if need be. Whether you take that paperwork with you or not back to your cell is your decision, sir.
well, I just wanted to put that on record that I'm not accepting the paperwork.
Your objection to the paperwork is noted.
It doesn't matter if you don't accept
I
it.
did have another question about, in the event Mr. Brooks has forfeited his right to be present in the courtroom and has been removed, how will cross-examination proceed?
Well, I've reviewed
Better when he
the
leans in
case
and shouts
law,
and tries to stare
and
down the judge, but through the screen and not looking at the
one
camera,
of the
then he just
possibilities is that he forfeit his right to cross-examine. If he's not in this courtroom, it's can be challenging to facilitate cross-exam. And if he's able to abide by the rules of decorum and civility, and whether it be even objections, right, or cross-exam, I mean, that can be shut down, for lack of a better way of saying it.
I understand that, and I know this court has been more than patient. We would just
more than patient.
ask the court for its continued patience. We want Mr. Brooks to be able to confront and cross-examine his accusers. He has demonstrated on the 2 occasions so far that we've had testimony, he's quite efficient at asking questions.
Yeah.
And
He just plays dumb.
If he is calm and cooperating and not rude and disrespectful,
That's not gonna happen.
We believe he should be given the opportunity after every witness to cross-examine. Even if he's in the other courtroom, we should at least make that inquiry, unless it becomes absolutely not an option because of his conduct.
I would agree.
Okay, thank you.
So just so I understand, 'cause I don't.
I don't.
How can I forfeit my right to actively and effectively participate in a trial if I have to constantly be put in a separate location? How will I be able to see everything that is going on in the courtroom?
Well, don't make a mess. That's the thing. If you don't make a mess, no one's gonna care. You're gonna stay there. It's as easy as that.
To effectively put on a proper defense.
Mr. Brooks, I direct your attention to Illinois versus Allen. That's the case that I've been relying upon regarding your removal. That's found at 90 Supreme Court 1057 from 1970.
That's all I understand. The Supreme Court, the federal court.
That is the Supreme Court of the United States of America.
Of America.
Is that federal?
That is the Supreme Court of the United States of America, sir.
I'm just really seeking to understand, Your Honor.
Sir, that is the Supreme.
So
Sir, I've answered the question.
Yeah.
you have, but I still don't understand.
You have, but I don't understand. So let me.
Sir,
wait. He's like, okay, I answer a question, and then you ask I ask the question, you answer the question, but I don't understand it. So let me ask it again, even though you already answered it.
Explain the law to you. I cannot do that.
I'm not asking you to.
Then what are you asking?
I'm asking, is that a federal court?
All right, I'm going to move on to the next topic.
I still don't understand.
Doesn't matter.
How am I expected to do everything in a legal basis, in a legal manner and everything when I keep informing you, Your Honor, on record, in open court, that I do not understand?
Because it doesn't matter if you understand or not.
I have yet to understand the true nature and cause of the charges against me, which I don't understand.
Doesn't
There's
matter.
so many things that I do not understand that I keep explaining to you, Your Honor, that
Mr.
See,
Brooks,
I'm
gonna refer
telling
back
you.
To document number
I'm telling you, I'm
244, which is
explaining
the
to
waiver
you
of
why
right
you are
to
wrong.
attorney form that you willingly, knowingly, intelligently, from my perspective, understandingly filled out. Let me make my ruling.
I do
sir.
not understand.
Do not interrupt, or you will be muted. All right. So from my perspective, sir, we clearly went through not only this form, but really the topics that are referenced in this form, the advantages of having an attorney represent you, the disadvantages of representing yourself.
He's not even paying attention. He just got up and is walking about. It doesn't matter.
Honored your request to represent yourself, and it's a bit disingenuous to now say you don't understand what you did. So we're going to keep going. I need to go through some other topics. You are not muted, but there's nothing for us to discuss at the moment.
I'm not trying to discuss anything. I was
All right,
just
then shut up.
letting you make the record, which I haven't been afforded the opportunity to make the record when I offered for my appeal.
You don't need to make any
Again,
record.
I do not understand, and Your Honor, I think it's very unfair for you to say that you're finding that I understand. How can you tell me what I understand and what I don't understand? I've clearly made that very, very clear that I
Very clear.
And the same document that you referred to that I filled out specifically crossed out the word understand. Why did I do it like that? Because I do
All right,
not
Mr. Brooks,
understand.
I'm going to mute you because we're
Yeah,
off topic.
I'm gonna.
We've gone over this
I don't
time and
care
time
for this.
again.
No, I did that earlier, but I was printing a bunch of things and then.
So put on the record, Madam Clerk, what you believe you provided to Mr. Brooks already. All right, so he was provided with the packet of preliminary jury instructions. So let me I just need to add a line in here. I'll print this here for the state, and I'll print it in the other courtroom. There's a printer over there as soon as I do that.
Right, we are almost there. We're almost. We only have in 10 minutes. We'll be in the first day of trial. We want to be in the actual proper trial. So let's go. We're almost done with the pre-trial.
At least it was put in front of him on the table.
By the way, if you guys know
He accepts
any
it or not, I
Discords, any
understand, but Mr.
friends
Brooks,
that
was that piece
you
of
think that will
paper,
enjoy
placed
this
in front of you?
content, like me just rambling over and getting upset at Darrell Brooks, please share it. Tell people to come by. Maybe they'll have fun too.
On the table in front of Mr. Brooks, and he
Thank you.
took it off the table and set it on the floor next to him. It appeared.
All right, thank you for making that.
Or consent to that. I would
Mr.
not
Brooks.
accept any more paperwork.
All right, Mr. Brooks, you made clear you're not going to accept paperwork, but we have an obligation, whether you make that statement or not, to provide you with copies of everything the court is addressing with the parties.
Yeah.
So
We have
what
to.
you do with them is up to you. So your objection is noted.
You may be aware that certain things are not going to be awarded, especially when it comes to fairness.
Mr. Brooks, I need to move on to the jury instructions.
Yeah,
Are
that
you
doesn't
willing
matter.
to participate in this process right now?
No, I am
No.
not. And I don't give consent
No.
without me being present in the courtroom, like I said before I was brought over here.
Would you like to come back over?
So why would you ask me that? Why would you ask me that?
Again, you just have to answer yes, dude. This is what you want. You want to come back. She's telling you, you want to come back? And you just be like, yeah, I want. And you're back.
Mr. Brooks, you were put over in that courtroom because of your disruptive behavior. If you can agree to abide by the rules of decorum and courtesy,
I'm not gonna
then
agree to
I will
anything.
bring you back over here at any point in time.
I'm
Did
not
you
gonna
hear me
agree to
advise you
anything.
of that, sir?
No, I did not.
I did not.
You're advised, sir, that if you want to come back to this courtroom, you may make a request at any point in time.
Any
If you
point.
come back, the court expects you
But-
to follow the rules of decorum and courtesy that you've previously been advised about.
So is how it's gonna be the whole trial? Every time I seek to understand
Mr. Brooks,
something
I'm
and ask a
offering you the
question?
opportunity to come back to this courtroom to participate
I
here.
don't wanna go over there and then essentially have to come back right over here because when I ask something that I don't understand, it's being looked at as me intentionally trying to disrupt the court.
Mr. Brooks, I'm asking you a question.
Yeah. Yes or no?
Please answer. Would
Yes.
you,
No, it doesn't matter. Yes or no?
would you like to come back to the main courtroom right now? Yes or no?
Yes or no?
I asked you a question too, Your Honor. I've asked.
All right,
is
I'm
this
going
gonna
to
be
mute
how it's
him.
gonna go?
I'm going to make a
See ya.
finding that his decision to not answer the court with a yes or no
Yes or no.
is non-responsive. Attorney Opper, will you or Attorney Basie be addressing the preliminary jury instructions?
I will, Your Honor.
All right, do you acknowledge receipt of those?
Yes.
All right, I will put on the record that the 68 pages were also provided to
It's just
Mr.
like-
Brooks. What I intend to do is to read the following. This court is tasked with ensuring the orderly administration of the case. My job includes making sure that Mr. Brooks's rights are protected, making sure that the state and the defendant can present their respective cases in a coherent and orderly fashion, and that victims, witnesses, and the public are appropriately treated in the courtroom. There's a second part to the proposal that if at the time the court reads the preliminary jury instructions, Mr. Brooks is not in the courtroom, then to add the second where it says to be read only, that says at the moment Mr. Brooks is appearing from another courtroom, this must not influence your verdict in any manner. I understand Mr. Brooks is objecting. I'll give him an opportunity to make any statements regarding that. On the
Right.
record, I'll ask the state first whether there's any objection to inserting this in that location.
No objection to it. Inserting that, I would just note that in all of the jury instructions, I don't think we've ever mentioned Mr. Brooks by name. I think it's always been the defendant. I don't know if the court wants to be consistent. That was my only comment.
I think it would be good to be consistent. Mr. Brooks, I'm going to unmute you so that you can put the basis for your objection on the record.
Here we go.
First of all, I'd like to state for the record that I'm pro per, not pro se.
Doesn't matter.
And what you just said about keeping it consistent,
It's the same thing.
then it's been in this form ever since it was brought up. So why start to change the language and logistics of it now at this point to constitute me being in a separate location?
I'll be back.
If it's going to be consistent, then it should be consistently as it was constructed. Nothing should be changed.
Sir, do you have, want to make any statement related to the jury instructions that I've provided to you, whether you object, consent, agree, or otherwise?
No, I don't consent. I do not.
All right, your lack of, sorry, go ahead.
I just stated the reasons why.
Is that to
You
the
just
whole?
said so yourself. You just said so yourself. They need to be consistent. So why does anything need to be changed at this point? I also want to make
Small d.
state this on the record. You just referenced wanting to protect my rights, correct?
You have the language in front of you, sir.
Well, you just said on record that you will want to preserve my rights.
Mr. Brooks, you have the language of the jury instruction immediately on the screen in front of you. Do you have a question or a position on whether that's included?
I was getting to that. You did not let me finish. So it's not a question. Like I said, I was stating for the record. Part of protecting my rights would be the ability for me to inform the jury of the truth, their rights, and their duties under the First and Sixth Amendment.
Do you have a jury instruction that you would like me to read that would state that? Have you drafted anything, sir?
I wouldn't need to draft anything if it's already in the Constitution. I should be able to be afforded for those rights to be protected under the First and Sixth Amendment.
I'm sorry, I mistook what you were saying. I thought you wanted me to add a jury instruction, a written jury instruction, so that I would read something to the jurors. Am I mistaken on that?
It's clear that you're not grasping quite what I mean by what I'm saying. How about I draft something up and get it to you as soon as possible? Would that be sufficient for Your Honor?
If you draft something and submit it, and we have it by tomorrow morning, I can address that on the record, and whether it will be included or not. So yes, that's acceptable.
For the record, also may I state, it is going back to the language that says pro se. Can that be changed to pro per?
That is a phrase that has meaning in Wisconsin law. It is accurate, and so your request to change it to pro per is denied.
Okay, how is it accurate?
That's my ruling, sir.
I don't understand, so I'm just seeking.
Mr. Brooks, that's my ruling. I need to finalize these, Mr. Brooks, I need to finalize these instructions.
Part of my rights being protected would be to be able to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys. That's another right that's not being protected.
If you're requesting that that language be included, the request is denied.
And is that a judicial determination that I won't have?
I do not believe that accurately states.
That right preserved?
I do not believe that that statement accurately reflects the law. All right, so we'll make the, Mr. Brooks, I'm moving on.
Can you show me by?
Mr. Brooks, I'm gonna mute you. Does the state approve of the jury instructions?
Yes.
All right, Mr. Brooks, I'm gonna ask
sorry.
you, that question. Actually, two, do you have
I'm just
any?
doing laundry, so.
And you're raising the objection. Hold on. You're raising the objection sign. It's noted for the record.
Use the sun.
Continue doing it, that's the only way I can.
No, I know, and I'm making a record of it, sir. But we're at the point in time, do you have any requests for edits? Let me
yeah.
finish the question, sir. You're in.
Yeah, that's the other thing. He doesn't. He wants people. We're gonna see it with a witness soon. That when she says that she got up, and he was like, "No, my definition of that is this." Hello, Deacon.
Interrupt. All right, I'm gonna have to mute him again so that.
Hey,
I can get my
oh, holy
question out.
Deacon!
Mr. Brooks,
Wow.
my question to you.
Thank you for the
Do you
$50.
have any other
Oh,
requests as
Jesus.
it relates to edits, other instructions?
Wow.
Or
Thank you. Thank you so much.
corrections of the 69-page instructions that you
Wow.
provided with?
Thank you. Thank you.
And the
Wow.
added
cannot-
instruction that you were able to see on the
Cannot
screen.
thank you enough for that. I really.
Go ahead, you are.
I really needed that.
I wasn't looking at anything on the screen.
Oh yeah, this is the perfect nonsense. I love this
On the
nonsense.
record, and you just confirmed on the record that I will be able to draft something that will get it to you. So why can't I address anything in that draft?
Anything.
Sir, I am addressing what we have now. So I will ask you now at this point, since you've not answered my
All right.
question.
I also missed. Thank you for your $50 for surviving day one of the Brooks Scattered universe. But I can look away either. I also hope this can help with some of the unexpected events that we'll have to handle. Yeah. Thank you. Thank you
And
so
I
much.
understand that you're going to
I
draft something.
really,
Other than
really,
that,
truly
do you have
appreciate
any other
it.
edits, corrections, or requests for inclusion at this time related to these jury instructions?
I really needed that help, and I thank you so much.
I'll be able to inform the jury of the truth.
Oh yeah, this is the best part of watching this now. Is that
Sir,
we know that
I
he
have
gets.
provided an answer to that. All right, I'm gonna object.
We know that
I'm
he
going
gets
to
so
not object. I'm gonna mute him again.
destroyed
I have
in this that I
told
love
you
it.
You will have the opportunity to draft a proposed jury
Okay, 1 minute,
instruction. for
1 minute,
inclusion
and
with
we
this
are in day
packet.
one of the trial.
At this
Let's
point,
go.
he
Let the
hasn't
fun
answered
begin.
my question directly, and by his responses, I will make a finding that he's not responding.
Nope.
It's a non-response type of answer. As to what we specifically have before us today, do you have any objection? Okay?
What prompted the change now, all of a sudden?
Because this is the time in the proceedings for the court to finalize those
Yeah,
and to
we're
address any
moving.
modifications.
We're moving on.
That's standard protocol.
So I'm still.
All right, your objection is noted, sir. I am approving everything that's in there. Mr. Brooks will still have an opportunity to submit any additional proposed
I'll be over
instructions
here
tomorrow morning, but at
putting
least we
hangers
have,
on my clothes, if you don't mind.
this
I'm
packet
sorry.
that's been
I have to do both.
approved.
It's my only day that I can do laundry. Oh, wait. I was watching this. Let's go back to the beginning. Here you go.
Darrell
Day
Brooks
one.
appears
The
in
big
person
three
in custody.
boxes.
I'd also like
They're
the
gonna
record to
be-
reflect that he is appearing in jail attire today.
And
He's
look,
also
here's
wearing
Rory.
a mask.
Come on, Rory. Rory's here to visit us.
Name and would like the
Hello,
opportunity
lady. Hello,
to state
pretty
that
girl.
I'm here
Look at
concerning
this
this
face.
matter
Look at this little
as a
puppy.
third-party
Look at
intervener
her.
in this
Hello.
matter, appearing as
Say hello.
authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights if I may.
Mr. Brooks, you just interrupted me within
First
a
day,
minute
first
of us starting
interruption.
this case here today. I'm asking you to respectfully not.
I wonder who gave him that script. I always wonder who was the one that was like, you need to say this, bro. This is gonna help you. This is gonna block anything that they can say against you.
Interrupt me, that's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record that
Mr.
I'm not
Brooks,
identified by
it
the name
wasn't
that
the
you called me
proper
by, that's
time to
all.
do that. That's now the third interruption.
With all due respect, Your Honor,
Mr. Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done.
But it is my
I have a
right
number
to-
of documents
it is
that I
my
need
right
to discuss this
it is
morning.
my right to,
Mr. Brooks, you do not have a right to interrupt the court.
No, it
I
was-
will
that
remind
was
you
not
once
my
again
intention.
of the Supreme Court rule. I
That
checked,
was
I
not my
verified,
intention.
It
I
is.
accept it in return for
Mr.
value.
Brooks, that's
Your
yet
Honor.
another interruption. Let me get through this, please.
I just want, for the
You will
record,
have an opportunity when I give you an
I want-
opportunity.
I heard
No
something
one
that
else
was
is
boyfriend
speaking
of
at the
Dawn's.
moment but me. You
maybe.
need to stop interrupting.
I don't identify by that name.
Mr. Brooks, I am going to keep going. You are warned. You need to follow the standards of courtesy and decorum for the courts of Wisconsin. Chapter 62, that's
Your
another
Honor.
interruption.
I intend to follow decorum.
This court comes with a history
I
of Mr.
intend to,
Brooks
just not right
interrupting
now.
I am
object-
well
I
aware
object
that's another
respectfully, Your Honor.
interruption. I'm
I-
well
I
aware.
object
Stop
respectfully, which I
talking.
have the right to do.
I'm well aware,
And
Mr. Brooks,
I
that
have
you
not
object to the
intended to
name that
cause any,
has
disruption.
identified on the information and all documents in
want it
this
noted
case.
for the record
Your
that I
objection
did
is
not
noted. It
identify
does
by
not
that
need to be
name.
repeated. I will make a record right now. The
May I
court
have the
notes
opportunity to
a
preserve my
continuing
rights, Your
objection
Honor?
by Mr. Brooks of his name.
Yeah, that's a lot of-
that he objects to being here.
Even the
I
judge,
know
the
he's
judge is
filed
not
a number
old.
of
She must be in like
documents
what? She's
previously
I never
related
objected
to
to
that.
being
Those
here. I just-
documents
40
are
stuff
of
maybe
record.
at-
There's
at
another
most?
document that's filed. At least 2 more interruptions just now. I believe I'm up to 8. Mr. Brooks, you're advised that continued interruptions will result in you forfeiting your right to be present in this courtroom, where you'll be taken to the courtroom next door to appear by video and audio
I don't
means to
consent
participate.
being removed from the courtroom, Your Honor.
That's another
And
interruption.
you haven't shown me any lawful case law that I can be removed from the
Mr.
court
Brooks?
proceedings in a trial and forced under coercion and duress to appear in the
They can never say coercion. Or is it really say like that? Coercion? I always be substitutes are always like that. They don't know how to pronounce words.
trial that I am needed, that I'm trying to express that I have the right to
Mr.
be
Brooks, there's a
present for.
proper manner in which you raise objections. You have not followed that proper procedure. You are unable or unwilling to abide by simple rules of civility.
You haven't
You
given me the
interrupt,
chance to
you don't wait for
state my
anyone
name.
to finish, and it will result with you being removed from the courtroom. So you are
Coercion.
once again
Coercion.
reminded of that. I would like you to appear in street clothes. It is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so.
You being in a suit and a tie or other street clothing, I think also lends to the dignity of the
Yeah,
proceedings.
you look
This
better.
is a
Everyone,
trial.
look, even Darrell, he looks.
Again, it is
Everyone
your
looks
choice.
better in a
Are
suit.
you willing to go back to your cell and
This
be
is my
dressed
jacket.
in the street clothes that you
I
previously
use
appeared
it.
in?
I'm gonna use it tomorrow, maybe.
With all due respect,
But everyone looks better in a blazer or a jacket.
not agree with
It
that assessment
immediately
whatsoever.
push you
Mr. Brooks,
forward.
did you hear the question that I asked you?
and I respectfully keep the position that I just put on the record.
Mr. Brooks, I will ask you again. Are
Again.
you willing to go back to your cell or into the jail and put on street
I do
clothes?
not consent or agree to anything that you just stated, Your Honor.
Let the record be very clear that Mr. Brooks was given multiple opportunities to answer that question.
And I
And go
answered
back, Mr. Brooks, that's yet another interruption. You refuse to
it's
answer
not that
my
you answer
question
it.
about
Did I
whether
refuse?
you would
Is that you?
go
You just
back
didn't
to the
like to
jail.
answer
That's
it.
another interruption.
That's not how it works,
So
dude.
based on his refusal and his
I did
choice
not
to come,
refuse.
that's
I did
another
not consent
interruption.
to saying
Based
a
upon his
refusal. I answered.
failure to answer my question directly, I will
I
take
did
that
not
as
refuse.
a non-response, but he came to court
That was
here
not a
today. That's another
non-response, Your Honor.
interruption. No one has forced him to come
I
to
did not
jail in
consent
those
to that.
clothes. This court is encouraging him not to, but it is his choice to not do that, and we will proceed accordingly.
Okay, I'm just
We're on
gonna
the
go
record
hang
now,
this
challenge
up
the
outside. I'll be
subject matter jurisdiction.
No, you
3
may not,
minutes at
sir.
most,
You need
and
to
then
file
I'm
a
gonna be
motion
ready
in order
to
to
go.
do that.
So
Mr.
the
Brooks?
motions I filed haven't even been responded to. I gave.
Mr. Brooks, you're interrupting me
No,
yet
you
again.
just weren't speaking,
All right,
so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the
I
other
don't
courtroom.
consent to that.
I have
I
had
am under
a
duress
dozen or
by
more
having
interruptions.
shock- I
We'll
have
be
shock-
off the record while we
shocks on
do
my
that.
ankle.
Thank you,
I don't
everyone.
agree to a stop. Well, I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I did not. I have a right to be present for trial.
All right, we are back on the record. Appearances are as they were before. I need to make a record that at 8:42 a.m., this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. On every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case. At the moment, he is muted because of the way that he was removed from the courtroom and his conduct since. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting. That
Okay, oh
at one
God,
point
okay,
he
we
took
are in
off a
this
shoe,
space.
And it appeared to the deputies that he was going to throw the shoe.
Why would you take off
can
your
see
shirt,
that
dude?
he
You're
is
skinny.
seated
I
with
mean, I'm
his
skinny,
back,
but I don't take my
to the
shirt
court
off.
or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items if at any point in time he wants to come back, and he is willing to promise that he will abide by the rules of courtesy and decorum and be civil and show respect for the court proceedings.
He's not gonna
for
show
all
respect.
individuals
Look, he's like,
in this
look at this.
courtroom,
Look at this.
including
I got a tiny
Mr.
bruise in
Brooks
my
himself,
fingernail and a bruise on my
then
arm.
he may come back
Why?
in.
Because I resisted.
It's also my intention to give him
No, I don't
that
think this is in front of the
opportunity
jury.
at each new stage.
Look,
Since
look at
going
me.
back on
Look at
the
this. I had a
record,
little cut.
Mr. Brooks still appears to be communicating.
Oh, this was in
or
front of the
is
jury.
attempting to communicate with someone else. I can see his hands moving. He has turned his back. I can tell that he can hear me because he shakes his head no. At a point in time where it's clear he's disagreeing with something that I've said, I believe he can adequately hear, and that his statement earlier in the proceedings that he's hard of hearing is simply another tactic of
Yeah,
his
that's
to disrupt,
100% another
to delay,
tactic.
to create chaos.
I did want to address a topic that's maybe not been raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks to proceed to trial. The court is well aware that the district attorney has an obligation and a duty to raise any concerns as to the competency of any defendant to proceed to trial, and the court itself, if it had a concern as to the competency of any defendant to proceed, can request an evaluation that's pursuant to 971.14. At no time has anyone involved in this case had a competency concern.
Yeah.
You've made a
The
record
headphone
with
thing is
attorney
just,
Terry
it's a sham.
previously
It's a
as to
tactic.
Mr.
Maybe
Brooks' ability to
he has a
understand what's
little
going
bit,
on as
but
to
not
some
enough
of the
to
discussions
cause
he's had
anything.
with other individuals. He makes multiple phone calls every day, and they are all listened to. He knows
This as well. I mean, she knows that they listen to the calls.
the issues in the courtroom. He discusses what happened in court that day with these individuals he's speaking to. I am thoroughly convinced, Your Honor, that Mr. Brooks is 100% competent to proceed to trial, that his mental capacity is not reduced in any fashion.
In any way.
Anybody that thinks otherwise has no involvement with this case. He drafted this himself in his jail cell last night, I presume. Maybe it was this morning. He has continued with the same objections that he has been making.
That's the weird thing as well. He got rid of the shirt, but he still has the face mask. Why? I don't get that.
Repeatedly in this case, so he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this form notarized by a
the
jail
notarized thing.
employee so that it is a signed and sworn affidavit. Mr. Brooks' antics, which is all they are, clearly speak for themselves. This is not his inability to understand what's going on by any stretch.
Thank you, Attorney Opper, and I do appreciate you raising that with the court. I would also add to what you have just stated. This court has read through not one, not two, not three, but 4 evaluations related to the special plea that was withdrawn. And those are very recent evaluations where the examiners met face-to-face in the jail or in an appropriate visitation room with Mr. Brooks, either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted by those examiners as well. This behavior is frankly more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from a mental disease or defect that would qualify for a special plea. We are at the stage where we are at with Mr. Brooks muted in another courtroom because of his defiant actions. No one else. And I appreciate everyone's patience as the court goes through these things, frankly, gives Mr. Brooks time after time after time to conform his conduct to the clear expectations, but he just simply flat out refuses to do so. So what I'd like to do is finish with the approval of the jury instructions, the preliminary jury instructions. I will make a record that Mr. Brooks did not file anything in writing regarding a proposed jury instruction as he was advised to do yesterday. If he wanted me to consider something, I believe we had a very clear discussion on the record about that. He was given a full copy of the draft preliminary jury instructions. He was part of that conference that we held yesterday. Has the state had an opportunity to now review the preliminary jury instructions with all the changes that were made yesterday?
We have.
Any objection to those?
No.
All right. Mr. Brooks, I'm going to unmute and ask if you have any objection to the jury instructions that were provided to you yesterday. I'm specifically looking for a yes or no answer, and I'll address further if need be based upon that yes or no. The microphone is unmuted.
All right, yes or no? Can he do a yes or no?
Actually, we'll need to turn him up. It's not very loud on our end. Mr. Brooks, did you say one more time? Yeah, but you know what? Your volume's a little low, so we're gonna
you're really low.
Have them adjusted over there and in here. So give us a second. Mr. Brooks? Try again.
Am I on the record?
You are on the record. Ooh, that's loud now. We'll turn ours down.
That's really
Mr.
loud
Brooks,
now.
do you, yes or no question, do you have any objection to the preliminary jury instructions that were provided to you yesterday?
Of course he's gonna have an objection.
Go ahead, answer, please. All right, your objection is noted for the record, and I'm just putting the mute back on.
I'm just muting
Provided
you
that
again. It doesn't
objection
matter.
Without any legal basis. I muted him just so I could ask this question. I'll be right with you, Captain. Mr. Brooks, do you have a legal basis to object to those preliminary jury instructions? I'm unmuting you.
Yeah, I think this is the only time that it will be like, okay, you know what? You don't have the right to be here at the main courtroom, but we're having technical difficulties, so we're gonna bring you back. I think this is the only time where they will be like, okay, you know what? Technical issues happen, but not the other times.
Hold on, it's the volume is not being appropriate at the moment.
He's still looking at his fingernails. He's like, my boo-boo. Mom, my boo-boo.
Try it again, sir. I apologize for the technical issue.
Nope.
All right, the technical, we're gonna have to figure that out. It's not appropriately working. I do appreciate that he was able to hear me because he leaned in to answer, so I just want to make that record. I'll take.
Yeah, they always make the
we'll
record that
go to the recess.
he knows, he can hear.
While we're doing that, when I needed to take the break for the audio issue, I also was advised by the captain that Mr. Brooks was requesting medical attention and reporting a small
I mean,
cut to a
he would have
finger
a better
as a
defense if he
result
was
of,
muted the entire time.
when he was removed from this courtroom.
If
and
he would
taken
just
to another
remove and move the
courtroom.
case forward without
I
him,
was further advised
I think
that
that
there are no
it would be a better
signs
shot of him
blood,
getting
and
out
that
free.
when asked, he refused to show his hands. At this time, I'm not going to pause the proceedings further for him to be seen by jail medical, but at an appropriate break, that will be done.
Look at him being frustrated. I love it.
Now, I want to turn
that's
back
just joy
to
for
the
me.
issue
It's
with
just
the
like
jury
he's mad,
instructions,
and
Mr.
I'm
Brooks.
happy because
You
he's
indicated
mad.
you had an objection. My next question to you is, what is the legal basis for the objection? I'm going to unmute so you can answer. Go ahead, sir. You need to turn around so I can hear you.
Turn around every
Part
now
of
and
the issue is
then I
also
get a
not facing the
little.
microphone, and so I need to hear him, and he needs to turn around.
Every day, every now and then we fall apart together. I don't remember the
Mr.
song.
Brooks, I'll ask you once again, what is the legal basis for your objection to the jury instruction?
He doesn't have a legal basis. He just objects. But in case of a mistrial,
I'll ask a third
they
and
will
final
just
time, sir. What is the
do the
legal
trial
basis
again,
for
right?
your
He wouldn't be like, oh no,
objection
we
to
had
the
a
jury instructions?
technical difficulties, now you're free.
I wasn't allowed to make, I can't even hear what she's saying all the way, man.
All the way, sure.
It's too low.
You want your headset?
Mr. Brooks, I can hear the deputies over there. I know they can hear me. That's been confirmed. There is the headset available
But
to
he's
use
not
should
free.
you wish to use
What
it.
does it matter if
If you
he...
can't hear, I would ask that you put them on.
It doesn't really matter.
I'm able to hear he said to the deputy, put them down. I don't want them. All right, I'm going to mute once again so I continue with my record. He did not answer the
But it doesn't
question, what is
matter.
the legal basis for
Oh,
the objection.
okay, I
asked
get
that
it.
question 3 times.
It's
based
different when
upon
he's
that
in jail and it's
non-response.
different when he's in prison.
His objection is noted for the
I
record,
get
and
it.
I will approve.
Maybe that's why he
the
doesn't want to go to general population.
preliminary jury instructions
That makes sense.
that are on file with the court. Obviously, they'll be uploaded once I read them, but all parties have been given copies of those. before I turn to the motion for reconsideration, you raised this earlier, at
Oh,
least the
okay.
topic
So in
of it.
prison,
Mr. Brooks,
I assume prison is
presented
more
a filing to the
more
court this
severe
morning.
than jail. But
To me, it
thank you
just
for
reads
giving me
like
that
an
explanation. I didn't know
objection
that.
he's
I
filing,
thought there
and
were
that will
more
be, of course,
synonyms
noted for the
than
record. Attorney
something.
Hopper,
Thank
anything
you.
you would want to add to the record on this, any position you are taking?
No, I also viewed this as, because he labeled it objection by affidavit, I think my interpretation is he was trying to make a record for appeal that he objects to the court's previous ruling. I don't think there's anything the court needs to do with this document at this time.
All right, thank you.
Maybe
Then
jail
we'll
has
move on
better
to the
food.
motion for
Maybe the
reconsideration.
bed
And
is better
again, I'm
at the
keeping
jail.
Mr. Brooks muted so that I can get through this process orderly, efficiently. When necessary, I will unmute him if the court has questions. All right, Attorney Opper, I have read through the motion. Is there anything you want to add to what you have put in your filing?
There are your headphones, my
Only
guy.
one other
You cannot listen.
observation,
There
Your
you
Honor,
are.
that since I filed that the events of the last couple of days, I
Put 'em
think
on.
further
Put 'em on, big boy.
Support my request. Not that the defendant's behavior in the courtroom has anything to do with the broadcasting of victims and witnesses, but I think the stress that is going to be placed upon them potentially by Mr. Brooks' behavior will be.
I mean, his bond was
additional
$5
challenge
million.
to them as they testify, and so not having their faces displayed, I think, would
I'm sorry.
help ease some of that tension for those individuals.
What if Elon Musk wanted to get
Mr.
him
Brooks,
free?
my first question to you is, do you have a position
Jim
on the
Bezos was
state's
like, I don't know,
request
I think he's
in their motion
innocent.
for reconsideration?
I'll get him out.
I'm looking for a yes or no answer. If you, I'll unmute and provide that to me. Go
I
ahead.
didn't hear what they said. I just put the headphones on, so I didn't even hear what she said.
Sir, it's a written document that was filed, and you were provided a copy of that yesterday. The denial of the state's request to prohibit the photography and video recording of victims and witnesses, and specifically their faces, while they testify.
A ruling was already, we already talked about that. You already ruled that,
Erica needed to
victims and
recant
witnesses will be
his
shown.
decision.
That was already ruled on.
You are correct, but they filed a motion for reconsideration. That's the document that was provided to you yesterday. I'm asking if you have any position on the request that I reconsider my ruling.
Yeah, it was, everything's supposed to be public. This is a public trial. I don't understand why there would be even the need to reconsider what you already ruled on.
I understand it won't be easy. It may be messy. It may even be stressful. In my humble opinion, the right to a public trial supersedes the other provisions, and especially in a case such as this, it's important. I want to keep this trial going.
Yeah, everything's gonna be
and,
public. The faces
that's
are
what
gonna
we
be
will do.
public.
So the request is
think-
denied.
The only thing that they didn't show was the names
But
of the
I
jury
did not hear if you
in video.
I was kind of overhearing that you addressed the file.
I was kinda overhearing. What does that mean, dude? You're in a trial that is gonna you're gonna go to jail forever or not, and you're not paying attention.
Filing that I filed this morning. I
did.
didn't hear exactly what was said. I'm just making sure that you know that I'm not trying to interrupt. I just want clarification on what I may have missed.
I'll tell you what I ruled previously. I've reviewed the filing. It's entitled objection by affidavit. No relief was requested, but also there's no statutory or constitutional or law that you cite to that I could even interpret as a request for relief. So that's how I'm going to address that filing, sir. It's noted for the record.
Can I say one thing about that?
Quickly, sir. I need to keep going.
I was filing that paperwork. I would say pursuant to the federal rules of criminal procedure under Rule 12.4 about the disclosure statement.
All right,
What?
I'll note
so I
that
will-
for the record, sir, but it was not in your filing.
So that's a judicial determination, Your Honor?
He has to come this close to the mic so the judge can listen to him.
I did want to put on the record, and that is when we were
I don't know
testing
why
the
he has to
audio,
do that.
I did advise the sheriff's department to let Mr. Brooks know, to ask him on my behalf if he wanted to come back into this courtroom. My understanding is he declined.
No, that is not accurate, Your Honor.
Mr. Brooks?
The reason.
Mr. Brooks?
I would
Shut
just
up.
want it.
Hold on, I'm gonna
for the
mute you
record.
for a second unless you stop and listen to me.
I just heard what you said, but I just.
I'm not
want to correct
asking
the
for a
record because
response,
it's not-
sir. Mr. Brooks?
It's not. It's
Okay,
not accurate,
you're
Your Honor.
interrupting, hold on.
Mute him.
You're interrupting me,
Thank
sir. I
you.
wasn't looking for a response. I'm happy to ask you the question myself on the record for you to answer it. I will ask you, sir, do you want to come back into this courtroom? You've been unmuted to answer that question.
Yes or
Not
no?
until I can receive medical treatment for the bruise that I have on my arm and the cut. You just said a while ago on the record that you cannot see blood. That's because I wiped it on my pants and you can still see the blood in the cut and a big bruise right here on my arm. I was told that the nurse would be coming in to see me, and then I was told, no, she's going to come at the next recess, which we just took. I know it was technical difficulties why you called the recess, but that was more than enough time for me to at least be seen, at least get the cut cleaned out and get it bandaged, at least at minimum.
He's acting like he has like a 5-inch slit through his arm. It's like, if the nurse doesn't come to fix this, I'm gonna bleed out, bro.
That, and for somebody to look at this bruise.
All right,
That
Deacon,
was-
thank you
that
for
was
stopping
my
by.
position on why I was not
Thank you,
yet
thank you.
ready to come back into the court, because I feel like this needs to be addressed.
All right, Mr. Brooks, I understand your request. I'm denying the request to take an adjournment, or I'm sorry, to take a break at this time.
I'm not asking for a break. I didn't ask for a break. I was just saying that at the time that there was the technical difficulty recess, before you even called that, Your Honor, I was told that a nurse was coming in at that time, but then when you called the recess for the technical difficulty, I was then told that I would have to wait until another recess to be able to be seen by the nurse, which my thing was, I
Mr.
wanted
Brooks,
to
you've
get
made
seen
your
by the
record,
nurse.
okay? I don't need you to go further with that. You've made your record. I'm gonna mute you for the time being. I want you to be aware, sir, I was advised regarding the cut, the bruise is new information. I made a determination that
doesn't
you
matter.
would be seen at the next appropriate break. From my perspective, a small cut and a bruise is not going to hold up
it doesn't
the
matter.
start of bringing the jurors in and advising them of the preliminary jury instructions. If that means the next break we take is for lunch and that's when you are seen, then that's what will happen. So I don't think I've overlooked anything, Attorney Opper, but anything you had on your
Talking
list.
to the air. Keep talking, my guy.
Nothing else on my list, but we want to give Mr. Brooks one more opportunity to change out of his orange jail uniform, excuse me.
That I would give him an opportunity to do. Mr. Brooks, would you like to go back and change into your suit?
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to. Just like I should be awarded the right to be present for every proceedings in this trial.
All right, I'm muting him again. Then with that,
I'm muting him
I
again.
am going to just take a short recess just to have the jurors brought in.
And I think Mr. Brooks needs his objection signed.
We'll make sure he has it.
Thank you.
You need to write down the objection in addition to raising your hand, and I will rule on the objections after the closing statement. So you must write down the basis for the objection and what you're objecting to, in addition to holding up your sign.
It's
That's
like,
the
nah.
procedure that we will follow.
Nah.
Right now, we're on a short break until the jury comes in.
There's an objection. I don't think I have a marker here. He really thinks that that's like a magic word. Like, if he says objection or he shows the thing.
I appreciate your patience as the court addressed some important legal matters with the parties this morning. I'm going to
He
read
wants to
through the
eat.
preliminary instructions at this time. Please pay careful attention. The first count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, caused the death of Virginia Sorensen with intent to kill that person and while using a dangerous weapon. Sections 9.
This whole process must be painful for the judge and for the jury. I mean, just for reading that, it's 67 counts. 76? 77? Whatever amount of counts that he has. It's just too much.
40.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statute.
He doesn't know what camera to
The
aim
second
it at.
count of the information in this
on or
case
about
charges
Sunday,
November 21 of 2021.
And now he realized he needs to start writing.
Caused the death of Leanna Owen with intent to kill that person. The third count while using a dangerous weapon. In this case,
I mean, I don't know what he's objecting to. She's just reading what the papers say.
charges that Darrell E. Brooks, on or about Sunday, on Main Street, November 21 of 2021, Waukesha County, Wisconsin, did cause the death of Tamara Durant. The fourth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21, Waukesha County, Wisconsin, did cause the death of Jane Coolidge
maybe.
with
Yeah.
intent to kill that person.
I don't consent to that name, or I don't know that individual.
Charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, Waukesha County, Wisconsin, on Main Street, did cause the death of Wilhelm Hospital with intent to kill 939.50 using a dangerous
It's not Darrell E. Brooks Jr. in all caps.
sub A and 939.63 sub 1 sub B of the Wisconsin statutes. The sixth count of the information in this case charges that
I mean, I would think that after an hour or two, he will realize he's not gonna respond to that.
Did cause the death of Jackson Sparks with intent to kill that person and while using a dangerous weapon.
Hello,
Contrary
Darrell.
to Section
Hello.
940.01 sub 1 sub A. The defendant has entered a plea of not guilty to each one of these charges. Of the information in this case charges that
He got-
Darrell E. Brooks.
He forgot to. He was like, you know what? My hand is tired. I'm just gonna be like that.
Did recklessly endanger the safety of Maura Gilchrist under circumstances which show utter disregard for human life.
This is
and while using
funny.
a dangerous weapon. Sections
I mean,
941.30 sub 1.
If he wasn't such a
939.50
rotten person,
sub
he would have
3
been
sub
funny
F,
sometimes.
And 939.63 sub 1 sub B of the Wisconsin statutes. Waukesha County, Wisconsin.
And then
did recklessly
keep messing with
endanger
the fingernail.
safety of Patrick Heppy under circumstances which show utter
So
disregard.
like, yeah,
for
look at
human
this.
life.
Look at my
47
objection. I'm
belongs
still
in
objecting.
the information
I'm in
this case.
perpetual
Represents
objection
the
mode.
Darrell safety of Lori Loken under circumstances which show utter disregard for human life. 939.63 sub 1 sub B of the Wisconsin statutes. For a moment, I just want everyone to stand.
Yeah, please, let's just stand for a little bit because we've been going with this guy for hours.
On Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the
make a
safety of
stretch.
David Marquez under circumstances which show utter disregard for human life and
There
while
we go.
using a dangerous weapon. 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin sub B of the Wisconsin statutes.
I think he gave up with
Did
the
the
sign
defendant
at this point.
commit the crime of first degree recklessly endangering safety.
All right, let's.
Ladies and
There you
gentlemen
go.
of the jury, I still have many pages of my jury instructions
But I'm tired.
yet to read to you. However, it's 11:54, and I would like to break, at least for the jurors, to have lunch. I have some legal issues I do need to take up with the parties, but when you come back, the court will continue where we left off with the jury instructions. As I indicated prior to bringing the jury in, because of the process that was utilized for this court to approve of the jury instructions, and Mr. Brooks was provided with opportunities to object and provide input, I would not be taking a break or acknowledging, at least at that point on the record, any objection to those. Nonetheless, he held up his objection sign for much of the
2 hours, 3 hours.
Reading of the preliminary instructions. At 10:37 a.m., I received a note. I don't consent to that name. It is not me. It is not my name. Please let me object to this as it is my right. His objection is noted. I'm not going to take any further argument on that for the reasons I've already stated.
It doesn't matter.
At 10:48 a.m., he sent another note. Are you going to acknowledge my objection? What law are you citing when you cite intent? How do I know it's what the law actually says?
How do I know?
I would once again refer Mr. Brooks to document number 244, the waiver of right to attorney form. This court is under no obligation and in fact cannot give him legal advice and is not required to explain court procedures or the law. Mr. Brooks is holding up the objection sign. I don't have anything in writing, which is the procedure that I told him he needed to follow in terms of me addressing any objections. So if he wants to write down what his objection is, and we'll file that. It's 12 noon. Let's be back here at 1 p.m.
And could he also have the opportunity to change into his street clothes if he wants during the lunch break?
He doesn't want to.
Absolutely, during the lunch break, I'm told, will be seen by jail medical staff for the concerns that he's raised. He will be given the opportunity to change into his street clothing, should he choose. Of course, when he comes back, once again, invited back into this courtroom should he choose. Mr. Brooks, if you're willing to abide by the rules of courtesy and decorum, you are welcome to come back. Would you like to come back to the main courtroom?
Huh?
Can y'all hear me?
Yes.
You're on the record. Would you like to come back to the main courtroom? And if I could just get confirmation from the bailiffs. I know the audio was tested. I was under the impression it was working, both audio and visual.
He just doesn't know how to use them good yet.
Looks like Mr. Brooks has put on the headphones and they're testing them to see if they are working. I don't believe he had those on prior to the break.
He didn't.
My notes show he had removed him at about 10:54 a.m. and when we...
I love that the attorney upper is taking notes of that.
About the last hour of the morning session, he was not wearing the headphones, Your Honor.
Thank you. All right, Mr. Brooks, I am offering you an opportunity to come back to the main courtroom. Would you like to do that?
Huh?
I'm not sure why we're not hearing him very loud at the moment, but can you repeat that again?
I say yes.
You'd like
There
to
we
come
go.
back? All right,
There
we'll
we
have
go.
you brought back then.
Finally. Let's go. He said yes.
I'd like to go back over there, Your Honor.
Oh my God. Oh, Jesus. You cannot make this up.
You would like to, you're asking that to voluntarily be taken to that courtroom.
I'm trying to seek to understand how the testimony evidence that was given could be
Mr.
considered
Brooks, I've already
evidence.
dealt with that. I'm not going to deal with it. If you want to go to that courtroom, are you waiving your right to be present right now?
can I at least raise the issue of subject matter jurisdiction? That's still
No, there's no lawful motion before the court. You may not.
Are you making a judicial determination that I cannot?
Mr.
bring
Brooks,
up
I'm going to bring the jury out. I'd like you to stay. That's my preference that you stay. But when you start doing what you're starting to do right now, going back to filings I've already addressed, and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
That is not accurate, Your Honor.
Your objection to my characterization of that is noted.
I would like to make a motion for finding the fact then.
Your request is denied.
On what basis?
It's denied. That's the
your
basis.
request is denied,
It's denied. That's it.
Your Honor, I'm merely seeking to understand on what.
Mr. Brooks, you made a deliberate choice to waive your right to an attorney, which this court honored and granted. And you, Mr. Brooks, don't interrupt me. Okay, now we're that's at least the second time. So don't interrupt me. Even though you're speaking in a soft tone of voice, the conduct still has the same effect. And that's to disrupt, to delay, and to show disrespect for the court proceedings.
It is not. It is not my
Mr.
intent.
Brooks,
It is not
please,
my intent.
I'm not going to force you to sit down. You're welcome to sit down, but I am instructing the jury to come out. You, at your peril, run the risk of me admonishing you in front of them at this point. I don't want to do that, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
You cannot.
All right?
Asking for legal advice.
I cannot explain court procedures or the law to you. So with that, Mr. Brooks, that's another interruption. You keep going. Stop.
I'm seeking merely to understand, Your Honor. I don't understand the nature and cause of the charges.
Mr. Brooks, I've already dealt with these.
I'm trying to bring up the subject matter
Mr. Brooks,
jurisdiction.
if you keep interrupting me, then you will forfeit your right to be present because you're showing through your conduct that you will not follow the most simplest rule of civility in a courtroom, and that's by not interrupting. You continue to interrupt. It's been a couple of minutes since we've been on the record, and there's been a number of times you've already interrupted me. You claiming to not understand and you wanting to discuss subject matter jurisdiction, do not, it's just a tactic by you. The fact that you are doing that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
If that's what you want to say, that's your assessment. It's not accurate.
Well, my assessment will stand on the record, sir. It's based on my observations.
And
So at this point, Mr. Brooks,
I respectfully object
stop
to that.
interrupting me, please.
I merely
Stop
just seek
interrupting
to
me,
understand.
sir.
I'm not. I was
If
in
you
the middle
have
of
an
saying
objection,
something.
write it down.
I thought that
You don't
applied to
matter.
me being.
It's
from
applying right
another-
now since you keep interrupting me while
So
I'm talking.
so what is the purpose of me being present if I'm not able to ask simple questions that I do not understand? I'm
Mr.
just
Brooks,
seeking.
I've been
I'm not
more
asking for
than
legal
patient
advice.
with you. And the issues that you keep trying to raise every time we're in here are not issues I'm going to raise at this juncture or address at this juncture in
They
the
don't
proceedings.
matter, Brooksy.
Is there
All
a
right,
reason
I've
why?
I'm not giving you advice. I'm not explaining the law. I don't need to do any of that, sir. All right, you filed what you needed to file. I've addressed every single filing on the record. It may not be to your satisfaction,
That's inaccurate.
but I have addressed them.
That's inaccurate,
All right,
Your Honor.
some of your
With all
filings,
respect.
sir, you're interrupting me yet again because you're not letting me finish with my explanation. I've addressed them in the way that I believe the law requires me to do. Again, that may not be to your satisfaction, and that is
Tough
simply the
nuts.
way that it's going to be. But
have
we are continuing on with the reading of jury instructions. Madam Clerk, have the jurors brought
Your
in,
Honor,
please.
What you're doing is judicial misconduct. You're making the judicial determination, and I'm not allowed to ask questions.
You're
I'm
not. You're
allowed
allowed to ask questions, but the court is not. They don't need to answer them. That's the difference.
question, Your Honor, which is my right. I've merely brought up subject matter jurisdiction because it has merit. I've merely
It doesn't.
tried to seek to understand the proceedings that I do not understand. You're rushing me to judgment by constantly removing me from the court.
Rushing
when I
to
should be
judgment.
present
I want
for
to
all
know. I want
proceedings,
to learn
and
what
I
that
should
means.
be able to understand,
Rushing
which I do not.
to judgment.
Once again, I do not understand the charges, the nature of the charges against me. I do not understand why Your Honor will not answer mere.
An attempt to come to conclusions despite incomplete information due to a pre-existing bias. That's not what he's doing.
questions that would give me clarification on understanding. I'm not attempting purposely to be disruptive, disrespectful in any manner.
But yet you
But
are.
if I don't understand something, it benefits me to ask so that I can have clarity. The waiver that you speak of with the attorney, I gave the right the waiver back in the way that I felt that it should be altered, and you said so yourself on the record that the word understanding was taken off of that.
Yes, we know you altered the thing, but also at the bottom of the page of that thing that you scratched at, it says that this document cannot be altered. So, what does that tell you?
Paperwork that I sent back to you. That should have let you know right there further that I did not understand the proceedings, and that was some of the issues that I'm bringing up now. It's merely
I think they might be trying to imply that her
clarification,
bias
Your
is
Honor.
because she
I
hasn't
don't
heard Elvis'
understand
words because they're meaningless.
what is going on.
But she doesn't need to.
It's not to be disrespectful. It is not
Mr.
to
Brooks,
prolong the proceedings.
Do
It
you
is
understand when I tell
I
you
do
not
not
to
understand.
interrupt me?
No,
Do you
no, I do not.
understand when I tell you you need to follow the rules of decorum? I believe you do. Please sit down. The jury's coming in.
I still would like to ask
Mr.
questions,
Brooks?
Your Honor.
Stop
cannot, though.
talking. We are proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me. The record should reflect that the jurors are entering the courtroom.
Your Honor, with all due respect.
With all due
Mr.
respect.
Brooks, stop talking. It's not appropriate at this point in time.
Shut up.
You'll have opportunity
I disagree.
later to raise other issues, but the issues that you seek to engage with this court are issues I've already addressed.
You have not. You have not shown proof.
Mr.
that
Brooks,
you have
the
not
jury
shown.
is in the courtroom.
I understand that,
You
Your Honor.
continue to talk.
He said that he understands something. Oh, I didn't notice this before. He just said, I understand that. It's the first thing that he's understanding so far.
Despite being told to sit down.
But he just
and
admitted
pay
to
respect
understanding something.
To this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor. It is my right.
That's the equivalent of if I'm free to leave, I'm free to stay.
Mr.
I'm
Brooks,
merely
you
exercising
can
my
stand.
right.
You need to be quiet. Thank
Your
you.
Honor, Your
Mr.
Honor.
Brooks,
Your Honor, Your Honor.
please stop. I'm going to continue with the instructions. If you interrupt me, you will run the risk of being taken to the courtroom next door.
I'm seeking to understand, Your Honor.
Mr. Brooks, final warning.
Shut up.
I'm seeking to understand, Your Honor. It must be some clarification.
Mr. Brooks,
There must be nothing. Shut
I
up.
want you here.
I want to be
Stop
here.
Then shut up.
interrupting me.
You were quiet. I didn't.
Mr. Brooks,
Shut up.
stop talking so I can read through the instructions.
Your Honor,
Ladies and gentlemen of the
You
jury,
can
I'm
move
going
me
to
to the other
continue
thing.
with the jury instructions. You must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly
If you are
endangering safety
satisfied
while
beyond a
using
reasonable
dangerous
doubt
weapon?
that all
And
three
he stands the
elements
whole
of
way.
first degree recklessly endangering safety have been proved as to count 52,
you should find the defendant
52.
guilty
We are only in 52. Jesus Christ.
of first-degree recklessly endangering safety. If you
charged
find the
in count
defendant
52.
guilty of count 67, you must answer the
67.
following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? And just for a moment, since I'm going on to a next section, let's just stand for a minute.
Another standing break.
If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 73,
73,
you
we
should
almost
find
done.
the defendant guilty of hit and run as charged in count 73. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Jackson Sparks?
He did.
The defendant is charged with violating a condition of bond that required that he not commit any crime. The state alleges that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death, and battery. If you are satisfied beyond a reasonable doubt that all 3 elements of bail jumping have been proved as to count 75, you should find the defendant guilty of bail jumping as charged in count 75. The 76th count of the information charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, Waukesha County, Wisconsin, did cause bodily harm to Erica Patterson by an act done with intent to cause bodily harm to that
Hey,
person.
Deacon, welcome back. We're just
without that
about to
person's
finish
consent.
reading the
parties
instruction
will
juries.
make opening statements. The
Opening
purpose of
statements.
an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show, so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. Before we have the parties, or before I give them the opportunity to make opening statements, I am going to excuse the jurors to address a few legal matters, give you an opportunity as well for a short comfort break.
Yeah.
We'll let you know when we bring you back in. Go ahead, sir.
I noticed that one of the jurors, the lady in the black.
No, that's why I like this edit, because it's not, we don't have to listen through all of it. It's the channel name is called Yes Antonio. Yes Antonio.
Closest to the screen in that corner chair over there.
Oh, here we go.
I recognize her from my initial appearance. She flipped me off coming in to my initial appearance and coming out. I know it's her for a fact. I seen her
for a fact.
About like how I'm looking at you right now, so I know for a fact that's her. I don't want that to end up being an issue. Is this some type of way that could be addressed by Your Honor?
Mr. Brooks, you had an opportunity to exercise preemptory strikes and even to question jurors about that. You chose not to. So at this point, any issue you have with that juror is waived.
Okay. You do remember that I was not present in the courtroom. I couldn't see. All I can see from that courtroom in there is just you, Your Honor, and the prosecution's table. I can't even see the bailiffs. So it was no way.
And this is how you know that he's not dumb. I mean, he's stupid, but he's not dumb, because he has all of these arguments that are valid, that he knows. He has something here, but he's just too dumb to actually apply it in a good way. Also, if I would see him in the streets or in jail, I will flip him off. Just for the record.
For me to even see who the jury was. Obviously, I wouldn't know him by name. If I would have been able to see the jurors, I would have immediately addressed that.
I will make this one indulgence. I'll have the civilian bailiff ask that juror if she was in attendance at your initial appearance out of an abundance of caution. Do you know the number of the jurors, sir? They have numbers.
I just know that I can't see the number from here. I just know the chair she was sitting in.
Which chair, sir? Top row or the top or the bottom row?
The bottom row, the last black chair. Black shirt. She had the black shirt.
They're all
on.
black chairs, sir. So
The last
chair
black
closest-
chair closest to the television.
Thank you, sir, because there are two sides,
Yeah,
right?
it
So there's a
doesn't
last
make
chair on
sense.
both sides, so I wanted to make clear. You're saying the chair closest to the television. Thank you.
I said that at the beginning, Your Honor.
State have copies of the filings?
He keeps antagonizing the judge.
I will take these in
I don't know
order.
how that fares in
The
these
first,
tactics.
is a note from Mr. Brooks that was handed to Deputy Wittig at about 12:05. It says, "I would like my filings addressed, parenthesis, notice of special appearance, statement of particulars, both are by affidavit, filed 10/3/22, which today is deadline to respond. Thank you, Mr. Brooks. I'm respectfully declining to respond to those filings."
Boom.
That's my decision, sir. Next
Are you
topic.
making a judicial determination that those have no merit?
Mr. Brooks,
It's a decision.
I have indicated to you on the record what I will or will not do.
I would like to motion for a finding of fact.
Your request is
Denied.
denied. The next,
May Your Honor explain why.
Mr.
it's
Brooks,
denied.
later
He doesn't
on,
have to explain
if you think
anything,
I've
bro.
made an error, you can then raise that on appeal.
Yeah.
I know you're making the error, Your Honor.
Mr. Brooks,
I
I'm not
know
going
you're
to debate
making an
with you
error.
right now. We
I'm
are
not.
continuing on. I'm giving you the courtesy to respond to each one of these things. That's how I've responded. The next piece of paper filed at 1:52
Like a
p.m.
judicial, are you making
says,
a
"Are
judicial
you making a
determination?"
judicial determination? I'm not allow my right under the First Amendment to freedom of speech in this courtroom." Mr. Brooks, we have rules of decorum and courtesy. You do not have a right to disrupt the proceedings.
That was not
And
disruption.
Mr. Brooks.
I was asking, will my First Amendment right,
Shut up.
which is freedom of speech and the right to be heard in court, will that be honored by Your Honor? That's a valid question
Mr.
because
Brooks,
that's a constitutional
I have
right.
given you ample opportunity to present information, evidence, to question when we've had witnesses on the stand, but I expect you to follow the rules of procedure, the rules of evidence when presenting your requests.
Yes.
I can't even
So-
get these admitted into evidence.
Because they're not valid,
Mr.
bro.
Brooks, I cannot explain to you if you don't
Beacon is right. You have a
understand the
deadline.
basis in law for the denial.
You're right. I don't understand. But
So,
I was
but that
following-
doesn't mean we're going to have a
I was
discussion
following- no,
or a
I'm not
debate
trying to debate
about
with you,
what
but I
it
was
means, because we're
following-
not
I
going
was
to do
following
that.
the rules that you set
So the bottom
by
line is, I
writing
don't
and
feel,
sending-
Mr. Brooks, stop talking. I do
No.
not,
This thing also. He always says that you told me to, if I wanted something, to turn it in writing. And I'm okay. That's cool. But if you turn it in writing, that doesn't mean that they have to answer to it. Doesn't mean that they have to approve it.
not
I was
feel,
right. I was following the rules when you said that I had to make all
and you did, and I'm
objections
going through
in
them, so
writing.
please give me the courtesy that even when you disagree with how I answer them, that you will not interrupt me.
It's not about me trying to interrupt you, Your Honor.
Mr.
All
Brooks,
I'm saying is,
I'm going to address the next one,
what
so
you-
please pay
what you
attention.
were saying about decorum, I was asking, does that fall under the First Amendment? Because the First Amendment, which is my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr.
That's
Brooks,
all I'm really-
again, you have the right to present a defense, but that right is not unfettered.
But that's
He doesn't
That
know what
right,
that means.
Mr.
I'm talking
Brooks,
about the First
you
Amendment.
are interrupting me. Stop.
Because you're talking about
No, because you're
talking about an
purposely
amendment that I'm
doing
not
this,
referring
so
to,
I
Your Honor.
can't get my reasoning
But
out.
I'm
You
not
make it
referring to the
incredibly
Sixth
difficult.
Amendment. I'm not referring to the Sixth Amendment.
He doesn't
Mr.
know what
Brooks.
that feather
The First
means.
Amendment, which clearly says that I have the right to freedom of speech and to be heard in the courtroom. Are you not going to honor my constitutional right, Your Honor? If not, that is judicial misconduct. And you're making a judicial determination to not honor my constitutional right. I just want to be treated fairly, like anyone else, which you said on the record that you will be fair and impartial.
She's
the same paperwork that you gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree or consent to. We both know that, Your Honor.
Mr. Brooks, I made findings regarding that, and those findings stand. That despite you scratching out some of those words on there, I made very specific findings about your waiver of right to an attorney. So we're not going to relitigate that here right now.
You also accepted the terms of the paperwork that I
Mr.
filed out.
Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract.
We did not.
Or engage in any.
Bound and gagged. Does that mean? I mean, they can tie him up to the chair and put a ball in his mouth? Because I would love to see that.
Type of that kind of dialogue, because that's what you're claiming through some of these filings, and you've said that previously.
I'm not claiming that, Your Honor.
So,
in any way,
Mr. Brooks, I am giving you some leeway. I'm asking you to follow the rules of civility.
Literally, yeah.
Simple rules, sir. Don't interrupt me.
Did I not just let you read the whole jury instructions and follow?
I let you read. I allowed you to read that.
The rules that you said I have to write down.
You did.
Anything that I object to, and then hand it in.
Except now that we're discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not what's being asserted.
Here's
on my
what's
end.
happening, sir. I'm telling you, I'm advising you to respect the rules. I'm advising you that if you continue to interrupt, you risk forfeiting your right to be present. So I'm gonna, if I need to, I'll remove you to the other courtroom so that I can do this. And yes, exercise the mute button, sir.
Get him out of there.
And then I'll bring you back when the jury's back.
I filed this paper.
Mr. Brooks is clearly not following the simple rule of civility that I have established. He continues to interrupt. He's not providing this court with ability to make rulings on the record without interruption. So this is your final warning, or you will be removed to the other courtroom.
Will Your Honor honor my First Amendment right?
I'm not answering that question, sir, because I've already addressed it.
Yeah, she already told.
Judicial determination to deprive me of my constitution.
I am not making any such determination, sir.
So you just said you're not going to answer the question about my First Amendment right, which says
Sir,
that
I've
I
already
have freedom of
answered the
speech.
question that you have a right to present a defense.
That is the
You have a
Sixth
right
Amendment,
to
not
be
the first.
present.
You're trying to twist
You
up the
have
amendments.
a right
You gotta
to
you're
present a
twisting
defense,
this, Your Honor.
but your rights are not unfettered.
Yes, they
Your
are.
rights-
Yes, they are.
You're citing the Sixth Amendment, which I am not
Mr. Brooks,
questioning.
your First Amendment in some respects is circumscribed by the rules of evidence and the rules of procedure.
Does it say that I have
So it
freedom
doesn't
of
mean you
speech?
get to say anything that you want in
No,
front of
I'm-
a jury.
Your
And it
Honor.
doesn't mean you get to put forth any kind of evidence that
Right.
you want
Your
in front
Honor,
of a
am
jury.
I
What it
being-
means, sir,
am
is
I being
that you
disrespectful?
must
Am I
follow.
calling you
Yes,
out
you're
your
being
name? Am I threatening
disrespectful because
anybody?
you're
I'm
not.
not doing anything of the sort.
All
Yes,
right,
you are.
he is continuously talking over me. So at this point, I'm going to find that he's forfeit his right to be
I have
present
not
as I
Thank
go
you.
through
He's out of
I
here.
have not consented to
Get him out of
his
here.
paperwork.
to
He's to be
understand.
removed to the other courtroom
I'm
until
simply
such
trying to
time as he
understand
can pledge to
why we're
follow
not
the
talking
rules
about
of
the First
decorum and
Amendment. I'm not
civility.
talking about the
We'll be
Sixth
in
Amendment.
recess
Get him
until
out.
we have
Your Honor, I
everything
do
set
not
up.
agree to a
The
estoppel.
record to reflect, I'm stepping off.
Yeah.
After repeated warnings to him, the court made a determination that he had forfeited his right to be present in the courtroom while we discussed
The
his
defendants, I don't know if there is a pro se. I would obviously
filings.
apply that way. Yep, she's the one being loud, of course, big brain.
The record
Of
will
whoever had to.
reflect
Oh
that
yeah,
Mr. Brooks
the
did not give
transcribers.
consent. I
After
am
that, I will ask for a
still
raise.
Continuing with my findings, sir, so I'd ask that you not interrupt me. Mr. Brooks, I'm not done. I'm going to mute him because I, frankly, can be difficult to keep one's train of thought when you are consistently interrupted, which
Yep.
is why I believe he engages in the conduct that he does, because it's plain and simple, it is disruptive. He
It
has
is.
forfeited his right to be present while we discuss all of these filings, but what I will do is go through them one by one from the beginning. Since they're Mr. Brooks's filings, his position has been made known. I'll ask the state to respond If I feel any additional follow-up is needed from Mr. Brooks, I'll ask him for that. So the first one that I will deal with is the one that's got today's date and 12:05. I addressed it earlier in terms of that I did not believe it was a filing that required any court response, and I'll ask the state if the state sees any of that differently.
No, Your Honor. In no way
No.
have any of these defenses, such as his name, the jurisdiction of the court, the fact that the state's an entity, any of these efforts that Mr. Brooks has tried to put forth have been soundly rejected by the courts.
And that is why I can simply deny
He's
the
doing all
request
this
to
stuff and
address
he's
those
like-
filings without any further discussion or hearing on them, even without giving Mr.
No,
Brooks
it's
an
not that he's
opportunity
not
to
being
further
disruptive. He just
respond.
he doesn't mean to be disruptive.
The second statement, and I note he's raising the objection, and I'll indicate for the record he's objecting to what's being ruled upon. Then the second filing, we heard him discuss at length, and that was his
I
claim
know,
that,
Deacon. It's so
his First Amendment
it's
rights
something
to freedom of
else.
speech are not being honored in this courtroom. Not sure really how to address, are you making a judicial determination? Everything that I do when I rule on something is a decision that is made by this court.
Yes.
So I've answered this. We'll move on to the next one. That is and he is raising his objection, and that's fine. He can do that. His objection will be noted for the record. He also raises in the next filing at 158, I still motion to prove jurisdiction, please. Also motion to dismiss for no proof of jurisdiction.
Motion to
Also
dismiss
motion for finding
already.
of fact. Again, none of these things cite to any legal authority or any factual basis, nor do they request any specific relief. And therefore, I will deny
Yeah, he's just saying stuff. It
the
doesn't matter.
requests in that piece of paper summarily without further consideration.
Summarily.
I know he makes repeated
Deacon, does
objections
summarily
at
means
either how I say his name
forever?
or how
Something
it's
like that?
referenced in the caption. This court will refer to the name that is on the information in this case. That is the official charging document. I know when I first had hearings on this case, even his own attorneys referred to him as Darrell. And it was only after I viewed his recorded interview that I learned it was Darrell. I asked him at one hearing, how do I say your name? Is it Darrell? And he said, that's
yeah,
right.
no problem.
Or words to that effect. I may not have the exact quote, and I'm not quoting him, but he confirmed for me on the record, at least at that point, what his first name was. So his continuing objection about his name is so noted. It's preserved in the record based upon his filings, and I'm not going to address it further.
Good.
Frankly, his last document, which says a plea is to argue facts, I don't intend to do that, and I never agreed to or consented to a, quote, not guilty, quote, plea. My attorneys never got my consent for a not guilty plea. I don't understand. The
So
law
you
is
want to
very
be guilty?
clear, that a plea of not guilty, even when a defendant stands mute, is what the court proceeds with. I will note Mr. Brooks continues
So he
to
never agreed to
have
being
the
not guilty. So that
objection
means that he's
sign
guilty?
raised.
What?
I certainly am willing to have you brought back over while the state gives their opening statement, and certainly if you choose to make an opening statement, for you to do that in this courtroom in the presence of the jury. I know you're holding
Yeah,
up
it
your
was about
objection
summarily.
sign, sir.
I don't know what
But
summarily
I am giving you
means.
the opportunity to come back over here. Would you like to come back to this courtroom?
Huh? Yes or no,
To
Mr.
reflect,
Brooks?
he's holding up his objection sign. It appears that he's writing, I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements?
Yes or no, Mr. Brooks? Yes or no?
So I'm on the record.
Yes.
You are. If you would please address my question.
Yes, answer the question. Yes or no? Yes or no?
So you want me to come back over there just to get brought back over here?
No, she's asking you
That's
if
not
you
what I
want to
asked
come
you,
there.
sir. The jury's going to be brought back in shortly for opening statements. The state will go first as they bear the burden of proof, and then you will be given an opportunity to also present an opening statement. So my question to you
Dismissal with a noise for
is,
serious
do
misconduct.
you want to come back to this courtroom, sir?
Thank you.
So I can get sent back over here, because as soon as I say something, I'm gonna get sent out.
It does.
Mr. Brooks, it's your conduct in this courtroom. It is what dictates the court's response. If you follow the rules of decorum and courtesy and civility, you will remain.
Yeah.
You say that even though I never consented to being taken out. You say
don't
say
have to
that
consent.
everything is about the decorum and all this. That's what you say. But when I'm raising issues of understanding, which I keep telling you I don't understand, then it's looked at as being disruptive. I don't understand why everything I say has to have
I am an old
title
Latin.
to it. It's even been put on record numerous
I don't
times.
know old Latin, but I am one.
With inaccuracy. Even what happened today. Nobody reported on record about me being bruised up. And
Who cares about you being bruised up?
And all these things, but it was put on me, laid at my feet as if me, quote unquote, being disruptive was deserving of what happened to me.
You do, it was.
I'm simply trying to have a fair trial. And if I don't, forgive me for being this way, Your Honor, but if I don't understand, I'm going to ask questions. That's the only way I can have clarity, is by asking questions. And you have refused to answer anything, but I have to answer everything you ask me.
Yes, that's how
Where's
it
the give
works.
and take? It should be fair.
No.
I'm not asking for legal advice. I'm not asking for nothing like that. I'm asking to simply have clarification so that I can understand. I cannot put on an adequate defense if I don't understand something. Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Mr. Brooks?
Doesn't matter.
I'm not going to go through this with you again, where you attempt to put on the record all of these issues that you have.
Should have thought of that before, bro.
All right? You willingly waived your right to an attorney. I
Yep.
made all of those findings, so we will go
You
forward.
made those findings,
I
but
am
they-
not obligated to answer questions.
You made
when you
those
ask me
filings.
questions.
Exactly.
I'm going to mute him.
Yes, thank you.
I am not obligated to answer questions that explain procedure or the law.
Yep.
I am obligated to
look
address
at him.
motions to address that
Eh.
are based in law and fact. I'm obligated
He's just throwing
to,
his tantrum
to
over there.
address objections, for example. But I am
And
not
no one
obligated,
cares.
sir, to provide you with an explanation of the law, of the procedure. All right, then we will have the jurors brought in, and then the state can then proceed with its opening statement.
He's still yelling to the clouds.
All right, at this time, we will give the parties the opportunity to make opening statements. Does the state have an opening statement?
Yes, thank you.
There we
And
go.
just for
Opening
the
statement. Let's go.
record, Mr. Brooks is appearing from the other courtroom. That should not influence your verdict in any way, ladies and gentlemen of the jury. Go ahead.
I don't remember what day the forts were.
The event started off.
But I'm gonna endure as much as I can. I'm gonna be here at least for. All right. How long is?
Local businesses.
We still
all making
have
their way down the parade route.
about an hour 20 of this one.
The evidence is going to show that
Yeah,
Mr.
we're
Brooks
gonna
left
finish
behind a
day
trail
one, and we're
of
probably gonna
carnage
start with day
and
2.
chaos as he made his way down Main Street through the parade route. The evidence will show
I'm
that he
gonna try-
left that crime scene, created that crime scene, in fact, because he was fleeing
To power through
from
it.
another one.
I thank you for the.
One where he had laid
I
his
thank you
hands
guys
on a
again
woman,
for the donation for the fund.
and where police involvement became inevitable. So as he careened down Main Street, swerving from curb to curb, hands glued to the steering wheel, eyes fixed on the road in front of him with a silent rage on his face, he hit the gas with his red Ford Escape and used it as a battering ram over and over again, striking men, women, and kids.
Kids.
In the end, Mr. Brooks killed 6 people. He injured dozens more and left a permanent scar on this community. We're going to move into the first chapter of this story, and you're going to hear about the origin of Mr. Brooks' rage that day. A violent domestic argument with Erica Patterson, his former girlfriend and the mother of his child. Erica Patterson is going to testify either today or tomorrow, hopefully today.
Oh,
She's
that's
gonna
going to be
tell
a
you that
good one
in
too.
November of 2021, she was staying at the Women's Center, which is a shelter here in Waukesha. And on the day in question, November 21st of 2021, the defendant showed up in Waukesha in his red Ford Escape that she knew
It wasn't
drove,
his, it was his mom's. That's the
and he argued
saddest
with her.
thing. It
harassed
wasn't even
her.
his car.
And he punched her in the face. And the thing about a swollen eye is it's tough to fake. You're going
Look
to
at
hear
that.
evidence about how the defendant was reacting that day. You're going to see what he looked like, what he was wearing, the red Ford Escape that he was driving. You're going to see how the defendant reacted once Erica's friends showed up and he lost
Yeah,
his
Saki's
physical
a good
advantage
guy.
over a woman. At some point during this scuffle,
He's
the
married
police
though,
were
Anx,
called.
so
The evidence is going to show that the defendant must have known once things got loud and once there was more than just him and Erica on scene, the police were going to show up. So he took the coward's way out.
yep.
You're going to see him in the video get into the driver's seat of that red SUV. Corey and Erica will tell you that no one else was in the car. And you're going to see him pull off on White Rock towards Main Street. You're going to hear evidence about the first of the larger groups that was affected by this incident, the Waukesha South High School Marching Band. 10 kids in that band got either hit or run over. Here's the first example of our efficient presentation of evidence. You're not going to hear from any one of them. High school-aged kids, there's video showing each and every one of them getting run over. So instead, you're going to hear from their band director, Sarah Waymire Aparicio. She's going to come in and she's going to look at some still shots of the video.
Oh, the
She's
ring.
going to identify each of the 10 kids for you. You're then going to watch and listen to the video, and it'll be clear as day who's getting run over or hit. It'll be clear as day whose safety was endangered by Mr. Brooks that day.
Yep.
I think it's important to point out you can't consider this evidence of each crime in a vacuum. You need to consider the entire incident. Because at this point, by the time we get to the Blazers, the defendant will have already hit or run over 15 people.
15, dude.
You'll see in the video that at this point, the
Look, he's
defendant
smiling.
has actually
You
increased
can see his
speed
face, he's
in that
smiling.
area right before the Blazers got hit. The defendant
He
was
has the
traveling
thing, but you can
in
see
excess
him
of 33
smiling.
miles an
That's that really makes my
There were
blood
5
boil.
victims
Why would he smile?
That includes Jackson Sparks, who was walking with his big brother Tucker. Cut down in the road before he had a chance to put any miles on his soul. Jackson was 8.
8 freaking years, dude. That's how can
Died
you
2
live
days
with
later
yourself?
in the
How can
hospital.
you wake up in the morning knowing that you did that to someone who?
I think this is a good point to talk about the law of first-degree intentional homicide. Again, the judge provided the law to you. It'll be provided to you again at the conclusion of the trial.
Yeah, he thinks he has control, but
We're going to
he
move further
does.
down the parade route. And the
He
next
really
group
doesn't.
after the Blazers is the Extreme Dance Group. There were girls of really all ages in this group, from toddlers being pulled in strollers up to high school-age teenage dancers. 15 victims, 15 people associated with this group either got hit or were very close to getting hit. That doesn't include 2 additional spectators who were watching the parade from the south side of Main Street, near the 5
And how can you measure the psychological damage of those people? Because that also has something to do.
Girls in this dance
it.
group suffered catastrophic injuries. The group of victims also includes parents, grandparents, siblings, people marching with the group. The next group down the parade route is Citizens Bank. And here we reach
one of the few things I haven't
second
seen in
count
this case is actually videos watching
of
the
intentional
video of
homicide.
someone else. I can search and I can
Jane
imagine.
Kulik was marching with Citizens Bank.
Oh yeah,
with
I
friends
I
and
never seen
coworkers.
the actual video of him running people over.
This is the only
I don't have the stomach to watch that.
Clear video depicting how she died. You're going to hear about 3 kids who were standing along with a bunch of others along the curb in front of Steaming Cup. And as the defendant swerved from the left side of the street as he hit Jane back to the right side of the street as he was avoiding the vehicle that was ahead of him, clipped the curb and hit these 3 kids. Then we're going to move in to the next group in the parade route, which is the Dancing Grannies.
Oh god, the dancing grannies.
This is the deadliest point in the parade. 7 people in this group were struck. 4 of them died. You're going to hear from witnesses, members of the Dancing
This
Grannies
freaking
group,
guy.
who will come in and they will describe being completely caught off guard. We will learn about Bill Hospital, who was marching in a support capacity. He was there to support his wife Lola and their friends, the rest of the Dancing Grannies, just walking along the parade route trying to be helpful.
Yeah, he didn't have anything to do
As
with
the
it.
defendant swerved around the Dancing Grannies vehicle, which is a white SUV, you'll see it in the video, swerved around the right side. He hits Bill. And the medical examiner is going to tell you that Bill Hospital cause of death.
Yeah,
was
but
multiple
him being
blunt
in
force
prison
traumatic
doesn't
injuries.
mean anything really to the
We'll
people.
learn
I mean,
about Tamara Durand.
if some look at that's just
Marching with
show.
the grannies,
That's
cause
just
of
show.
death,
I don't believe for a
multiple
second
blunt
that that's
force
for
traumatic
real.
Injuries.
Get that out of here.
You'll hear about Lee Owen.
People
another
that believe
dancing
in
granny
that
walking in a winter wonderland.
don't do that. Don't
She got
behave the way that he behaves. So get out of here with that.
You'll learn about Ginny Sorensen. You'll learn that Ginny was walking at the front of the group carrying the banner. You'll see video of Ginny getting struck. At that point, where the defendant crashed through the Dancing Grannies group, he was traveling at approximately 32 miles an hour.
32 miles, dude.
The 8th and final group that was struck by the defendant in this case is the Catholic Communities of Waukesha. We're going to be efficient.
Yeah, he's
but we have
acting.
a lot to get through. A lot. And at the conclusion of all that evidence, District Attorney Opper is going to stand up here and she's going to ask you to render verdicts consistent with the evidence, to find the defendant guilty of each and every count. Thank you.
Hey, let's go, Zach.
Mr. Brooks, my first question to you is, will you be making an opening statement at this point or deferring until your case? Meaning the defense portion of the case.
I will be deferring at this time.
He doesn't know
I
what to
need,
do.
A little more adequate time to
Adequate.
make sure I go over the points that I need to make.
All right, then the court will honor that request, advise the jury he's deferring his opening statement until a later point in the proceedings.
I can't wait to get to that.
Transportation is also difficult.
I agree with recidivism
and
unless
so
he's been
she's
shown
here
that
and
the
ready to
offender
go
should not be
if the
released back
court
to the
would
community and
indulge
whatever
those
he's
two
going to do is
witnesses
about.
this
Yeah,
afternoon.
It certainly seems reasonable.
I agree.
Mr. Brooks, my question to you then is, do you want to come back over for the testimony of those witnesses?
A yes or no question.
I would prefer to. I'm still kind of taken aback by not being able to know exactly how many witnesses are expected to testify.
What does
and
that have to
being
do
able
with anything?
own witness list.
Well, Mr. Brooks, you've been given copies of the witness list. The state's offered you a flash drive with all of the exhibits to streamline what will be presented at trial versus what is in discovery, so you've had ample opportunity to review those.
Yeah.
I'm happy to bring you back. You, of course, will have an opportunity to cross-examine them. Are you willing to follow the rules of courtesy and decorum and the rules of procedure and evidence?
Yes or no?
From what you explained yesterday, the objections you said have to be like, I think you said like 3 words. Is the way to actually object.
He doesn't even know how to object.
Some objections really are one
Yeah, he got all the
hearsay.
discover.
Maybe 3 words, calls
All
for
of it.
speculation, things of that nature. So, if you're willing to abide by that procedure, then you can come back to this courtroom.
Yes or no?
I can't really definitively give an answer right now to that.
What? Why not?
So you're not willing to follow the rules of courtesy and decorum and procedure and evidence?
What?
That's not what I said.
That's why I'm asking the clarification question, sir.
Yeah, then what did you say?
I was clear in what I said. I don't think I can make that determination right now.
When then? When are you gonna
Let me
make
ask it this way, sir. You may reclaim your right to be present if you are willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. Are you able to do that, sir?
Nope.
I thought I have.
Yes or no, bro?
Sir, it's I think, a fairly simple question. I'm asking
It is.
you if you are willing to conduct yourself appropriately.
Yes or no question?
Shorten it to that. Are you willing to conduct yourself appropriately, sir?
I have to the best of my ability.
That's not the
please
question.
Answer my question directly. Are you willing to conduct yourself appropriately?
Yes or no?
I have
Yes or no?
conducted myself appropriately.
I'm not asking about your past behavior. I'm asking if you're willing from this point forward, for the purposes of the testimony of 2 witnesses, to conduct yourself appropriately.
Yes or no?
I have.
That's not my question. That's not the answer I'm looking for. I'm not asking if you have. I'm asking if you're willing going forward to conduct yourself appropriately during the questioning of these 2 witnesses. Yes or no?
Yes or no?
I'm going to end up getting put back over here eventually.
Yes or no, dude?
Mr. Brooks, I'm further advising you, I'm looking for a direct answer of yes or no, and that your failure to give me a yes or no answer will be considered by this court to be non-responsive. So let me ask you the question one more time. Are you willing to conduct yourself appropriately during the questioning of these 2 witnesses?
To be 100% honest, I cannot answer that.
That's
Right, then,
that's a
based
no.
on that answer,
Yeah.
which is non-responsive to the question that I asked, he has not given me a pledge or indication of a willingness to conduct himself appropriately going forward, and based on that, he'll remain where he is.
Yeah.
He will remain unmuted, and so if you have an objection, you can lodge that objection within accordance or according to the rules of evidence, sir.
Non-responsive.
He doesn't have to answer that.
You did not answer yes or no. All right, do we need to
So
back
that's
out?
Yes, that's what not responsive means.
Do you think with where that chair is, the witness will
I
be?
would ask the witnesses to have to stand where I am so that everybody can see.
Oh, that would be a good idea. No, you're not muted yet.
Yet. Not yet.
Brooks, if you're asking me to make a judicial determination, I've already rendered a decision.
Hey, let's go, Deacon. Lies of P is a great game. I'm still enjoying it. Have fun with your homework.
The blue boxes are the names.
Okay, here we go. Here we go. We are in testimony now. Let's go.
Officer, PA would be a parking agent. CSO would be our community service officer.
The reserve officers and non-sworn officers, would they be wearing a police uniform or some type of designation?
Yes, they all have.
Hold on. There's an objection. It's overruled. He may answer.
All personnel on the parade route are in uniforms.
There's something marked as a mobile gas station, is that correct?
Yes.
Objection.
How is that an objection? He's just asking if...
Somebody that's running the parade as far as lining up the participants and making sure everybody that's walking in the parade is where they're supposed to be, correct?
Correct.
Is there a title for that person?
Boy, I wouldn't know.
Your objection's noted. It's overruled. He may testify about the question asked.
Or is there somebody that you were dealing with directly that was kind of responsible for the units of the parade and you're responsible for the security of the parade?
Yes, there was a.
It's not.
Overruled.
Can you estimate how many spectators were present?
Objection.
What?
And there's spectators on both sides of the road, north and south sides of Main Street?
Correct.
And all the way from Hartwell all the way down to Veterans Park at the end there near Wisconsin Avenue?
Yes, I'd say the majority of this.
Hold on, there's been an objection. Go ahead. What's your objection?
That is hearsay. We can't know.
He doesn't know what hearsay means.
Was at.
The objection is noted. It is overruled.
As the units would enter the parade route, then they all kind of move forward, I'm assuming?
Yes,
It's not hearsay.
Overruled.
The parade participants are set up on either side of White Rock Avenue, and they're kind of funneled together into almost a zipper type fashion.
Yeah, let's count how many words he doesn't know the definition of. We start with hearsay.
Objection as hearsay.
He has no idea what that means.
Essentially, in the middle of the roadway, the road is much wider than the SUV squad I was driving is. I positioned it that way to give a visual representation to motorists that the road wasn't open.
And is your squad marked or unmarked?
It is unmarked.
Objection irrelevant.
It's relevant. The answer may stand.
Are there red and blue lights on your squad car, sir?
Yes.
Objection irrelevant.
Irrelevant.
Overruled. The answer may stand.
He doesn't know what relevancy means.
Did you have your red and blue lights activated as it was parked across the roadway?
Objection irrelevant.
Overruled.
Yes.
You remember hearing something about a disturbance near the boat launch?
Yes.
Objection hearsay.
Hearsay.
Are you offering it for the...
Foundational, Your Honor.
All right, it's not being offered for the truth of the matter asserted. The objection is overruled. He may answer.
I was speaking with one of our reserve officers. We were discussing the proper timing of the opening of the road. And I overheard actually on his police radio that he was wearing squads that were not assigned to the parade being sent to a fight at Frame Park that involved knives.
Were you aware of any vehicles being associated with that fight?
Objection irrelevant.
Overruled. He may answer.
I did not hear of any vehicles. At that time, we were still focused on opening up the roadway, and I made my way back toward my unmarked police vehicle, and I looked to my right or to the north down White Rock Avenue, and I saw a red SUV traveling toward me at a high rate of speed.
Traveling.
What do you
Not
mean by
driving,
operating
traveling.
speed,
He
sir?
was not in commerce.
Objection that's hearsay.
Overruled. He may answer.
I believe the vehicle is traveling in excess of 40 miles per hour.
What's the posted speed limit there on White Rock Avenue?
It's a 25 mile per hour zone.
What about Main Street in downtown Waukesha? What's the posted speed limit there, sir?
The speed limit,
Overruled, it's relevant.
the speed limit throughout the parade route is 25 miles per hour.
What did you do when you saw this red SUV traveling at a high rate of speed?
Objection, leading the witness.
The objection is noted, it's overruled.
Overruled.
When I saw the red SUV traveling toward me at a high rate of speed, I used both hands and waved
Traveling.
overhead like this in an attempt to catch the attention of the driver.
What did you observe the path of travel for the SUV to be?
Objection, that's hearsay.
It's
Yes,
not.
it's not hearsay, your objection is overruled, you may answer.
Could you state the question one more time?
Sure, where did you see the SUV go? Better question.
Objection, irrelevant.
Overruled.
The SUV entered the parade route.
I want you to describe what you remember seeing as it passed your location, please.
As a driver passed essentially in front of me by about 6 feet, I could see the operator of the vehicle and just a dazed, straight, focused look straight ahead, not looking at anyone.
He's just in a
The
trance.
driver appeared to respond to your efforts to stop the vehicle.
There was absolutely no response.
Did you notice the car slow down in any fashion?
Nope.
No, in fact,
Hearsay.
It's not hearsay, it's overruled, he may answer.
fully expecting that as it passed, that I would see the car slam on its brakes as it realized that it entered the parade route, figuring it was a lost motorist. I didn't see that happen. It continued into the parade route at a high rate of speed.
What did you do?
Upon seeing that, I got on my radio in an attempt to notify other personnel assigned to the parade route. I stated that a red SUV had just blown by me.
Do you remember using those exact words, sir?
Objection, that's irrelevant.
What?
Overruled, he may answer.
I don't know if I said a red or maroon SUV, but I remember saying that it had blown by me.
Maroon.
Were there parade units still on White Rock attempting to get onto the parade route at that point?
Yes.
Objection.
Were you able to see the vehicle clearly as it
Hold on,
went?
he
I'm sorry.
objected, it's overruled. Go ahead.
Yeah, she's not used
Where
to
you were
everyone
standing
objecting
there,
to
were
every
you
question
able to
ever.
Turn and watch the
And not only
SUV as it
questions, to
traveled
everything.
Past you down White Rock towards Main Street.
Objection.
Overruled.
Just asked that.
Ask
I
and
only
answer.
watched it for a short period of time before returning to my squad car, knowing that some sort of police action was going to need to be taken.
If you look at the screen in front of you,
Yeah.
we're going to play a video.
She only has
It's
to
pretty
exist
short
and he will be like,
duration.
objection,
I want you to
irrelevant.
watch it first. Did you see that clip, sir?
Yes,
Is that a video clip you've seen before?
I have seen that, yes.
Move for admission and permission to publish, Your Honor.
Any objection, Mr. Brooks?
Yes.
Can you repeat that? I'm sorry.
I wasn't
The state
paying
just
attention.
moved admission of Exhibit 2.
Yes, I object. Of course.
No, I object to that. Keep it.
Keep it.
All right, the objection's noted, it's overruled. Exhibit 2, ladies and gentlemen of the jury, is received. Permission to publish is granted.
Thank you.
Good.
Sergeant Warner, is that consistent with the vehicle you saw traveling away from you past the parade floats that were about to enter the road?
Yeah, they're good
Yes.
attorneys.
And is that
They,
consistent with the
they,
approximate
I
speed
think,
you saw it traveling?
Yes.
I get to the font size of, yeah.
After
Yeah, he will object to
learned that
anything.
something
Yeah,
terrible was happening on the parade
I think
route.
they aged like 5 years in the
Your
in the
incident commander, what do you do?
in the month that it took to
I
This- for
drove
this
in my
trial to
police
be over.
vehicle down toward the area that I just heard repeated over and over on the radio where the casualties had taken place. An officer used a code over the police radio basically requesting police assistance from any officer in the county that would be listening.
Did multiple officers respond?
Yes.
From
Yes.
within Waukesha County?
From when,
Relevant.
Waukesha County and far beyond.
Everyone was like, what the hell is going on
Thank you,
here?
sir. I don't have any other questions at this time.
Okay,
Mr.
here we
Brooks, do you
go.
have any
It is the
questions
fun
for
part.
this witness?
Yes, I do.
All right, let's go. What is the first question that Darrell's gonna ask the witness?
First off,
Good afternoon.
Good afternoon.
I'll say this is very emotional, so I'm gonna try my best not to keep you up there any longer than you would like to be.
Whatever. Ask the question.
My first question is, I noticed that you are in uniform today. Did you feel the testimony that you would be giving at trial today warranted you to be in uniform?
What?
Sustained.
That is the first question that comes to your mind?
You've been in
What?
duty for 18 years, correct?
Yes.
Okay. So?
In any of those 18 years, have you ever come across or had any interaction with the plaintiff in this matter?
Why is that relevant?
Sustained.
Objection
Not
relevance.
need to answer that, sir.
Next question, Mr. Brooks.
How long have you known the plaintiff?
Objection, vague and irrelevant.
Why does that
Sustained.
matter?
You do not need to answer that, sir. Next question, Mr. Brooks.
Do you see the plaintiff in court today?
Objection, vague and irrelevant.
Sustained. Next question.
Do you have any knowledge of the plaintiff?
Objection,
Relevant. Doesn't matter. Ask him about the case, not the plaintiff.
Have you ever even seen the plaintiff in this matter?
same objection.
Sustained.
I want to go to the clip that was just shown.
Would you like it shown to the witness again and published to the jury?
Would he prefer for it to be so?
He doesn't know what that
I just
means.
wanted to know if that's what you were asking. You can certainly question him about it, and if need be, it can be shown again.
Okay, can you show the witness the video clip again?
Sure.
Okay. Something to do with the case. Good. We're learning.
I can tell
From my monitor and the witness monitor, it is up, but it is not being projected to the courtroom other than that. And you can go ahead and play it.
Okay.
Do
What about
you
the
see
video?
The said driver of that vehicle intentionally trying to hit anyone in that video?
No.
Speculation, though.
Again, I would ask, were you brought here today to testify on behalf of the plaintiff?
What?
Objection, asked and answered.
Sustained. He already answered.
Yeah, don't worry. I appreciate you being here for that long, to be honest. I really, really do appreciate you hanging out with me.
Again, I would ask just one more time for the record. Do you see the plaintiff in court today?
Objection,
Sustained. Do you have any other questions, Mr. Brooks?
Do you know of the plaintiff at all whatsoever?
objection.
Because it is
Sustained.
for dinner, I may have to put the mouth on. And I suppose I have my phone.
No further questions.
They think they get
you.
food
May
every time they
redirect.
stand up.
All right, thank you, Sergeant. You may step down.
They do that.
Really quick on the record, if I may.
I also will need
we're gonna
to
call the
find
next
some food
witness.
soon.
We have the jury.
But I want to power
We have
through the first
questions,
day at
sir?
least.
I will have a oral tennis motion I would like to be put on the record.
A what?
If you have a motion, you'll have to wait until after the next witness is called. Write it down, submit it on paper, and I'll review whether it's appropriate for this court to address. All right, the state may call the next witness.
When did you meet Erica Patterson?
Either October or November.
While you were bunking together with Erica at the women's shelter, did Erica ever talk about a boyfriend of hers?
It wasn't her boyfriend.
Oh,
Okay.
she,
Did she ever talk
I
about a
think
man?
Yeah.
I have an issue with.
What? Did she ever?
I have an issue with her as a witness. I think she doesn't really. I mean, she's. You can tell that she's biased against Brooks, but she seems like she had something before the trial. I think she's a little out of herself. Maybe. I don't know. Could be.
Did you ever provide the name of that man?
Yeah.
What was it?
Darrell Brooks.
Okay. Were you with Erica on the afternoon of November 21st, 2021?
Yes, until I split up with her
Do you remember why?
to go hang out with Nick
Do you know Nick's last name?
Kirby.
Okay. And Erica didn't go with you?
No.
Okay. So what happened after you split up with Erica?
She met up with Darrell
How do you know that?
because she was on the phone with him and they said that they were going to meet up.
Now, before that day, November 21st, had you ever met Darrell Brooks?
No.
You'd only heard his name from Erica?
Yeah.
Okay. After you split up with Erica and she went to hang out with Darrell, did Erica ever contact you or Nick after that point?
Yeah.
How did that contact take place?
Yeah,
was
I
it-
could see
again,
that
did she,
too.
like, see you, or did she call you?
Like I said, I don't
called me
know.
on my
It's
cell phone.
it's a maybe.
And what was the nature of that conversation?
That he was beating her up and he was following her.
Okay. What did you do when you learned this information from Erica?
Me and Nick started running to where she told us she was.
Yeah.
So, Mr. Uncle, we're going to play a few moments from this video. I want you to watch and see if it's the same video that you've reviewed previously. Okay, so we're just going to play about 10 seconds here.
I could just tell that's her walking up.
I'd move Exhibit 3 into evidence and ask to publish.
Any objection, Mr. Brooks?
Yes, of course.
Yeah, my objection would be, you've only played 5 seconds of the video, whereas the other 5, you just said 10 seconds that you would play. I'm curious to see the rest of the video.
Your objection is noted. It's overruled. This is for foundation.
I feel she's definitely someone I'll be afraid to meet in person. Accidentally get in the right side. Then probably Muslim. Yeah, I can see that.
There's his car.
We saw a person wearing a blue shirt walking from the left.
She
Do you know
seems
who that
strong.
person
She
is?
doesn't
Erica.
Erica Patterson?
take
Yeah.
crap from anyone.
And when you said there's his car, what car were you referring to?
The red one. The
And
SUV.
do you know who was driving that car?
Darrell.
Darrell Brooks?
Yeah.
Okay.
Darrell Brooks.
And again, this would have been the first time you ever saw Darrell Brooks, is
Yeah.
that correct? Okay.
I take crap from too many people, but like, yeah. I mean, Erica was in the same spot that he was just being abused by these guys.
Who's the
Since
person in the
she
gray
was a
hooded sweatshirt?
teenager, so she didn't know. I don't think she
That's Darrell.
knew better.
The objection's overruled. Or answer my stand.
That's Darrell.
Do you see Darrell Brooks either in the courtroom or on any monitors in the courtroom right now?
Yeah.
Your Honor, and actually for this point, I would ask that the court order the defendant to remove his mask.
Yeah, take
Mr.
off.
Brooks, your order to remove your mask.
There you go. Got it.
I'm not gonna do that.
Wow.
Mr. Brooks?
I'm not gonna do that.
We talked about this at a prior hearing. For purposes of identification, your order to unmask.
Yep.
Thank you, sir.
There you go. Was that so hard,
No,
baby?
we asked that question.
Was that so hard, little
Do you
kid?
see Darrell, the person you're talking about in the video, either in the courtroom or on a monitor in the courtroom?
Yes.
Can you tell us where?
In orange.
On the monitor in front of you?
Yeah.
I'd ask the record to reflect.
Look at that smile. Look at that smile.
The record will.
He's happy that he recognized her. I really hate when he smiles. But I mean, Erica got was with more people. I believe she has more kids, if I recall correctly. But yeah, getting out of a manipulator, someone that was so there, it's really I wouldn't think how hard that is.
What happened after the physical confrontation with Mr. Brooks?
Brooks walked off
Did you see where he went?
into his car.
The red SUV in the video we
Yeah.
just watched? Was there anybody else in the SUV at that point that you saw?
No.
And what happened next?
After that, it was like he headed out.
Okay. Did Mr. Brooks say anything to you or Erica or Nick as he was leaving?
He told Erica he was. Oh.
The basis for your objection, you said objection, right?
Is hearsay and irrelevant.
That's not hearsay.
Being offered for the truth of the matter asserted. From the
Well, it's
state.
a statement by a party opponent, so it's not hearsay.
Oh, it's his statement, sorry. I think I misheard what she said. All right. The objection is overruled.
Yeah.
If it's, she may testify as to words that you spoke on this occasion. Go ahead.
He told Erica that he was gonna find her and he was gonna kill her.
Wow. He would never do that. I'm sure he's a coward. He will never do that. Look at that. Look at that.
Can we pull up
He's
exhibit
laughing.
5 for the witness, please? All right, Ms. Runkle, I'm showing you on your monitor a photograph that's
Yikes.
marked as State Exhibit number 5. Do you recognize that photograph?
Even if you don't believe
Who's
that
in
to
that
be
photograph?
true,
Erica?
Erica Patterson?
why would you laugh?
Is that an accurate representation of how Erica looked the night of November 21st, so after the Waukesha Christmas Parade?
Yes.
I'd move Exhibit 5 into evidence and ask to publish.
Any objection?
Yes, of course.
Yup, on the grounds of
Why
it's
wouldn't?
hearsay.
It's not
The
hearsay.
objection's noted. It's overruled. Exhibit 5 is received. Permission to publish is granted.
Were you with Erica Patterson the day before the parade, so November 20th?
Yes.
Did she have a swollen left eye on November 20th?
No.
All right, Mr. Brooks, do you have any questions for this witness?
I sure do.
He sure does.
So, my first question would be, you
There we
seem
go.
to be unclear about when you met Erica.
What is that
Did
relevant?
you say it was roughly October or November because you wasn't sure which one?
It doesn't matter.
Roughly in between.
Roughly in between.
Yeah. I know it was before Christmas.
Yeah.
Well, you just said that you had never seen her quote unquote boyfriend
Quote
or
unquote.
whoever she was referring to as that before
Alleged boyfriend.
the Christmas parade. Is that correct?
That was, the Christmas parade was November, right?
He's asking you if you had seen
Not before, but the Christmas parade was November. I'm just asking, right? Okay, so no.
Did she? Do you want her to restate her answer? She answered. She confirmed your question.
I wanted to be direct.
Okay, no, I have not.
So you just testified that you can identify who was driving the said vehicle as soon as you saw the video played. If you've never seen the driver before that day, how would you even know who it was?
Okay, here's another thing that I have with him. He thinks that everything that the witness say right now is should be like how do I say this? Like if she didn't know him before, but she saw him that day, that how can she tell that he's Darrell Brooks? But that's easy to do because you see someone and then you see him again and you know that that's the guy. It's as simple as that. He makes such a big deal about this.
That is not a clear question. This is just going to confuse the witness. It's confused me.
Also
You
stated,
confuse
Mr. Brooks,
Zach, Darrell.
rephrase the question, please.
Why? Why would you confuse Zach?
How would you know whose car it was if you've never seen this person before that day?
Because I was told that she was going to meet up with Darrell Brooks.
There you go.
So you were told this directly from Erica.
Yes.
Yes.
Did at any time she ever tell you what kind of car he had and what kind of car he would be meeting up with her with, quote unquote?
Meeting up, quote unquote. But you did meet up with her.
How do you identify that it was the said person's car if you had no
You
knowledge
testified
of
that you met up with
vehicle
her in your interrogation with the
this
police.
said person would be driving, or who the person even was, or what the person even looked like? How would you know?
Because I was told it was Darrell Brooks.
Yeah.
And so you were told that it was this name.
This name.
But you were able to identify the vehicle and the person on the first day that you ever saw them.
You never said that.
Asked and answered.
Let him finish his question.
Oh, Zach.
Again, as soon as the car came into camera view, you immediately said on the record just a few minutes ago, "Oh, there's his car." Who is his? Who were you referring to?
You.
Darrell Brooks.
Darrell Brooks.
And you would be able to know that that was quote unquote Darrell Brooks just by seeing the car come into the view of the camera?
Yes, now.
Based on an asked and answered question.
Sustained.
Thank you.
Mr. Brooks, are you trying to ask her whether at the moment in time she first saw the SUV, did she know who was driving? That would be a relevant question.
Yeah.
Did you know who was driving the SUV that you saw when you saw it?
Yes, because I don't see why Erica would be talking to anybody else and getting yelled at by somebody else.
But did you know at that moment who was driving the car?
No.
Yes.
All right,
And
there you
how
go.
would you know that? You just said that
Because she told her.
you had no knowledge of the vehicle that whoever Erica was meeting up with would be driving. So how would you know that?
Objection, asked and answered, and argumentative.
Yeah.
Yeah.
Her answer previously, Mr. Brooks, was she's basing that on what someone told her, not based on what she saw at that point. That's at least how I took it.
So let's back up a little bit. Erica told you that she was meeting up with this Darrell Brooks.
Yes.
Correct? That's what you said, right?
Correct.
And did she at any time tell you what vehicle this person would be driving and how the vehicle looked?
Yes.
She did not.
Oh. Okay.
So the first time you saw the vehicle, did you know who was driving the vehicle?
Yes, when she told me. When she told
What
me.
he's asking you though is, did you know based on personal observation,
Oh,
not
no,
based
not
on what
personal
someone told you?
observation.
Thank you.
So let's just
Thank
make
you
sure the
for getting
record's
us out
clear
of
what
this,
your answer
Judge.
is.
It's based on what I was told when I up with her.
Yeah.
So it was told.
That's been established. It's been established
Yeah.
what was told. So next question.
No, I was going to a different question. I can get to
Then
it.
ask it.
Well, then ask it, please.
I'm trying to.
No, you're not. You're
So-
saying other stuff.
You were told after the vehicle drove away, and you
Yeah.
and Erica were.
Yeah, he's
alone?
just, it's the definition
That's
of
when you were
just
told.
pettiness.
Yes.
So it would be fair to say that before you were told this, after the vehicle drove away, you did not know who was driving the vehicle, correct? Would that be fair to say?
Oh, I had a suspicion.
Just,
it was
you too, just say
Darrell.
yes or no.
You had a suspicion, or did you know?
Had a suspicion until I
So
asked
you
her.
didn't know.
Objection, argumentative.
Yeah, so we've kind of
Yeah,
been
he's
a little
being
bit circular
hostile to
here,
the
so
witness.
the objection is sustained. I think we need to be clear, Mr. Brooks, when you ask your questions about what point in time.
you identified the
Identify it.
defendant in court. Would that be fair to say?
Yes.
Yes.
And the alleged defendant that you identified was the same person that you saw driving the vehicle that day.
Yes.
Yes.
The video also shows that
Can be a little too good at hair splitting and trying to figure out the issue, but it's also seen as
matter of fact, let me ask a different question.
yeah, he's just trying to
You made
confuse
reference to
people as
hanging
much as he
out
can.
with Erica in the park, correct?
Yes.
With maybe one other person.
Maybe
Yeah.
he was another person.
Yes.
Hanging out. What were you guys actually doing?
Drinking?
Yeah. Drinking on the
So-
on the Sunday afternoon.
Would it be fair to say that because of alcohol being involved, that there may have been a misinterpretation of what you saw?
No.
No.
What you thought you saw?
No.
Calls for speculation.
The question, the way it's
Yeah.
asked, calls for speculation. If you could please rephrase it.
Oh, I asked it different. How much were you drinking? Was it a few beers, a bottle,
Half a
something to that
pint.
effect?
Half a pint.
Do you remember what you were drinking?
How much is a pint?
Vodka.
Like a glass? Like half a glass?
Do you remember if Erica was drinking?
She was.
Okay. 2 adults drinking. Good.
And you said that you separated at
So
one
what?
point to go hang with another person. I can't remember the name, but would that be fair to say that you separated from Erica to go hang out with another person?
Yeah.
I did say that.
And is it true that you did give a statement about what you saw and heard that day? Would that be
Yes.
fair to say? Would it be fair to say that in this statement that you gave,
Mm-hmm.
you never mentioned the person that you saw driving make any threats? Would that be fair to say?
I never mentioned.
Well, I have the statement right here.
That's not her statement. That's the summary of her
Would it be fair
statement.
to say that the
That's-
statement that you gave that day, that you do not say in your statement that you heard any threats being made or yelled towards Erica? Would that be fair to say?
He did tell her.
Possibly.
It's been a
So
year.
do you remember giving a statement?
I remember giving a statement.
Do you remember what you said in your statement?
I do.
So I'm gonna ask you again because I just asked. I have your statement in
Mhm.
front of me. You did not mention
That's not a
any
question.
threats being yelled or made towards Erica.
That's not a question.
Would that
That's
be fair to
a
say?
I did mention some.
What exactly did you mention?
That you were yelling at her, saying that you were gonna kill her and to get in the car.
mm-hmm.
And that's in your statement.
Yes.
Would you like me to read your statement to you?
Yes.
Yeah.
You sure?
Yeah, sure.
Why wouldn't she be sure?
Procedure that the defendant is employing at this point.
Sure. Mr. Brooks, there is a procedure. I can have the state bring up her statement, I hope electronically, to show her. It would,
That would
and
be
then,
fine, Your Honor.
all right.
Bring it up for her to see.
You'll want to direct her to what part. You can ask her to review it, ask her if that refreshes her recollection, and then you can ask her a question.
Excuse me, Your Honor, if I may ask you, are we still on the record right now, or we are? Okay.
We're always on the
Taking a
record.
Stretch break, but we're still on the record why they,
Okay. I was gonna say something to the bailiff, and I didn't want to be disrespectful by.
Wow.
do you want me to mute you for a second so you can?
Oh
say
no,
something?
no, it's fine. It's fine.
What did you want to tell the bailiff? That it was gonna be disrespectful.
I'm allowed to come back into the court so I can see everything.
You have earned your right to come back, sir. I mean, I can bring you back if you want to finish your questioning here.
I do.
All right, we'll
I
take a short
do.
break for you to do that. All right, I'll have to excuse the jury.
I think there may have been some misunderstanding on the nature of this statement in question. This witness provided a statement to a police detective who then wrote a police report summarizing the statement.
Yeah.
The proper method at this point for the defendant would be to confront her by orally quoting from that, asking if she said or didn't say these things. To show her this statement we're not refreshing her recollection. She didn't write this.
Mr. Brooks, did you hear what Attorney Wichelt just said about the procedure?
No.
Is it a way to verify that that is in fact procedure? just to be clear for the
Is there a way to know if that is procedure? You should know.
I had referenced
You're
earlier
supposed
that I
to
thought
know.
we were trying. We might be showing her the statement to help refresh her recollection, but I don't have any of the statements in front of me, and I wasn't aware that it's the police report that may be referenced as written by someone other than this witness. She wrote a statement apparently, but the police report is a summary of her statement. Starts with "in summary" near the top.
Yeah.
And then
Oh, that's what in
page
summary
2 of 5,
means.
and then down below,
Oh.
presumably it says 3 of 5, but I'd like to bring the jury up, so let me know when you're ready.
Okay, I'm ready.
All right, let's have the jury brought back in.
Earlier, when I asked, I think you were asked by Attorney Wichelt if you heard any yelling or anything being yelled at Erica, or I'll forget how you phrased the question, but did you hear any yelling or anything directed towards you guys? And do you remember what you said?
You were yelling at Erica, telling her to get in the car, and that you were gonna kill her. The fact of you were yelling at her, telling her to get in the car, was the time when you were around. Brooks was around.
Brooks.
Brooks or you?
You are Brooks.
You said you, and then
You are
said
Brooks. I hate this.
But you did state
this is one of the things that I hate.
You had never seen Brooks before November 21st of 2021. Would that be
You
fair
are
to say?
Darrell Brooks.
Right.
And you also did say that you had only heard of him through Erica, correct?
Right.
Right.
At any time, did you ever observe any phone conversations or interactions between Erica and Brooks?
Yes. He was a roommate.
He's just asking you whether you have, not the content of any of those.
I have.
What is specifically
And
did
here we
you
go.
know before November 21st, 2021?
You don't want to bring that up.
Sure you want to ask that question? Think about some of the pretrial rulings I've made.
Let me rephrase that.
Okay, good idea.
I'm sorry, it's new. It is
matter.
Runkle, right?
Yes.
I don't want to mispronounce your name. It says Runkle further stated that she heard Brooks telling Erica he was going to smash her face in and that he was going to kill her.
Yes.
I'm
sorry.
Is that what you heard?
Yes.
So you didn't hear what you just testified to hearing?
No.
Or did you hear what I just read to you?
I heard that after you were leaving.
Yeah.
After
Not that what you just read. I heard that after you were leaving.
You do know that this is your statement that
It's
I'm
not-
reading from, right?
It's not her
I
statement.
do.
We've established that, and this is argumentative.
Sustained. Rephrase.
I'm trying to figure out which one did you hear.
Objection.
Again, not a question.
Did you hear the I'm going to smash your face in, or did you hear what you previously said?
Well, I heard when you were sitting there arguing with her, I heard that.
Mm-hmm.
Who is the you you're referring to?
Oh, I'm sorry.
Darrell Brooks.
Said that.
It says right here, but through knowing Patterson, she did know that Brooks was Erica Patterson's boyfriend. Did she ever tell you that Brooks was her boyfriend?
She said you were, I'm sorry. She said Brooks was her ex.
The thing is, she said to the police
I'm
that
a little confused by the statement.
that her
and then the testimony.
he was boyfriend of her.
That's not a question.
Sustained. Mr. Brooks, you need to formulate a question for the witness.
Did you
okay?
ever hear, now this is coming from your statement, Runkle stated that after a short dispute between her, Kirby, and Brooks, she saw Brooks get back into the red SUV and heard him saying something to the effect of, I don't swear, so F you,
I don't swear.
effing bees, you're dead. Did
You
you
do
at
swear.
any time hear anything like that?
Yes.
So when you just testified, why did that part of your statement never come up? Why did you never say that?
She said that.
Because it probably wasn't brought up at that time, but it's in my memory.
So what all exactly did you hear?
I heard what you
Hold
were
on,
saying.
we heard you say at this time? Like, the question's not
What
clear to me.
all-
Like, what time frame?
what-
and who are we talking about?
Yeah, when?
Because in the video it's clear that
Hold on, go back to your question. I didn't mean for you to not ask it. I just want to make sure I understand specifically who you're asking this witness about statements that were made.
I'm asking about who she said was the individual driving the vehicle.
Well, that's different than what you just asked. So if
Well,
you want to change and
because
go to
you
that,
just
that's fine.
you just clarified it a little bit. What exactly did you hear coming from the individual who was driving the vehicle?
I'm sorry, can we just clarify at what point we're talking about?
Exactly.
At the point that
And no one knows what you're talking about, bro.
I guess I would refer back to the video at that point that we saw on the video.
So what point of the video? There's lots of points. It was many minutes long.
Roughly, I'm not sure, I think it was
Can you describe what part of the video you want
the
her
part
to
of the
talk about?
video, when that she testified to, where she said she had the green gloves, and
So
she was
in the
standing.
beginning
She was
of the
standing
video?
no, it was like towards the middle. She was standing in the street, and she said she had the green gloves because I think somebody asked her which one was she,
Right.
and she
I
said
remember
the
that.
one with the green gloves.
I remember that.
At that point, did you observe anything being said out of said vehicle? Did you hear anything being yelled or screamed or anything like that at that point?
Well, before I showed up, I heard yelling.
You heard yelling before you showed up.
Yeah, because like before I showed up into the video.
So how far were you down the street that you were able to hear what was being said?
Objection.
Not.
Calls for a fact, not an evidence. She didn't say what she heard. She didn't say she could understand what was said.
I understand what the state is saying, but I think he's trying to establish where she was at that point in time.
I was right where you pulled up the second time.
Are you sure you know what I was asking?
It was not entirely clear to maybe all of us, but I was trying to give you some leeway. So
I knew you understood where I was going with that. Were you at let me say it like this. Were you at a distance before you came into that video? Like approximately how far away were you from the vehicle and from Erica? Before you heard anything being yelled or screamed, as you say.
I was at a distance.
So would it be fair to say that it would be hard to hear the conversation that was being had?
Not really. Brooks was yelling pretty loud.
So you were able to hear the gist of the conversation from the distance that you were at?
Yes.
Even with a parade going on and a street full of people, you were able to hear from a distance, which you just said you were at a distance, you were able to hear the gist of the conversation. Even testifying that you were drinking vodka.
Yes.
What else did you hear?
At what point and by whom?
At the same point, what did you hear from Erica at that point?
I don't remember.
But you remember hearing something from the driver of the vehicle who was inside of the car.
Yes.
Yep.
Because you were yelling.
But you don't remember what you heard from Erica, who was outside of the car and would be more easier to hear.
Okay. Thank you for being specific at that. I
You're
remember
welcome.
Erica sitting there
You're
telling
welcome.
me that she wanted to go.
So she was telling you that from you being at a distance.
No, she was right next to me. That was when she was walking towards. She said, "Come on, let's go."
At what point was that? Because you just testified that you were at a distance.
Objection, argumentative. I'm also going to object to the manner in which this defendant is asking this witness these questions. He's intentionally misleading her.
Yeah.
He's trying to confuse her.
Yeah, of course.
Be as
He's trying
specific
to.
as you can, time, place, circumstances. It's helpful for all.
I mean, the video is very clear that
But you can't testify right now, right? You can't make an argument about the video. So your opinion about it right now, that's not appropriate.
I want to.
Keep going.
What was said at that point between you and who you were chesting up with?
I'm not going to go back to that, but I was sitting there saying that you shouldn't be hitting a woman. No, Brooks should not be hitting a woman.
You.
And Brooks was saying
I hate that she's afraid to say you.
Erica Patterson is not a woman.
It's him.
Are you sure that's what you heard?
Yes.
At that moment when you were chesting up, in your words?
Yes.
You're sure that's what you heard?
Yes.
Yeah.
What then happened from that point?
Then we started brawling it out. Oh, me and Brooks started brawling it out.
What do you mean by brawling it out?
Threw a couple punches. I threw a punch. Brooks smacked
All
me.
this facial expression, like.
So did you put that in the report that you made, or the summary of the report that you gave to, I think it was Attorney
She didn't make
Johnson?
the summary. The cop did the summary.
This witness prepared a report or a summary.
What's his name?
Can we show the witness the video again?
Are you asking her whether the video shows a brawl?
Would it be fair to say that the video shows a brawl in which you just said that punches were thrown? That'd be fair to say.
Yes.
Okay, so what's a brawl to you?
You can't.
Yeah.
Oh, I'm sorry.
I know.
What is your definition of brawl?
Okay,
I think
well,
hold on, Mr. Brooks, are you trying to ask whether are you going to confirm with her that she saw the video, and then on that video, you cannot see a brawl between her and Mr. Brooks? Is that what you're trying to get at?
A version of that, yes, but I was
You
gonna
got to ask the questions
I
though
was
to
gonna
get to
say,
that.
can the video be shown to her again?
Ask your questions.
Why are you laughing? Don't laugh.
In the video that you saw, would it be fair to say that a brawl was not depicted on that video? Would that be fair to say?
It's just a couple, it's just like a push, looks like a push, but it was a smack. And I got up and, yeah.
You got up.
Oh, this
I
is.
got up and.
She got up.
You were knocked to the ground.
No,
No.
So where did you get up from?
from being pushed and smacked.
Yeah, he was like, what?
So
And then
you
she
fell
got
to
up.
the ground.
Not that hard to
To the ground.
Sustained.
comprehend.
Next question, sir.
So would it be fair to say that in the video it shows you being knocked to the ground?
No. He never said that.
I was not knocked to the ground. I staggered back.
Would it be fair to say that the video does not show you being knocked to the ground at any point?
So I'll object to relevance because the witness never testified that she was knocked to the ground. So this is not a question aimed at her credibility.
She just said she got knocked to the ground.
Nope, she never said that.
She said she got up. I'm sorry. She said she got up, which
Yeah.
would constitute being, if
Well,
you're not
I
knocked to
think
the
we're
ground
having a
or
little
down,
War
you can't
words
get up.
here, Mr. Brooks.
I'm sorry.
It's okay. No, she was clear. I think she clarified what it meant by getting up, and it might mean something different to you than it does to her.
Yeah.
But we need to keep going.
So what, can I ask what
Every other thing that he does all the time is misrepresent what they say. She was like, she just said that, and we literally just heard her said another thing.
What is
She
getting
didn't
up?
say
What
that.
does getting up mean to you?
Stagger back.
So it would be
Yeah,
it would
just
be fair
be
to
like,
ask you
like,
then.
oh, and then you got up. You're like, oh, I
Does the
got pushed.
video
and
show
then
you
got up.
staggering back?
It does.
Does it show you being, as you called it, smacked?
It does.
Can we show her the video again?
Go ahead. Play the video.
Yeah, he's just not good at what he does. They're fighting. Then he tells her stuff and then he leaves.
In the portion of the video you just saw, would it be fair to say, on your part, your interpretation, that you were in fact smacked and staggered back?
Yes.
Yes.
Next question.
Were you, are you sure you weren't
Are you sure? She just said yes.
over exaggerating that?
No.
It looked like a push.
Again,
Sustained.
you don't need to say that.
Would you say again what happened
Again.
directly after that?
Ask and answer.
Directly after the smack,
Directly after what you say is a smack.
staggered back.
No,
Yeah.
directly after the whole.
He's not convincing the judge or
Listen.
anyone. He's convincing the jury, and he
came
does
back-
a horrible
came
job
back
doing that. No one's gonna believe that. Even if he were, even if he didn't do it, just his. Let's just say that he didn't do it. That they're slandering him and everything.
Shows it sometime,
Um,
somewhere.
He will be so.
So would it
The
be
jury
fair
will
that
still
you're
find him
saying
guilty just
your
because he's a bad
interpretation of
person.
What you just saw would constitute a brawl, as you say, or brawling it out, as you say.
For her, yes.
Hold on, Mr. Brooks. I've given you a lot of leeway on this topic. What's the relevance?
Yeah,
of
where
all
are we
of this
going?
At this point, I think you made your point
I
about
thought
what
that-
happened and what didn't, and what's in the video and what's not, and the jury can also
Move on, get on with it. Yeah, get
I'm
on
sorry, I
with
thought the
it.
state
Where are we
was
going?
Supposed to object to that. If they saw an objection, I'm a little confused about that.
I need the questioning to kind of circle back to what's relevant for the trial.
Well, I thought it was relevant because of what the video is actually depicting.
And
And
that
so
video is
what?
going to speak for itself.
Yeah.
It's been an exhibit.
Yes, it
And
does.
so you've asked a lot of questions about it. So let's move on.
Yeah, move on.
Under 906.11, that's my authority. I'm telling you to move forward.
Yeah, Erica,
Next
into the
line.
Did you hear
descriptions mean there's some
anything
form of conflict.
after the,
Yeah.
as you say, brawling out? Did you hear anything coming from the vehicle? Was anything said to you directly coming from the vehicle at that point?
Not at that point. You're not on the
After
vehicle.
you leave? Oh wait, Brooks leaves? Or when
I was
Brooks gets
clearing
in?
what I just asked after the brawling it
He
out.
always thinks that he's
Directed at her,
clear,
and
but
then you
no
said
one
anything from
understands
the
what he
vehicle.
says.
So that's a compound question, so you need to be specific.
Did you hear anything after the brawling it out, as you say? Did you hear anything directed towards you?
Directed towards me? No.
Uh-huh.
Did you hear anything directed specifically towards Erica?
Not till he left. No, not till Brooks left.
Would you say that again?
Not till Brooks left.
So, did you or did you not hear anything directed towards Erica after the brawling it out, as you said?
Okay, no.
So, can we pull that statement up again?
Go ahead. The state would do that once again.
I'm reading directly from the statement where it says,
Mr. Brooks, it may or may not be a statement, so you need to be accurate.
Yeah, it's
I
a
know you're
summary.
referring to
the summary,
statement.
the summary of the statement.
Yeah, different.
I'm reading directly from the summary of the statement
Mm-hmm.
where it says, Runkle stated that after a short dispute between her, Kirby, and Brooks,
Yeah. Brooks'
she
quotation.
saw Brooks get back into the red SUV and heard him saying something to the effect of F you effing bees, you're dead, as he was leaving.
So I'll object on two grounds. One, asked and answered, and two, this could confuse the witness because it's not a direct, it's not, she used the F and B.
Zach is like, this is
Sustained.
BS.
There was something on the back end of that I didn't get to.
I'm not sure what you mean by that, sir, but
It was-
you've already asked that question before, so the objection is sustained.
I actually don't recall asking a question directly to that part of the summary.
I do. You read through that previously.
Do you remember what the question was?
No.
So that I don't re-ask the same question.
Just move on. You can't.
Mr. Brooks, move on.
Yeah. Why are you frustrated that you don't remember?
Did you ever hear something to the effect of F you effing bees, you're dead?
I did.
At what point did you hear that?
While Brooks was leaving?
So that would it be fair to say that you heard that after the brawling
Yes.
it out?
You shook your head. Can you say
Yes.
Thank you.
That's a little confusing. So
Mr. Brooks, that's not a question. You're attempting
I'm
to
about
testify.
to ask a question.
You
If I
can't
can
do
get
that.
to it,
Ask your question.
Ask your question.
But you also can't mischaracterize the testimony or the evidence up to this point.
what do you mean?
In your questions, you can't mischaracterize prior testimony or evidence. You have to be accurate. So
I'm trying to be, but it's
what's your next question, sir?
kind of hard.
Well, it is hard. You're representing yourself, but you need to deal with that.
Just a quick second.
It's not the Kurt's fault.
Right, unless you have a different topic.
It is.
Anything related to this, what's in the summary, the questions regarding what she heard or didn't hear around this time, we've gone through that. You've gone through it. Under 906.11, you need to move on and ask a new line of questions.
I was trying to, if I can get to it.
Go ahead.
He's so frustrated because of himself.
This part of the summary looking at now says Runkle stated that she did see pictures of Brooks following the Christmas parade incident via social media, and Runkle confirmed that was Brooks was the, well, I don't know, it looks kind of, I don't know if that's a mark on my screen that's
What?
going through, okay. I couldn't read it.
I'll object. I don't think there's a question there.
Nope.
I didn't get to it yet.
Well, ask it.
I'll object to the ongoing commentary with lack of any questioning.
Yeah.
And I'll sustain that objection.
Get him.
Before November the 21st of 2021, do you know of any time before that Erica mentioned to you anything about the relationship that she had with Brooks outside of what you learned that day?
Yes.
Did Erica ever confide any information
What does that have to do with that?
to you before that day?
Why?
She did.
What was the nature of the information?
Nope.
It's not allowed to be brought up.
Yep.
I think she's referring to a pretrial ruling that she's aware of.
Yep.
So, you want to rethink asking that question?
He's like, what?
Otherwise, I'm going to allow her to answer it.
What pretrial?
I'm not going to state.
No,
that
I'm not.
right now.
Are we both privy to the same pretrial procedure?
This guy. And here comes Zach. He shouldn't have done that. He should have let him hang himself. I don't know why he did that.
Do you want her to answer that question, or do you want to move on?
I want to move on.
All right, strike that question from the record. The jury will disregard the question that was asked.
This guy. This freaking guy. I still don't know why he did it.
Drinking a half pint of vodka that day. Was that the only thing you had to drink that day?
Yes.
Would it be fair to say that you were tipsy?
Yes.
Would it be fair to say that you may even have been intoxicated?
No.
Tipsy and intoxicated are different.
Would that have impaired your
I told you, Miss Mandy, I was gonna do a marathon.
No.
It's the least that I can do for
to say that you were
both Deacon and Angst.
clear and sober mind during that whole incident after drinking a half pint
That
of
have been with me, and they supported the situation that I have right now. So I'll do it as long as I have to.
Why you may have left
because I really appreciate the help, and I really need that help.
Anything that happened during that specific
And
incident.
there's only one way that I can torture myself right now,
Possibly
and
left something
that's
out.
watching this guy being this guy. But I think we've been going at it for like 5 hours, something like that.
No.
They are.
Do you know the plaintiff?
Here we go.
For previous reasons.
Sustained.
No. That's great.
Objection.
Sustained.
I get it, and I appreciate it a ton. You don't have no idea how much.
Have you ever had any interaction with the plaintiff?
Objection.
Sustained.
No further questions, Your Honor.
Thank you. Any redirect?
There we go.
Very briefly, Your
Oh.
Honor. Ms. Runkle, you met with Detective David Van Els to provide a statement on November 22nd of 2021. Do you remember that?
Yes.
That's accurate?
Yes.
Okay. You remember telling Detective Van Els, when he was asking you about this incident, that when you arrived, you heard Darrell Brooks telling Erica Patterson that he was going to, quote, smash her face in and that he was going to kill her, end quote.
Yes.
Yes.
Okay. Do you remember telling Detective Van Els that as you saw Brooks get back into the red SUV, you heard him say something to the effect of, quote, fuck you, fucking bitches, you're dead, end
Zach.
quote.
I do.
There's children here.
During your cross-examination, you repeatedly referred to a person as Brooks. The person depicted in the video, Exhibit 3, the person that you chested up to, is that person in the courtroom?
He is.
Can you point him out for us and just very clearly tell us where he's sitting, what he's wearing?
You want me to point?
Yes, please.
Yeah.
All right, he's right there and he's wearing orange.
I'd ask the record reflect that the witness has identified the defendant.
It will.
And I have no further questions. Thank you.
Thank you. Thank you, ma'am. You may step down. You are to decide the case solely on the evidence offered and received.
All right, are we done with day one?
With that, you are excused. I will provide information to Pete and Mike shortly as to what time.
Yes, we're done with
we
day
will
one.
start back
We
up
did
tomorrow.
it, people.
Thank
We
you.
survived the
For the
first day of the trial. And here comes the mask again for some reason.
I have the state appearing by District Attorney Sue Opper, Deputy District Attorney Leslie Basie.
All right, day two.
Assistant
Here we go.
District
Day
Attorney
two
Zach Chow,
is.
and
I
have
mean,
the
how many parts is
defendant,
there for day two?
Darrell Brooks,
Two
appearing
parts.
in person.
All right, let's go.
So
Oh,
my understanding
I got
is
a
that
notification.
what Mr. Brooks described
Thank you, Miss
happening at the
Mine.
initial appearance,
Thank you
there
for
was
the
a woman
$3.
that one of the deputies
I
spoke
appreciate the
with
message.
and warned her.
And thank you so much
My
for.
understanding that woman may have
for
been
sticking
in
with
the
me,
gallery
because
on
I'm-
Monday and was warned
I'm this
about
guy. I'm
behavior
just a guy.
then. I have issued an order. She is not allowed back
But
in
hopefully
these
I
proceedings
have
because
enough
of that. I believe we know her
stuff to tell to
identity,
make
and I can
to
tell
grow
you
the
with
channel.
certainty it is not our
Thank you.
juror. So I don't think it's necessary to bring that juror out, given that record. But I will certainly do that if the state.
But I say you need to go play a game now, do something for a breather.
important for their
I mean,
understanding.
we can take a break. Okay, we can take like a food break. I didn't want to stop the stream, but we made it through the pre-trial, the final pre-trial, and the first day. 2, 3, 4, 4.5 hours. But we can take like a lunch break, like a 5-minute lunch break, so Darrell Brooks can cool himself down. And then we can come back in the afternoon to keep at it. Yeah, let's take a quick food break. I'm gonna see what I can go make, and we'll come back. I don't know what time is it's 4 p.m. Let's say we come back at 7. Yeah, in 3 hours. 3-hour break, and then we'll finish at least the second day. I'll be down with that. So if you guys are up for it, if you guys know someone that will be up for it to have fun with us, let them know. I'm gonna schedule the stream for later today. So right, I forgot that you guys live in the East Coast. So maybe that's not that a good idea. I don't know. Maybe we'll leave day 2 for next week. Next week, I'll be here next week. Yeah, I'll be here next week in the morning. So yeah. Thank you guys for thank you guys for being here. Thank you guys for the support that you guys gave, and I'll see you guys later. And I'll probably gonna come back later, so I cannot stay away from this stuff. So we'll come back later this afternoon. I promise. Maybe in like an hour, maybe 2. Just see how long it takes me for make something to eat. Yeah, she's right here. She wants attention too. Maybe I'll give her a bat right now. But yeah, thank you guys so much for watching. I'll see you guys on the next episode for more reaction to Darrell Brooks. In the weekend, Monday through Thursday, I'm still doing the Isaac videos, so take a look at those if you can. Yeah. You guys have a good one.